script. As chair of the House Education Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with House Rule 67 and the Governor's Emergency Order Number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing of bills referred to the Education Committee. Executive session on pending legislation may be held. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All the necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting complies with House rules and RSA 91-A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@ledge.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. I want to introduce the staff that are on the meeting assisting us today. Jennifer Ford, committee researcher. Please note that all votes that are taken during this meeting shall be done by roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there is anyone in the room with you during this meeting, which is required under the right to know law. Madam Clerk, can you please call the roll?
Yes. Representative Cordelli,
Here in the committee room.
Representative Bohm,
Here in the committee room.
Representative Allard,
Here in the committee room.
Representative Lakis,
Here in the committee room.
Representative Moffett,
Here in the committee room.
Representative Hobson,
Here in the committee room.
Representative Andrus,
Home alone in Salisbury.
Representative Ford,
My home office alone in Chester.
Representative Leon,
Here in the committee room.
Representative Sodi,
Here in the committee room.
Representative Myler,
Here in Kentucky in my office alone, and Representative Lay will be late this morning, Madam Clerk.
thank you. Representative Luno, I'll go back. Representative Shaw, I'm here in Manchester. My husband is in and out of the room, and I'm wearing a mask, not out of extra caution, but out of the fact I visited the dentist yesterday. Representative Cornell,
Here in Manchester alone.
Representative Tanner,
Here in Georges Mills, part of Sunapee. I'm here with my rescue dog Raven. Thank you.
Representative Ellison,
Present, I'm home alone in Concord, New Hampshire.
Representative Mullen,
Here in the basement in Bedford.
Representative Woodcock,
Here in Snoqualmie, New Hampshire, with fresh 6 inches of snow, great for skiing, and my dog and my wife.
thank you. Representative Luno,
Reporting from Hopkinton.
thank you. And Representative Lay, I will check in on him later. All present, sir.
Thank you very much. And Representative Ladd is here in the committee room.
Oh, sorry. Yeah, I knew that.
Hope that tooth feels better.
I hope so.
Okay, folks, so we have 9 bills on today. The first bill is scheduled for this moment, so we're going to go right into HB 500. This is relative to reducing school food waste and addressing child hunger. Is Representative Lohman in the queue?
Yes, I just promoted him to panelist. Welcome to
I am. Can you hear me okay?
Yes, we can.
Excellent. Good morning, Mr. Chairman and members of the House Education Committee. I'm Representative Tom Lockman of Hampton. I'm pleased to be with you this morning to introduce HB 500 relative to reducing school food waste and addressing child hunger. This bill mirrors HB 1512 from last year, which underwent an interim study by this committee and was recommended unanimously for future legislation. This concept came about from a school district in Indiana that chose to partner with a nonprofit to take their prepared but never served extra food and package it into frozen to-go meals. These meals would then be distributed to students on Fridays to take home with them. This went a long way to solving two problems. It reduced school food waste while also addressing child hunger over the weekends. Child hunger during the weekends is something nonprofits like End 68 Hours of Hunger have done an excellent job of raising awareness of and addressing. What's particularly great about the food that would be involved in this bill is that it's nutritious. By packaging school food into frozen to-go meals, we're not limited to providing children with non-perishable food or drier food. Instead, it's freshly cooked, well-balanced. And while this bill has enjoyed bipartisan support, there were areas of interest expressed in last year's version and in leading up to today's introduction that I thought worthy of greater clarity through an amendment. Each of you should have Amendment 047H, which I had prepared for your consideration. It provides greater clarity on food safety and liability while also providing greater flexibility for program implementation. I believe it addresses the areas of interest that have been expressed. Specifically, the amendment ensures schools can implement such a program with or without a nonprofit partner, makes clear that portions and not whole meals may be distributed as well, if that were the case, that state food safety regulations and FDA requirements and guidelines do apply. Also that the Bill Emerson Good Samaritan Food Donation Act shall apply to any participating school, which provides some liability protections. And finally, it provides flexibility on which students may receive these meals. I believe in this concept and the amazing potential it has to do good and to bring comfort and vital nutrition to children who experience food insecurity. I'd greatly appreciate your support of this important bill and amendment. And I'd like to conclude by saying thank you for your time this morning, and I'm happy to take any questions that you may have.
Thank you very much, Representative Loman. I do have one question for you. Could you explain a little bit more for us the Bill Emerson Good Samaritan Food Donation Act and how that impacts or provides liability protections?
Sure. If you bear with me for just a moment, I'm going to open a note on that. It was essentially designed for situations not unlike this, where we do have excess of food in this country in various sources. And, you know, there was an understood need to protect organizations that would want to donate that food. So hold on as I open up this note here. This is from 1996, signed into law by President Clinton. Encouraged the donation of food and grocery products to nonprofit organizations for distribution to needy individuals. Makes it easier to donate. It protects the donors from liability when donating to nonprofit organizations. It protects donors from civil and criminal liability should the product donated in good faith later cause harm to the needy recipient. It standardizes donor liability exposure. It sets liability floor of gross negligence or intentional misconduct for persons who donate grocery products. So there's some structure there and definition. Let's see. Congress recognized that the provision of food close to recommended date of sale is in and of itself not grounds for finding gross negligence. For example, cereal can be donated even if it's marked close to the code date for a retail sale. And so there were all these opportunities to make it easier and more streamlined for, you know, sources of food to be able to donate to needy individuals or programs and provide some protections. And I think that would apply here.
Thank you very much for your explanation. Are there questions of the representative? Yep. Representative Bowman.
Thank you, Mr. Chairman. Thank you for taking the question. thing that, I believe this came up last year, was the thing on privacy. How do we protect the students' privacy for taking these meals? Because this looks like another way for bullying. So do you have any comments on that?
Yeah, that's a really good question. And, you know, in my experience in talking with different stakeholder groups and schools, is there are programs not unlike this where they try to get resources to needy individuals, and they all seem to have creative and innovative and thoughtful ways in which they go about that. And so I thought it best to leave that to the schools themselves or the individual programs to design the ways in which they can most effectively do that, rather than stipulate here how it needs to happen. Of course, I think the privacy of the individuals should be thought of and considered, and it should be as discreet as possible. I just, you know, short of just simply saying that, which doesn't say much, I thought it would be, you know, leave it flexible to the schools to decide how best to go about it.
Thank you very much. Representative Shaw.
Yes, what is the amendment number, Representative Laughlin?
It is 2021-047H. I emailed it to you all last evening, and also sent it to Jennifer Four to facilitate distribution to everybody.
Okay, thank you.
I'd like to make a correction on that, Representative Shaw. It's 0474H. I think Representative Longman left the last four out.
Ah, okay. Well, thank you. I appreciate that.
Thank you.
Just understanding too that we can discuss this amended version of section 1. However, we won't be able to take any action until it's presented by a committee member later on in the exec session.
I understand.
Are there further questions? Yes, Representative Mullen.
Thank you, Mr. Chair, and thank you, Representative, for taking the question. I noticed that there is a difference between the original bill and the amended bill in that the language about free and reduced lunch has actually been removed. Could you explain your thinking behind that, and whether or not that satisfies what Representative Boehm was inquiring about?
Sure. You know, this came about in one of the conversations I'd had regarding ways to make this bill more suitable. There was a discussion around what's happened in the past year. Because of COVID, for instance, the participants in free and reduced lunch has expanded greatly to the point where the data on it is fairly muddy. And I wondered if it wasn't best to make it more flexible, since, you know, so any parent who wants to participate in this program, wants their children to participate in this program, could. And so, you know, I suppose I thought it best to be more flexible rather than less flexible, in that needy children would still have the path to pursue participation in this program regardless. And maybe some additional children on the fringe, maybe not quite eligible, but close, could as well. And I thought that was a positive thing.
Thank you. Further questions? Representative Lakis, is your hand up?
No, I was pointing to Glenn, whose hand is up.
Oh, Representative Cordelia, is your hand up? Yes.
My hand's up, yes.
Okay, thank you.
Thank you, Mr. Chairman. Thank you, Representative, for representing this bill. It seems to me that the bill last term had issues related to the freezing of food. And when and who would be doing that? Would it be done by school staff in the cafeteria, or would the food be provided to the nonprofit, who would then take it to their facility and freeze it? I think that was an issue with the last bill, if I remember correctly, and I was just wondering if you had any thoughts along those lines.
Yeah, you know, and it's a great question. Thank you, Representative Cordelli. I recall the question, and in my sort of studies of similar programs, an example, the Indiana program, they did work with a nonprofit who would collect the food, package it, freeze it, and then bring all the packaged frozen meals back to the school to distribute on Fridays. And there are many ways to go about it. This bill allows for multiple configurations where someone could be responsible for the freezing and packaging, whether it's the schools themselves or a nonprofit partner, on premises, off premises, so long as they're abiding by the food safety regulations. And I think that's the best approach because many of these programs are successful, but they're finding a lot of different ways to go about doing it. And I thought that's best because these are essentially pilot programs in New Hampshire, having this kind of model, but also the flexibility to pursue multiple configurations may find an even more efficient or effective way to do it. And I thought the bill should allow for that.
Thank you. Representative Cornell?
Yep, the bill says a school may partner with a nonprofit. So this is enabling legislation, right? It's not telling school districts or schools that they have to do it.
Thank you for the question, Representative Cornell, and absolutely. This is enabling. I see it as a way of, certainly some of this is codifying some protections and all of that, but it's illuminating organizations or schools that this is a concept that can be implemented, because one of the questions that came up last year was, well, can we do this now? And you'd be surprised how nobody quite had the answer to that. And I think this does answer that. Not only can we do it, but we're providing a little bit of structure and guidance around it so that it can be done well and properly and safely. And so correct, it is enabling legislation.
Thank you. Further questions, Representative Lohman? Not seeing hands. Thank you very much, Representative.
Thank you, Mr. Chairman. Much appreciated.
Okay, next is Representative Murray. Welcome to education.
Thank you for having me. Thank you, Mr. Chair, honorable colleagues. For the record, my name is Megan Murray and I represent the town of Amherst, District 22. So briefly, I understand your schedule is busy today, so I'll be as brief as possible. Currently in New Hampshire, 1 in 8 are experiencing food insecurity. And unfortunately, that number has grown due to the COVID pandemic. Now more than ever, families who experience household food insecurity are navigating food pantries and SNAP services, but this issue existed well before. HB 500 and its proposed amendment offers communities another avenue for efficient supplemental food distribution, especially during a time of hunger and insecurity. As a former educator myself, I am well aware of the complex nature of food insecurity relating to self-esteem, self-efficacy, stigma, mental and physical health. As a child, I was one of those who for a time received free and reduced lunch. Not unlike many who experienced food insecurity, there were times where spaghetti sandwiches got my mom through stretching food to meet our needs. It was literally 2 slices of bread buttered and spaghetti between the slices. Food insecurity is one of the daily barriers children experience in their academic days, and it absolutely affects their learning day. Food insecurity for children is related to ACEs. As the committee knows, adverse childhood experiences have profound and lasting impacts, and left unaddressed in children can be harmful. Data shows that children in homes where ACEs are high have higher instances of household food insecurity. Hunger affects a child's ability to focus, have energy, and learn throughout the day. And no child should have increased anxieties around attaining meals or sustenance. States across the nation have enacted varying degrees of legislation like this, and the USDA recognizes food recovery for school programs in the first paragraph of their website and throughout it. Such permissible language as in HB 500 and the amendment would allow school communities, if they choose to participate in getting food to those in need in their learning communities. Addressing food hunger, while bolstering partnerships with nonprofits would increase the ability to feed those in need and keep good food from being tossed into costly and heavy waste streams. And if the food can't be recaptured, it should be composted and not landfilled. With HB 500 and the amendment, simply this permissible language would allow schools in partnership with a third-party nonprofit or on their own to safely package, freeze, and distribute the unserved food to those in need. I wholeheartedly testify in support of getting food safely to those who need it most and urge the committee to adopt the amendment when the time is right and pass HB 500 with it. I humbly thank you for your time and consideration with this important legislation, and it would change the lives of so many.
Thank you very much, Representative Marie. Other Representative Murray. Representative Cordele.
Thank you. Thank you, Representative Murray. We received email from the DOE Office of Food and Nutrition Programs. And then they mentioned the Health and Human Services Bureau of Food Protection. Do you know if anyone has talked with that bureau about this program?
Yeah, so there have been stakeholder conversations with both of those, and I do believe that with respect to the schools themselves and the nonprofit organizations, they are fully aware of what are called HACCP, food safety protocols, which is the hazardous analysis and critical control points. And so they are, when considering packaging those foods, they are already in compliance with how those procedures work within their school communities and within the nonprofit organizations.
Thank you. Further questions of the representative? Not seeing any hands. Thank you very much, Representative Murray.
You're welcome. Thank you for your time.
You're welcome.
Next, we have Mike Apfelberg, who's been promoted.
Can you hear us, Mr. Alfred?
Yes, I can hear you. I just want to make sure, am I unmuted that you can hear me as well?
Yes, we can.
Well, good morning, Mr. Chair and members of the committee. My name is Mike Apfelberg, and I come to you today as president of the United Way of Greater Nashua in support of HB 500. Prior to the pandemic, we partnered with the Nashua School District to establish a program of what's called share carts in the schools, whereby students could systematically get uneaten, unopened foods to their fellow students. This was a first in the state initiative. This came about as a partnership that included the schools, the United Way, as well as our local Department of Public Health. Since the pandemic began and the shutdown last March, our United Way partnered with the Nashua School District to distribute over 90,000 free breakfasts and lunches in our community. We also partnered with the school district and other organizational entities to stand up over a dozen weekly fixed and mobile food pop-up pantries, getting critically needed food into the hands and bellies of thousands of local residents. During this time, we have identified that there is both a great need to support children and families with food security, as well as a great need to work on the distribution systems in our community. There's often a surplus of food, along with a great need, but no way to get the food from the source to the recipient. School systems are phenomenal for distributing foods to kids in their physical school locations, but often not well positioned to get food out into the community. On the other hand, local nonprofits have the ability to get food into the community, but often have a need to access the additional resources of food itself. This bill helps to bridge the gap, and for this reason, we are strongly supportive of HB 500, and we look forward to continued support of our community during these trying times. Thank you, and if you have any questions, I will be here on the call.
Thank you very much, Mike. Are there questions from the committee for the United Way of Greater Nashua? Thank you very much, Mike.
Next, we have Sophia Biondolillo. She's been promoted.
Hi, can you hear me?
Yes, we can, Sophie.
All right. Thank you, Mr. Chair and members of the committee for taking my testimony today. My name is Sophia Biondolillo. I'm 14. I live in Manchester, and I'm speaking today on behalf of the New Hampshire High School Democrats in support of HB 500. I believe, as I'm sure each of you does, that no child in New Hampshire should ever go hungry. Yet, according to Feeding America, 1 in 8 New Hampshire children struggle with hunger, and the COVID-19 pandemic has only exacerbated this crisis. There are many students in our state who have nobody there to greet them when they get back home. They walk home by themselves and have their own key to the door. By allowing food that would otherwise go to waste to be sent home with children in need, this bill would be a step towards ensuring that no child in New Hampshire goes to bed hungry. In the United States, about 30 to 40% of the food supply is wasted, and according to the 2019 World Wildlife Fund report, schools make up about 530,000 tons of this waste. This is not only a waste of resources, it is also harmful to our planet. According to the Environmental Protection Agency, food is the single largest category of material placed in municipal landfills in the United States. In landfills, food produces methane, which is a harmful greenhouse gas. Allowing schools to repackage this food would help would help keep food out of landfills and put it in the hands of our students. This bill would help tackle climate change and hunger at once, and therefore I ask the members of the committee to support House Bill 500. Thank you for your time.
Thanks very much. Are there any questions for our young high school students? Sophia?
I'm sorry, I think you broke up. Could you repeat that?
I said, are there any questions that the committee would like to ask of you, Sophia? And I'm looking around the room here, and there are no further questions. Thank you very much for your input today. She's going?
She muted herself. She's all set.
Oh, she knew.
Yep.
Okay.
Thank you.
Okay,
No one else.
I have nobody else lined up to testify. We have, that's been given us here on the remote testifying sheet, supporting it 138, opposed 0, neutral 0, total number to testify 4. Okay, we are a few moments early here. We have about 5 minutes before the next bill to come up. Okay, I think what we're going to do is we're going to go ahead and exec this bill. I'm looking for a motion from Representative Likas.
I guess we have to do the amendment first.
Yep.
So I would like to move OTP on amendment 0474H.
Is there a second? Representative Bohm seconds the motion. We have a motion of to pass on 0474H. That's an amendment to the bill that we've been discussing, Bill 500. So we're voting on the amendment. Is there further discussion on the amendment? Looking around, I'm not seeing anybody with the maker like to say anything of the motion. Nope. Okay, Madam Clerk, you're out there somewhere. Gotcha.
Okay, this is on the, excuse me, this is on the amendment. Representative Cordelli,
Yes.
Representative Bohm,
Yes.
Representative Allard,
Yes.
Representative Likas,
Yes.
Representative Moffett,
Yes.
Representative Hobson,
Yes.
Representative Andrus,
yes,
Representative Ford,
Yes.
Representative Leon,
Yes.
Representative Sodi,
Yes.
Representative Myler,
Yes.
Representative Luno,
Yes.
Representative Shaw, yes, Representative Cornell,
Yes.
Representative Tanner,
Yes.
Representative Ellison,
Yes.
Representative Mullen,
Yes.
Representative Lay, you here yet?
Yes, I am. I am present. I am in Bow, and I vote yes.
Thank you.
You're welcome.
Representative Woodcock,
yes,
20-0 on the amendment.
And Representative Ladd votes yes also.
Oh, I'm sorry, Representative Ladd.
How many years have we done?
Okay, do we have another motion, please, Representative Likas?
Yes, I would like to move OTP on House Bill 500 with amendment 0474H.
Second.
And we have a second from Representative Bohm. So the motion is to pass on the bill HB 500 as amended with 0474H. Further discussion? Not seeing any hands. Would you please go ahead and call the roll, Madam Clerk?
I will. Hold on. Representative, this is on House Bill 500, ought to pass as amended. Representative Cordelli,
Yes.
Representative Bohm,
Yes.
Representative Allard,
Yes.
Representative Likas,
Yes.
Representative Moffett,
Yes.
Representative Hobson,
Yes.
Representative Andrus,
yes,
Representative Ford,
Yes.
Representative Leon,
Yes.
Representative Sodi,
Yes.
Representative Myler,
Yes.
Representative Luno,
Yes.
Representative Shaw, yes. Representative Cornell,
Yes.
Representative Tanner,
Yes.
Representative Ellison,
Yes.
Representative Mullen,
Yes.
Representative Lay,
Yes.
Representative Woodcock,
Yes.
Representative Ladd,
Yes.
20-0. Consent calendar,
Yes.
I hear a yes out there. Thank you very much.
Yes, yes.
Thank you very much, Representative Myler. Representative Lohman, I'd like to thank you very much for working with us on this and coming back with an amendment that seems very, very well put together. And I appreciate your calling me earlier this fall and discussing this. Congratulations. Okay, we're going to go into our next hearing. HB 140, relative to private rights of action regarding pupil safety. Is that yours? Representative Cordelli, you're recognized.
Thank you, Mr. Chairman. For the record, Representative Glenn Cordelli, representing Tuckenboro, Moultonboro, and Sandwich in the beautiful Lakes region. Bullying is a serious.
give me a break here. Oops.
Nationally and in New Hampshire. I sent out an information packet, I believe, on Sunday that I hope you all received. And in it, there is a report from the Department of Education for the 2018-19 school year with over 1,600 reported cases of bullying. Be aware that there are also estimates that 65% of bullying incidents go unreported. A CDC report stated that even students who witness bullying incidents are impacted and have a greater feeling of helplessness. A Yale review of bullying studies found 5 studies that reported bullying victims were 2 to 9 times more likely to report suicidal thoughts than other children. There have been multiple attempts to deal with bullying both by the legislature and by school districts. But are 1,600 reported incidents acceptable? I think you might hear from some people who think not. The current statute, RSA 193F:9, states that nothing in the chapter on public safety shall create a private right of action. In 2015, there was a case, Gautier versus Manchester School District, that went to the New Hampshire Supreme Court. And that case involved an altercation on a school bus with one student being punched in the face. After a week of threatening messages to the student, she was attacked in the cafeteria and had to be transported to the emergency room. The parents had never been informed about the school bus incident. They only found out about it in the emergency room. The Supreme Court ruled in favor of the school district, citing this statute and saying that there was no private right of action per state law. HB 140 is very simple. It states that if there's gross negligence or willful misconduct, there shall be a private right of action. We talk much about accountability in discussing other legislation. How about talking about accountability for gross misconduct or willful negligence in bullying cases? Your handout includes a number of news reports about publicized cases in New Hampshire. And remember that the statistics, that there are thousands of reported cases that have not gotten this publicity. Each one of these cases represents multiple students who have been impacted. For those of you who do not have it in front of you, RSA F:193F is the chapter on public safety and violence prevention. And let me read you from the purpose and intent of that chapter. From that to the purpose and intent. All pupils have the right to attend public schools, including public charter schools, that are safe, secure, and peaceful environments. One of the legislature's highest priorities is to protect our children from physical, emotional, psychological violence by addressing the harm caused by bullying and cyberbullying in public schools. It goes on, the intent of the legislature to protect our children from physical, emotional, and psychological violence by addressing bullying and cyberbullying of any kind in our public schools for all of the historical reasons set forth in this section, and to prevent the creation of a hostile education environment. We, the general court, needs to make sure that bullying issues are being taken seriously and that parents of bullied children are being listened to. It is our duty. We would all like to think that every district is doing everything possible to address and respond to reported bullying cases. That is their duty. But when districts do not follow their own policies or the law, families deserve a remedy. Passing HB 140 will send a message throughout New Hampshire that the legislature means business and we are standing with bullied students and their families. We owe it to them. Thank you, Mr. Chairman.
Thank you very much, Representative Cordelli. Are there questions for Representative? Yes, Representative Myler.
Thank you, Mr. Chair, and thank you, Representative Cordelli, for taking my question. I've got two. Please define for the committee the term right of private action. And secondly, define for the committee what is gross and willful misconduct. Thank you very much.
I am not a lawyer, but there is a dictionary definition that I found of private right of action that states a right to begin and prosecute an action in the courts. In terms of gross misconduct definition, I believe that the courts have declined in prior cases to come up with such a definition, but the term gross negligence and willful misconduct are in our statute, throughout our statutes. I can cite 65170, 21P12C, 186C14, 173B12, 200N:6, 329B:21, 310A:22, and 50812-A were just the results of a simple search I did. And there might be others as well that use those same terms.
Thank you very much, Representative Cordelli. Further questions for Representative Cordelli? Yes, Representative Woodcock.
Thank you for waiting, Mr. Chair. Trying to move that arrow all the way over to the other side of the screen. Thank you for letting me speak, and Representative Cordelli, thank you for taking the question. So in lay terms, you didn't, I was listening attentively after Representative Myler asked you the definition of willful misconduct, and you gave all the citations, but you didn't give me a definition. So I was curious, the definition. And specifically, in very lay terms, can you walk me through a scenario, what this might look like with a youngster or a parent? I'm concerned about who they action against the school district. Is it the school teacher or the school principal, the superintendent, the district itself? So those couple of things, just if you would, Representative Cordelli, explain willful misconduct, and then just tell me how it might show itself out in a little scenario here, please, so I can understand it in very lay terms. Thank you.
I think there are a couple of questions there. First, as I explained, our state statutes do not include a definition for gross misconduct, but use the term throughout our statutes. I think the courts could make that determination. In terms of walking through a scenario, this Act applies to school districts. There are protections further on in our statutes for school individuals, school staff. So this would apply to school districts in terms of the right of action. Further
questions? Yes, Representative
Moffett, yes. Thank you, Mr. Chair. Thank you, Representative Cordelli, for taking my question with a possible follow-up. I just have a question about the term aggrieved. I understand the term injured, that legally, but aggrieved, I'm just wondering, if somebody's feelings are hurt, is that what aggrieved means? Or can you just speak to aggrieved a little bit?
I believe that it's someone who feels injured. I think that there are other attorneys who might be better to weigh in on that than I in terms of a legal definition of aggrieved. But there is a higher degree with this action, with this act, and that it requires gross negligence or willful misconduct. A simple incident of calling someone a name, I don't think would meet the qualifications of this statute.
But thank you.
Further questions, Representative Tanner. Representative Tanner.
Thank you. In reading a little bit about this, it seems that there's a countersuit often for freedom of speech when there's been suits for cyberbullying. I'm just wondering if there's limited liability for schools if they are trying to deal with bullying and the issue of the First Amendment free speech comes up.
I know of none, but I'm not clear on how freedom of speech applies in this instance.
May I follow up on that?
Yes,
So I think what happens is that in the cyberbullying, they're using, public internet, and they're making all kinds of issues about a person. Isn't that an issue of free speech that is somewhat protected?
I think that in statute already, and I believe in this chapter, there are definitions for cyberbullying that might clarify that for you, but I think that's documented in statute currently.
Further questions? Representative Woodcock, did you have a follow-up?
I did, Representative Ladd, and I missed it. Thank you very much for coming back. Representative Cordelli, I'm back to the same question. Can you just give me a small scenario? Walk me through a layman scenario. A student in a school, the parent does this, what happens? I'm trying to figure out how this process works. Not citation, but rather a scenario how it might work.
There is a process outlined in our statutes already for schools dealing with reported bullying incidents. Part of that figured into the Manchester School District case that I mentioned earlier, and other cases as well. So there is a process already in our statutes that defines on how a school is to react when there is a reported case of bullying and the investigation that should be done following that report.
Final follow-up, Mr. Chair. I understand that, Representative Cordelli. I'm just trying to find out how we go from that step through your bill. That's all. How we get to the willful misconduct. I'm just trying to find. That's all.
I would think that after the investigation, if the parents are not satisfied that the school is complying with their own rules or policies, then they would have the private right of action.
Thank you. Thank you, Mr. Chairman.
Representative Likas, did you have something? No, well, thank you very much. Are there further questions of Representative Cordelli? Not seeing any. Thank you very much.
Next we have Shannon Bouchard. She's been promoted. Go ahead, please.
Shannon Bouchard, can you hear us?
She is muted.
Shannon, can you unmute your machine, please?
Oh, sorry about that.
There you
Hi,
go.
everyone. I am going to be reading from my story a little bit with my daughter. My
Shannon,
daughter,
if you have something you want to read, could you please submit that to the clerk where we put that into the minutes? However, to read something straight out where it's gonna, I see you're requesting 10 minutes, that's much longer than we provide for testimony.
okay, it probably won't take 10 minutes, honestly.
Okay, go for it then.
Okay, my daughter was bullied over her entire school career at the district. She has verbal apraxia, sometimes called dyspraxia, which is a motor planning speech disorder. So it was hard for her to, if somebody said something, to come back with something, you know, and be able to get her point across that it was happening. I requested a manifest educational hardship, which is the policy in law that you request it in the district. The superintendent brings it to the district and you're allowed to go before a hearing on your board. And when I did that, I was denied by the superintendent stating that she had a disability, so I couldn't go through the manifest educational hardship. So I had to then in turn go and find an attorney that could help me just to get in front of the school board. I was able to tell the school board what was happening and prove my case, and they awarded her the manifest educational hardship, which would have meant that she would be allowed to go to a different district. Only there are no districts that will accept her, stating COVID as the reason. So she is remote learning in the district that she has had nothing but hardship in. Wanted to say that my daughter, because of not being able to really get across clearly like what was happening to her because of her disability, she started self-harming and had suicidal thoughts. And I have a lot of things I could go to due process for, but I'm on disability from my own MS, and my husband's the only person that works. And to go and obtain a lawyer would be such a hardship for us that it's impossible. I think that the schools have full-time attorneys at their beck and call, and even most people don't go to due process because they can't afford to go up against the school and their high-powered attorneys. And meanwhile, these kids are suffering in silence because everywhere they turn, there is no help for them. We have kids that she reported the bullying, I reported the bullying, and they handled it as peer mediation. And we know how well that goes. She was then bullied even more for tattling. And so she kept it all inside and didn't report it again. I'm faced now with her being remote because of COVID, but I can't find a district that is within reason that because I'd be responsible for transportation, that either myself or my husband on his way to work would be capable of getting her there. The two districts that would be fine, they both have denied her, stating COVID as the reason, and not saying that as soon as they're back full time that they would accept her. They're pretty much told me that they will contact me if it changes. If not, oh well, she's on her own.
Shannon, are you finished?
Yeah.
Thank you very much. Are there questions for the person presenting right now? Shannon Bouchard. Representative Myler?
You're muted. Rep. Myler.
Need to unmute, Mel.
Thank you. Thank you, Mr. Chairman, and thank you, Ms. Bouchard, for taking my question. As you pursued your issues in advocating for your child, what was the relief that you were looking for that you felt would resolve the issues that your family was facing?
Most of the issues were around the school had her in a learning center, which was segregated. She had to go into a different part of the building, where it was labeled special education. She had to go into that to get her services. And that was the worst part for her because the kids were seeing that she was different.
Yeah.
So they were, calling her the R word every day and laughing and poking fun at her. And I felt like if we could get her into a different school the district we were at told me that she had to have a learning center or she wouldn't qualify for an IEP. And that's not the truth. And I learned that by getting an attorney, which was only limited representative from the Disability Rights Center. And before that, I wouldn't have had any clue. I believed what they said, obviously. And so by changing schools, she would get an inclusive education instead of a push-out education.
So the relief you were looking for was just a change in school. And what year is your child in school?
She is a freshman.
Thank you very much.
Thank you very much, Representative Myler and Shannon. Are there further questions for Shannon Bouchard?
I have a question.
Yes, Representative Hobson.
Hi. Can you hear me okay? Thank you for taking my question. I was just wondering if you could explain how this legislation might have helped you.
I think that there are a lot of issues besides just the change of school, that there were a lot of issues that I could have gone to due process for that the school wasn't implementing, but because of the cost of getting an attorney and having that, I couldn't afford it, honestly.
Thank you very much.
Thank you very much. Are there further questions for Ms. Bouchard? Not seeing any hands. Thank you very much. I'd like to recognize Jerry Zellen.
Thank you, Chairman Ladd, and thank you, committee members, for your public service. My name is Jerry Zellen. I'm a lawyer in Portsmouth. I specialize in representing school districts, primarily in matters involving special education and disability rights. I'm speaking today as a volunteer for the New Hampshire Association of Special Education Administrators, which is our statewide organization of about 170 members that represents, among others, all special education directors in the state of New Hampshire. Bullying is a terrible thing, and school districts should do their best to combat it. However, not all reports of bullying are well-founded. Special education includes some students whose disabilities cause them to misperceive social communications. They sometimes misinterpret innocent remarks as insults that amount to oral or cyberbullying. Now, I filed a letter with the committee that explains why the NHASEA opposes HB 140. In a nutshell, while the bill is well-intentioned, it is poorly crafted. But I'd like to focus on the first reason why we oppose the bill, which is perhaps the most important one. The bill, as written, allows any person aggrieved by any violation of RSA 193F to sue and recover attorney's fees, so long as the lawsuit alleges that the violation was a result of gross negligence or willful misconduct. The bill allows a plaintiff to prevail even if no actual bullying occurred, so long as there was some violation of some provision in RSA 193F. Now, RSA 193F includes many technical provisions for reporting, investigating, and following up on suspected cases of bullying, all within very tight deadlines. And those deadlines are, under some circumstances, easy to miss. So it's easy for a technical violation to occur. And as this bill is written, such a technical violation would allow a lawsuit, as long as the complaint alleges that there is gross misconduct or willful violation. And then the district would have to defend itself in court. And if there was a technical violation that may have been the result of gross negligence or willful misconduct, but just technical, with no harm, no foul, no one was injured, that would still give rise to a finding against the school district and an award of attorney's fees. Now, a year ago, the House defeated an identical bill, House Bill 1335. And in their minority report, the sponsors of that bill said, quote, last year, we passed legislation allowing parental suits in cases of discrimination in schools. Are we now saying that parents can sue for discrimination cases, but not when the district has been guilty of gross misconduct in a bullying case? Unquote. But here's where that analogy fails. A victim can prevail in a discrimination case only if, one, there has been actual discrimination, and number two, there is some causal connection between what the district did and the discrimination. House Bill 140, in contrast, allows the plaintiff to prevail and to recover attorney's fees for a technical violation of RSA 193F, even when no bullying actually occurred. This is a recipe for frivolous litigation. Look at the three ingredients. Number one, liability for any technical violation, regardless of whether any bullying occurred. Number two, a standard of liability, gross negligence, that, as my letter points out, the law does not define. And third, a prevailing plaintiff can recover attorney's fees, but a prevailing defendant cannot. So please defeat or amend House Bill 140. It's well-intentioned, but grossly overbroad. Thank you.
Thank you very much, Attorney Gisellen. Are there any questions? Yes, Representative Moffett.
Thank you, Mr. Chair. Thank you, Attorney Zahn. You touched on a point that I had brought up earlier. I'd like to ask you if the word aggrieved was changed to injured, would that change your view of this bill?
Well, that's an indirect way. I would rather have the meat of the provision talk about an actual injury being the bullying, and the district, either that the child was bullied and that there was some causal connection between the bullying and what the district did or did not do. Because injury in the abstract, how do you define that? There could be an injury to someone's feelings. There could be an injury to a legal right. It's still a very vague term, and we'd be litigating that in the courts. Just, what is injury? Is it just an injury of a legal right? A violation of some technical provision?
Thank you.
Thank you very much. Representative Likis.
Yes, thank you for taking my question. It says, and I'm just not understanding, as a result of gross negligence or willful misconduct in violation of any provision. So if it was just a technical and the school district was doing their best and maybe missed a deadline because of a holiday or something, but they were trying or didn't manage to get hold of a parent or whatever, that wouldn't be gross negligence or willful misconduct, would it?
Well, one can through gross negligence violate a technical provision of the statute. One can through willful misconduct violate a technical provision of the statute. And yet it's possible under those circumstances that there was no bullying. In addition, as a practical matter, anyone can file the lawsuit and the plaintiff will prevail only if the defendant can prove that there was not gross misconduct or willful violation. But meanwhile, the school district has to go through defending itself. So this will open the door to lawsuits that claim the gross misconduct that ultimately can't be proven. But the lawsuits will tie up district resources and staff time. So the bottom line is a technical violation when no one was injured should not give rise to a lawsuit, no matter what the district's state of mind was.
Representative Boone.
Thank you, Mr. Chairman. Thank you for taking the question. Section 193F1, its purpose and intent is to protect students. And it goes through all the stuff. And so why having a law at all if at the end F9 says you can't do anything about it? So what's the purpose of 193 to start with?
Well, there are ways to enforce statutes. There are complaints one can file with the State Department of Education. Remember that this statute supercharges the right to seek judicial relief by allowing an award of attorney's fees. But again, to err is human, and sometimes people will also intentionally gloss over a provision of the statute. But again, if there was no injury, if there's no harm, no foul.
Further questions? Representative Lamb.
Thank you, Mr. Chair. Thank you, Mr. Chair, and thank you, Mr. Zeller, for taking my question. I'd like to ask your professional opinion. I'm still very, very traumatized by an incident that happened in 2008 in my former school, where a bullied student who had been sexually harassed and physically harassed by another student had his concerns repeatedly minimized by the school, and it was never addressed to the point where this child, Brandon McInerney, was left with the faulty reasoning of a middle school student and killed his classmate in the computer lab. This child found the wrong solution to a problem, but this child was failed by the school. And I don't know if there's anything in New Hampshire where a student who has not been supported by their school and has been subject to bullying and harassment at this level can find a remedy against the school district so that they're not left with such a horrible choice. Is there anything that a student or parent can do here in New Hampshire now for that sort of gross negligence on a school?
Well, there is that hurdle of our municipal immunity statute, as well as the statute that grants what's called official immunity to school officials. And I recite what they provide in my letter to the committee. But if the committee wants to protect those who have been bullied, which is the case you've just described, then the answer is to craft a more narrow bill that allows the lawsuit if there has been actual bullying and if the district's actions or inactions were somehow causally connected to that bullying. That remedies the injustice.
You have a follow-up?
If I may follow up, so that means legally there's no recourse for a student like that, so they truly are left to their own devices?
At the moment, that's generally the case, unless the parent can surmount the provisions of the municipal immunity statutes. Those municipal immunity statutes do not grant immunity to school districts or school employees for when there's extreme culpability, okay? But if this committee wants to create a lower bar for suing school districts or school employees, understood, that might be warranted, but that allowing the sue for the damages should be when there was actual bullying and not simply a technical violation of the statute. Now, if a technical violation of the statute, well, if a district, for example, ignored what the statute required for bullying or for intervening to take remedial action, and then the bullying continued, so the student remained bullied, then there is a causal connection between the district's action or inaction and that later bullying. And so that is if this legislature wants to create a remedy that targets the perpetrators, or that targets the school officials who allow the bullying, then write a statute that does that. But don't write a statute that says a district may be sued for any violation of RSA 193F whatsoever. Write a statute that allows a cause of action when there has been bullying and when the district somehow contributed to that unfortunate event.
Representative Lightfoot.
Yes, thank you again for taking another question. I noticed that it doesn't say that they automatically recover court costs, but they may recover court costs and reasonable attorney fees as the prevailing party. So my question is, would a judge award them that if it was a frivolous lawsuit?
Well, depends on what you call frivolous. If the plaintiff prevailed, and the plaintiff won because the school district failed to do something within 48 hours, as some provision in RSA 193F requires, it wouldn't be frivolous in the sense that it wouldn't be an unfounded lawsuit. If the district violated that deadline, then it violated the statute, and then the plaintiff could recover attorney's fees. But do we want every case where the district failed to provide a notice by the 48-hour deadline where it took 49 hours? The plaintiff would prevail. Is that the sort of lawsuit we want to invite by offering the plaintiff's attorney the prospect of recovering attorney's fees from the school district?
Representative Woodcock.
Thank you, Mr. Chairman. Representative Attorney Zelen, good to see you again.
Good to see you.
Representative Ladd, this is just a clarification case, if I may. I've heard Attorney Zelen speak about a document he has sent as testimony. I don't see any of that document on my legislative mail. Do you know where that went, or did everyone receive it, or am I the only one?
Oh, well, actually, Jane Bowden sent it, or at least she was supposed to send it, and I understood she did.
And Rep. Star, did you receive that?
I have to check on that new name. Attorney Zelen, the name was what, please?
Jane Bowden.
Okay, I'll check there.
What I can do as soon as I get off is email it to the committee, if that would help.
Well, that helped me. Thank you.
Thank you. Are there further questions of Attorney Zelen? Thank you very much, Jerry.
Well, thank you, folks, and thanks again for your public service. Appreciate it. Bye.
Bye.
Okay, next we have Megan Douglas. She's been promoted. Go ahead, unmute.
Megan Douglas, do you hear us?
I can you hear me?
Yes, we can.
Okay, I'd like to start basically by saying that I dispute just about every single thing that Attorney Zelen just told the committee. And we can start trying to figure out where to start. I think that Attorney Zelen said that this provision, HB 140, if enacted, would give plaintiffs the right to successfully pursue a lawsuit and get a finding by the court for a mere technical violation of RSA 193F4. That is false, as Representative Alicia Lake has pointed out. In order to be successful in a lawsuit against a school under under HB 140, if it is enacted, a student is going to have to show gross negligence in application of RSA 193F4 or willful misconduct. What that means is outrageous carelessness in application of the duties that this legislature has prescribed to the adult professionals in public schools. Outrageous carelessness or intentional harm in application or omitting application of RSA 193F4. That's what a court is going to interpret gross negligence and willful misconduct as. That's what those terms are likely to be construed as. And I want to tell you, Representative Woodcock asked, well, what does that look like? I want to lay out for you what it looks like. It looks like a poor child who has to come to school every day in the same Fila t-shirt because he has no other Fila t-shirt. He's in school, he's in middle school, and a kid who is a leader of another group of kids pulls on that t-shirt every single day. and calls him skank. Until finally it's ripped, and it's ripped before a teacher. And a teacher sees that act and actually has been seeing the pattern of behavior leading to this and does nothing. Nothing. But that's not even gross negligence. That would be perhaps a negligent or mistaken application of RSA 193F4. To be gross negligence, that same student would have to have that same type of experience. Perhaps the shirt is ripped entirely off in front of the vice principal this time. And the vice principal documents it in an email or in a record in the school's office. But as was the case in the Gravelin case, or the Gautier v. Manchester School District, which was discussed earlier, that vice principal is too busy to address the issue. Still not gross negligence. Gross negligence is now the principal sees this child walking without a shirt and being taunted and beaten by book bags in the hallway. And there's a record of this, and still there is no action by the school. That is the case that a plaintiff's attorney is going to take, because that finally looks like gross negligence. As a plaintiff's attorney, I can tell you that the mere prospect of attorney's fees maybe being awarding to me at the end of a year's worth of work and $100,000 of work hours invested in a case is not enough to get me to take that case. And I don't know of any plaintiff's attorney who is moved by the mere promise of maybe preserve attorney's fees to the prevailing party. And again, I compliment you, Representative Lakis. You also picked up on the fact that Mr. Attorney Zelen was inaccurate and misrepresented the way the fee shifting provision works. It does not go to the prevailing plaintiff only. It goes to the prevailing party, So that could be the defendant. Okay. I am really frankly gobsmacked at the way in which this provision, which it actually does very little to change the status quo, has been presented over and over again as some tremendous burden on public school officials, when all it really does is hold our adult school professionals accountable for not being outrageously careless or willfully harmful with the safety of our children in school. That is all this bill does. And if you vote against it, what you're really saying is we don't want schools to have even that low standard of care. We don't want that because it's too much. And I think that that's a travesty for New Hampshire's children. There are a number of other things that were brought up that I'd like to address. The First Amendment has very limited application, or it has limited application in public schools. So what does that mean? It means that speech that interferes with the school's mission, to include the mission to educate and include a child in the school community, is not protected by the First Amendment. Okay. Aggrieved. It is very likely, I don't think it's a big deal to change the word aggrieved to injured. I mean, I could talk to, I could maybe speak with Representative Cordelli about that. But I think that a court is very likely to interpret the word aggrieved to mean injured, because there's a basic principle in our common law that a plaintiff doesn't even have standing to come before the court to bring a lawsuit unless he or she can show some harm or injury. So I don't think there's a real risk that a court is going to interpret aggrieved to mean anything different than injured or harmed, some provable injury or harm. The municipal immunity statute was raised. And I want to address that as well, because I think Attorney Zelen was inaccurate about that too. I think he said that there would be a municipal immunity problem with the enactment of House Bill 140. And I don't find that to be true, because the municipal immunity statute has an exception, basically revoking immunity when there is a private right of action expressly included in another statute. So there's a provision in municipal immunity that says essentially this immunity shall have no effect on private rights of actions guaranteed by or provided by other statutes. That's one of the reasons why it's so important to have an express private right of action for, again, gross negligence and willful misconduct in RSA 193F. Because without it, if RSA 193F9 is simply repealed, then there's still a chance that a cause of action may not lie. And then RSA 193F and all of the duties prescribed by it would only be enforceable even in the cases of most outrageous carelessness or intentional harm at the local school board level or via the Department of Education process, which, as we know, does not provide any economic relief to parents and children, nor really any incentive, I think, for schools to really pay attention to their duties under RSA 193F. Okay.
Megan, we're running out of time, and we need to get this closure so that questions can be asked of you.
Yep, I'm done.
Okay, thank you very much. Representative Myler.
Thank you, Mr. Chair. I think, Mr. Chair, for the record, I think when people come before the committee, they need to identify if they are representing an advocate group or a law firm. For those members of the committee, my understanding that Ms. Douglas is an attorney, and she's appeared before this committee on this particular bill before. And I think it's important for the committee knows that she does represent a particular viewpoint from a legal standpoint. And I don't know which law firm you're with, Ms. Megan, but it'd be Ms. Douglas, but it'd be good for you to, I think, to identify that for the committee. Thank you.
I can happily do that. It gives me an opportunity to add that I did submit written testimony on this subject matter, and it should be in your email inbox. And I am an attorney at Douglas, Leonard and Garvey. I am a plaintiff's attorney. I identify that in the very first paragraph of my written testimony. I am the attorney who represented Morgan Gravelin, who was badly beaten in the cafeteria back in the early 2010s. And I represented her with my co-counsel all the way up to the Supreme Court. And that was where we learned the ineffectiveness of RSA 193 F4.
Thank you very much.
Thank you. Are there further questions of Ms. Douglas? Not seeing any hands. Thank you very much.
Thank you very much.
Next, we've got
Welcome, Mr. Christina.
Thank you, Chairman Ladd. Good morning, members of the committee. Thank you, as always, for taking my testimony. For the record, Barrett Christina, Executive Director, New Hampshire School Boards Association. We are opposed to House Bill 140. A couple provisions of statute that we had talked about earlier that I'd just sort of like to reiterate. And then I'm going to go back and read the legislative history on RSA 193F. When it was enacted in 2010, this may jog the memory of, I believe, at least 3 members of this committee, Chairman Ladd, Representative Shaw, and Representative Bohm. You were on the committee at the time this bill was passed. So we talked a little bit about the purpose and intent in RSA 193F2. The sole purpose of this chapter is to protect all children from bullying and cyberbullying. And in reading the note in the legislative calendar from 2010, this bill offers greater guidance to school districts to improve their policies and procedures for reporting, investigating, documentation, and response to incidences of bullying, harassment, intimidation, and cyberbullying. It also requires annual training for school personnel, students, and parents. This is the bulk of the testimony. Nowhere in this bill is there a requirement that school districts eradicate bullying. Indeed, that would be absolutely impossible. As Representative Cordelli noted, there were 1,600 reported cases of bullying, whenever that, I forget what year he said that was. That's a good thing. That's a good thing that we have that number of reported cases of bullying. And in response to the fact that 65% of those go unreported, we wish that that number was actually higher. The higher that number gets, the more responsive our school districts are to addressing issues of bullying and cyberbullying. So it's terrible that these kids are still bullied, but school districts can't eradicate bullying. We can respond to the statute, we can respond to our local policies, and we can interject with the intervention services that are either found in local policies or found within the statute itself. Relative to the accountability aspect, it seems that the accountability of a bully should be with the parents. There's a lot of discussion in this committee about parents' rights, what parents should be able to do, and how parents should be able to raise their children. And the accountability ultimately falls on the parents. So if there's a bully in school, the school district has limited responses that it can do. It can intervene, it can do the peer mediation, it can discipline a child, detention, suspension, whatever the case may be. But also relative to that, the accountability of the parents to ensure that they're not sending in a bully into the school. Ms. Douglas, I spoke to Ms. Douglas last year when the bill was being heard, House Bill 1335, and I asked her after the hearing, why didn't you sue the parents of the bully? And she said, well, they didn't have any money. So if ever there was a perfect statement as to why the plaintiffs bar may be supporting this bill, I think it sums up in that statement. We also need to be careful with the specific language of the bill, as people have mentioned out, the language, any person aggrieved by a school district decision. I just want to make the committee understand and recognize that's not just going to be the victim of bullying. It could be the perpetrator who insists that it was not bullying. So school districts are going to get it not just from the bully. We're not going to be sued just by we're not going to be sued just by the victim of bullying, but the language states that if, a kid is found to have been a bully and the parents disagree with that, they can now sue the school district because the kid's reputation has somehow been damaged. The other aspect that's very challenging with this, when we talked about Representative Moffitt, I think you brought this up, changing the word aggrieved to injured. That may help, but what we have to ascertain is what's the level of injury. So I called Johnny a name. How do you ascertain monetary damages for me picking on Johnny or calling him names? Now I understand that bullying takes on, more significant actions than just name calling. There may be physical intervention, physical acts that result to bullying and other things that come along with that. But ascertaining the damages is I don't know how you do that if a kid's being called a name or a kid's feelings are hurt. Some other aspects to the bill. I see that this is only applies to public schools and charter schools. It should probably be expanded to apply to the approved school tuition programs under RSA 193:3. I believe that's paragraph 6. That's the Croydon bill, or SB 8. From a couple years ago, that allows school districts to send their kids to a private school. Why they are not included in this, I don't understand. But if we're sending public schools off using public money to a private school, again, it seems that they should be held to the same standards as traditional public schools. And the other thing that I'd like to mention as well too, as we know, Governor Sununu signed, I believe it was Senate Bill 263 a couple years ago, that opened up private rights of actions in the discrimination realm if a student's being discriminated against. It's very possible, and I forget which of the speaker, Representative Leon, it may have been you or it may have been Ms. Douglas, talked about a student who was being sexually harassed or bullied on one of those protected classes. There's a private right of action already available under that bill or under that statute. And you know, if you ask more practitioners that defend school districts on these bullying allegations, or school administrators, if superintendent or a principal, one of the challenges with these bullying investigations is how to interweave the bullying investigation under RSA 193F versus federal investigation. I'm sorry, investigations under what would be federal anti-discrimination laws. So if it's a mix of bullying and sexual harassment, you're basically trying to run two concurrent investigations. There's certainly some overlap. But so it's not just bullying isn't just sort of a separate, you know, category out there. There's a plethora of anti-discrimination laws as well too that allow for private rights of action against school districts. So we don't think this is good public policy. I just remind the committee that, again, the goal of the statute, reading through the legislative history and looking at the plain language of the statute, is not to eradicate bullying within public schools. That's absolutely impossible. The goal and the purpose of the current version of the bullying statute as it stands now it has been to implement greater school district responsibility in terms of investigation, reporting, parental notice, and things of that nature. And the fact that we have 1,600 reported cases of this tells me that school districts are doing the right thing, and we're investigating these, you know, in the way that they need to be investigated. So that concludes my testimony. I'm happy to take any questions.
Thank you very much, Barrett. Are there questions for some? Did you have a question, Representative Likas?
Yes, I did.
Thank you. Representative Likas?
Thank you for taking my question. You were talking about parental responsibility, et cetera, but part of 193F is reporting, and it's very difficult for a parent to take responsibility if they are never told about the incident.
Thank you, Representative. Was there a question there?
And I did, and I just didn't, I'm sorry.
That's quite a Representative. I understand the point you're trying to make, and thank you.
Further question, Representative Leon.
Thank you, Mr. Chair, and thank you for taking my question. You spoke to the protections for protected classes. Is that something where, when it is the transgender child sexually harassing the cisgendered student, where they also have a private right of action, or is that only if it had been reversed and it was the cisgendered student who is sexually harassing the transgender student?
Thank you for the question, Representative. Just please excuse me, sometimes the volume is not great. If a transgender student sexually assaulted a cisgendered student?
Yes.
Thank you for the question, Representative. I'm not an expert by any means in anti-discrimination law. I know that the The bill that was enacted a couple years ago, I don't believe has been tested or litigated in New Hampshire yet, so I can't say.
Thank you, because that was the situation at hand. Thank you.
Are there further questions of Barrett Christina? Pardon me?
I don't see any.
I don't see any either, so thank you very much.
Thank you, Representative. Thank you.
Yes. We have Marissa Chase who'd like to speak next.
Marissa Chase?
Yep, she's been.
Good morning, representatives. Can you hear me? Okay, thank you very much for allowing me to speak. For the record, my name is Marissa Chase. I am the Executive Director for the New Hampshire Association for Justice, the plaintiff's bar, as Attorney Christina just mentioned. A couple of points I wanted to make. One, Attorney Christina just mentioned that Senate Bill 293, the anti-discrimination suit, the anti-discrimination bill passed with the private right of action a few years ago, has not yet been tested. That means that there have not been any lawsuits filed testing that. I think that explains, or demonstrates rather, that there are no frivolous lawsuits filed in New Hampshire. We have a very collegial bar. Our organization represents about 400 members. And something else, frankly, I found Mr. Christina's testimony to be a bit condescending when talking about lawyers wanting to make money. As Attorney Douglas mentioned, plaintiff lawyers take cases on contingency fee. That means they better be pretty well sure that a case is viable before they take it. A potential client, someone has been injured, nobody ever wants to think they need an attorney. They call a law firm. The law firm does hours of investigation, usually having to spend thousands of dollars on experts for that investigation to determine whether a claim is viable before even taking it. An attorney spends money all throughout the case and may not even recover at the end. They don't recover unless they prevail. That means, again, that New Hampshire attorneys do not take claims that are not viable. That's why we don't have frivolous lawsuits in New Hampshire. New Hampshire also has no punitive damages. We don't have runaway jury verdicts. So the claim that lawyers want this to make money is frankly appalling to me as someone who represents lawyers and plays one before the legislature. I think that as Mr. Barrett Christina mentioned, again, Senate Bill 293 has not yet been tested. There have been no claims filed. As Attorney Douglas mentioned, these cases would have to show outrageous lack of care. It is important to note something I would perhaps suggest as an amendment. New Hampshire's civil justice system does not recognize degrees of negligence. The criminal context recognizes gross negligence, willful misconduct, etc. Our Supreme Court has never interpreted degrees of negligence. A negligent act, I think you can infer, is a much higher degree than we think of colloquially. To be immune, you just have to be responsible. Responsibility is the only immunity you need. And a law without a penalty is just a suggestion, in my opinion.
Thank you very much, Marissa. Are there questions? Not seeing any hands. Thank you very much.
Thank you. I appreciate your time.
Next, we have Carl Ladd from the New Hampshire School Administrators Association.
Good morning, Mr. Chairman. Good morning, members of House Committee. For the record, my name is Carl Ladd. I'm the Executive Director of the New Hampshire School Administrators Association. I'm not going to take up a lot of your time repeating testimony that you've already heard. I would just like to note that so far you folks have heard from 4 attorneys, and each one of them have come up with a different definition or a different explanation of gross negligence or willful misconduct. One of the attorneys indicated that the court would likely determine that gross negligence is outrageous carelessness, but there is no legal definition of gross negligence in the state of New Hampshire in any case law. So what we would be doing with this particular bill is opening up a whole new slew of lawsuits, contrary to the prior speaker's indication. There's going to be a whole new slew of lawsuits at public taxpayer expense to define gross willful negligence. I think that without there being a clear definition and some guardrails placed around this piece of legislation, it will open up an incredible number of lawsuits. Having been a school building principal for many years and a superintendent when the statute was first initiated, I can tell you that building administrators spend hundreds, if not thousands of hours investigating all of the complaints of bullying that are brought in front of them. And I can tell you that parents often feel that they are aggrieved because the decision by the administrator may not have been what they wanted, or because of Student Privacy Act, they cannot provide the aggrieved parent with the exact disciplinary measure that the administrator may have taken. So therefore, they are upset because they feel that the student may have gotten off, but that may very well not be the case. With this language within this bill, any aggrieved individual, so a parent who is aggrieved because they feel that the school district just simply did not listen to their complaints and did not punish the other child sufficiently enough, could also bring forth a lawsuit stating gross negligence or willful misconduct. I think that if, I do agree with Attorney Zellen, if you folks really want to put forward some legislation that gets at the heart of what it is you would like, then I think the language needs to be much more narrow. And I think that, you know, I do think that there are certainly school attorneys who would be willing to work with the sponsors on this. And in the interest of time, I'll end my testimony there and be glad to answer any questions. Representative Shaw, I will be sending a written testimony as well.
Very much, Carl. Are there questions for the School Administrators Association? I'm not seeing any. Thank you very much, Dr. Ladd.
Thank you.
As a courtesy, I feel like a judge here with attorneys wanting to rebut things. I'm going to provide Jerry Zellen another very short time, Jerry, to respond. You got mute there, Jerry.
Thank you, Rick. In the interest of the committee's time, I can just send an email with my follow-up remarks. Would that be best?
That would be fine.
Thank you. That's what I will do.
Thank you very much. Have a good morning.
You too.
Are there any further folks to testify that we have on this? Okay, so in summary here, I have 18 people supporting, 29 opposed, neutral 0, testifying 1, 2, 3, 4, 5, 6. I think that is in the ballpark. Okay, thank you very much. With that, I'm going to close testimony and the hearing for HB 140. For those sitting here, I'm going to take a 4 or 5 minute break, and then we'll come back in 5 minutes and pick this back up.
With HB 257.
Yeah, with HB 257.
Yeah.
You should allow an hour for that. Yeah, that's I don't think that's proper. Yeah, that's 2 seconds.
Silencio.
Coverage of his trip to camp.
Shit. It's something here.
Okay, for all our committee members, is that unmuted now? Because for all the committee, we're ready to open up the next hearing here. We are looking at HB 257, prohibiting political advocacy in public schools. The prime sponsor of that bill is Max Abramson. Representative Abramson, is he?
He has been promoted. Yep, he's there. Welcome to education.
Representative Abramson, can you hear us?
Yeah, I hear you. Can you hear me?
Yes, we can.
Okay, I'm still not used to these Zoom meetings.
Well, just forget being at Zoom and just do what you normally do, Max.
All right, I'll do my thing. I'm Representative Max Abramson. I'm here introducing House Bill 257, which is aimed at preventing political advocacy in public schools. This bill is absolutely not aimed at public school teachers. My grandmother was a public school teacher for 30 years, and there were, in her time, there were only a handful of school teachers who were pushing partisan politics. And what I've heard in the Seabrook School District and Winnicott School District is there are only a handful of school teachers who are doing this. The numbers are pretty low, but the principle is that public schools are there to teach children how to question all of our old assumptions. The example that I use is when I was attending school, we were being told over and over again in the movies and textbooks and material that was pushed in front of us that dinosaurs were cold-blooded reptiles. And we even saw a number of videos with Tyrannosaurus Rex still dragging their tail along the ground. And I had read some articles from more recent magazines on paleontology that showed that that wasn't true. So a lot of the material was outdated, but I was upset they were kind of taking sides. The next issue that I saw when I was a kid was that they were pushing this idea of an ice age happening, and that continued all through the 1970s and 80s and early into the 90s. And at the same time, they were also telling us that global warming was going to happen. And I said, this is, even as a kid, I said, the most advanced supercomputers that we have and the most advanced information we have on weather predictions and meteorology, there's no way we can predict. So it's climate change is one of those areas that's uncertain. And finally, the schools have come around to supporting what I think is a scientific view that that climate change is happening, but it's unpredictable, and there's no way we can know what the human contribution to that is. The bill simply says three things. It says, one, no public school shall campaign for or against any political candidate or measure that is on the ballot within that district. We've seen school district employees at Winnicott High School and some other schools holding signs, and I don't object to that at all. That's their absolute legal, moral, and constitutional right. Whatever influence that may have and whatever trust they may have with the parents coming through. But I found that they were using paid personal days to do that. And so as I walked by, or as I even held signs myself at some of the polling locations, I felt that they were literally using taxpayer dollars for campaigning. And I think that's a big no-no. I'm not sure that we need to spell that out in the statute in detail, but I felt like the use of tax dollars for political campaigning was just not right as a matter of principle. Number two, no employee of a public school shall advocate for or against any political doctrine nor subject any political position to ridicule while instructing students. That's really two ideas. The idea that the whole notion of education is teaching children to take on the scientific method and subject our old ideas to scientific scrutiny, whether they're political, scientific, economic, or otherwise. Most of the things that they were teaching in public schools in the 1970s and early 80s in the area of economics have been disproven, and a lot of the historical debates that have gone on have not been fully resolved. And some of them, if you've watched the Article 5 convention debate and what happened with the 1787 Philadelphia Constitutional Convention and the Annapolis Convention of the States, that there's a lot of dispute going on right now. Part 3, no student shall be deprived of the right to freedom of speech or of the press unless that expression is not protected under the First Amendment. There are some schools that have been selectively censoring news stories. I'm not sure that it's more conservative or liberal, if it's more right wing or left wing. But the idea of students having their own paper and expressing their own opinions, as long as it's not hate speech or something that creates a hostile learning environment for the kids, I don't think that the school district should intervene. That what we're supposed to do as adults is maintain an environment where kids can question, promote their own ideas, debate them, whether they're for or against the death penalty or they're pro-choice or pro-life. I think that it's something that we have to do. We have seen rare instances. For example, in Seabrook, there's a school teacher who's still discouraging her students from standing for the pledge. There's another school teacher in Winnicott High School. I've been told that he finally stopped doing this, but he was promoting videos that were obviously very Democrat-leaning historical videos. The biggest concern, though, for me has always been the textbooks. It's the teaching materials, the videos, the films that they used to play. The majority of public school textbooks come out of Massachusetts, and they have a tendency to come out with a heavy bias, whether it's intentional or not. When people have looked at it objectively, they're seeing that it's not objective at all. There's a report on one of the most popular textbooks out there called The American Pageant. Says, whereas Democrats Woodrow Wilson and Franklin Roosevelt are described respectively as, quote, a lover of peace and, quote, the premier American orator, unquote, Republicans Dwight Eisenhower was an example of, quote, the bland leading the bland, unquote, and Ronald Reagan was, quote, no intellectual, unquote. The report on the American Pageant materials, high school curriculum, goes on to show other examples where they're promoting an interventionist form of government, and they're promoting progressive economics, and they're promoting a one-sided view of American presidents. And this shouldn't have any great impact on people. But I see kids coming out of high school, and when we talk to them, they know absolutely nothing about our history. They don't know that, for example, Dwight Eisenhower was one of the great civil rights leaders of our country's history. So much of that just gets washed under, or even Barry Goldwater's civil rights voting record. Most people don't know about it because the public schools don't teach it, and so the media doesn't mention it. It doesn't get mentioned in debates, or that 7 out of 8 civil rights acts were signed by Republican presidents. Parents find out after the fact that books like this one, I'm not going to open it, it's called It's Perfectly Normal, and Planned Parenthood puts material like this in the public schools. And a lot of parents have objected to that after their kids have been exposed to it. We passed legislation a couple of years ago to try to notify parents before kids are exposed to this. But it has drawings and depictions of children as young as 10 years old, boys and girls masturbating, gay sex, interracial sex, and things that some parents object to, and those parents have a right to raise and educate their children according to their own standards. I don't want to go into too many of the examples of specific cases of censorship. This bill is really aimed at just the general principle of protecting in public schools and charter schools. It's meant to protect the environment that kids grow up in. I personally don't have any objection to parent-teacher conferences if politics comes up, even though that might violate some other constitutional principle. For me in particular, kids when they're young and impressionable need to be exposed to lots of different ideas, good and bad ideas. They need to learn to compare individualism and collectivism, Keynesianism versus socialism, and laissez-faire, and all the different ideas that are out there, all the different political and economic philosophies and views on history. So what the bill is intended to do is strengthen some existing laws like RSA 191 to ensure that that kids are not getting a one-sided view of things, that if there are textbooks and there are teaching materials that are heavily biased or partisan, that we reject those, that school districts not select textbooks and teaching materials and video that are one-sided, but that ask questions rather than take the heavy-handed approach of telling you what to think or believe. So that's why I've introduced this bill. I had intended to introduce it 2 sessions ago, but I think that now that this has become much more public, and now that we're outside of the national partisan environment that we had a couple of years ago, I think that this is a better time to introduce this kind of language.
Thank you very much, Representative Abramson. Are there questions for the sponsor of the bill? Representative Milan.
Thank you, Representative Ladd, and thank you, Representative, for taking my question. So I have a concern here. If we have, for example, a charter school that has been granted a charter, and that charter school basically uses, let's say, Rush Limbaugh's text, and only invites in conservative candidates, this law would, and parents have chosen the school because of that particular mission, I would assume that this law would prohibit that kind of granting of a charter to that particular school. Is that correct?
It's not meant to prevent you. That reminds me of a quick story. It's not meant to prevent you from going into a school and stating things as a matter of fact. So I was invited into a high school a few years ago to speak on what is classical liberalism, the kind of Jeffersonian, Gladstonian philosophy. And I explained what it is. I didn't advocate for those positions. I simply said, here are the 10 points of classical liberalism. When I was in public school, I did have one teacher who would listen to Rush Limbaugh and a lot of conservative talk radio. But as soon as the first bell rang, he would push the stop button on it, because classroom time is for learning and questioning. So this bill would say, yeah, you have to, push the stop button, and you can't use classroom time, and you can't use the public schools for advocating for one position or another. Obviously, Rush Limbaugh was certainly pushing for conservative positions, but I think he was spending about 2/3 of his time mocking liberals and mocking Democrat politicians. And there's no question that he was definitely partisan. So this wouldn't be allowed, like the Rush Limbaugh show wouldn't be allowed in public schools or charter schools. But if you had a conservative speaker or liberal speaker or social democrat coming in, they could speak, but they wouldn't be allowed to come in and advocate for positions. They could simply say, here's statements of facts.
But as a follow-up, but my question, though, to you, Representative, is that if the mission of the school is in fact granted through its charter to provide a conservative viewpoint only, this law, your proposal here, would negate that possibility if only one side of the picture is in that particular mission. Is that correct?
That's actually the intent. That's the intent of the bill.
Thank you.
To say that when we're talking about tax dollars, this is money that's taken from you. You shouldn't be made, as Thomas Jefferson said, to pay for the advocacy of a position that you find morally reprehensible or which you just disagree with.
Thank you.
Representative Moffitt.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. I come at this from both a public school person and also from the professor level, but let me ask you this. Oftentimes, teachers or professors, when there are certain discussions going on in class, employ the Socratic method. They ask questions. Oftentimes, they teachers play devil's advocate when some issue is being discussed, and to make sure that both sides of an issue are addressed, the teacher will play devil's advocate and ask questions from one perspective, and then they may ask questions from the opposite perspective. So my concern, my question is, if a teacher in the course of trying to get all perspectives, represented, gives expression to a perspective one way or the other, are they at risk of being reported on by students as committing advocacy? Is this a concern to you at all?
Well, you're at risk of being reported on regardless, but if you mean what effect does the law have, I don't think that the use of the Socratic method, provided it's objective, provided that you're, whatever it is a student advocates for or states as a political position, the use of the Socratic method, or even hard cross-examination of that student's viewpoint or statement, to whether it's to sharpen the edge or really put it into question, is that a collectivist idea? Is that an individualistic idea? That this bill certainly wouldn't prevent it, provided it's fair and objective. And public schools and charter schools, anything that's taxpayer funded must be fair and objective and equal to all sides.
Thank you.
Representative Ellison.
Thank you, Mr. Chairman. Thank you, Representative, for taking my two quick questions, just for clarification. One, on your first point about paid personal days for teachers, your position is that if I'm a teacher and I have personal days written into the contract, that I cannot use one of those to hold a sign outside a voting building?
Right. You should not be able to. Parents, when they found out that, I have no problem whatsoever if you're taking an unpaid day off to go out and campaign for any position that you want to. Once you're off the clock, as far as I'm concerned, you're off the clock. The argument for paid personal days was that those were personal days, where they were for stress or medical or almost anything else that was for personal use to kind of unwind as an employee. School teachers are in fact employees, but it shouldn't be used as a way to compel taxpayers to pay for one side on a warrant article or a campaign or a candidate or another.
Thank you. Mr. Chairman, one more quick question, please.
Go ahead.
Clarification on the example you used of a teacher, I think at Winnicott, who was implying or telling their students, his students, her students, they should not stand for the pledge. I think that's the example you used.
That was, I think that's Seabrook Schools, and I actually don't know the teacher's name, but I'm not going to use a specific teacher's name.
Oh, and I'm not asking you to. Would you feel the same about a teacher in that school who was telling their students they should stand for the pledge?
Would I feel something? As a Liberty guy, I believe that standing for the pledge or making any statement must be a completely voluntary act. Joining any organization should be a voluntary act. Payment should be a voluntary act. That whatever we want to get someone to do has to be strictly voluntary. You can use persuasion and education. You can argue the case or warn about consequences of doing something or not doing something. But I don't believe in forcing something on someone.
Thank you.
Thank you. Representative Lay.
Thank you, Mr. Chairman. So I had a question here regarding the first portion of your bill, which states that no public school shall campaign for or against, et cetera. First, what do you mean no public school? I mean, does that encompass all of those who work there? I mean, what is meant there?
The public schools, the school district, as far as how the courts view it, it's they'll view the school district or they'll view the public school as a kind of entity in and of itself, and it would be the same if you had a company. A company should not be able to campaign for or any other organization. When someone's acting in their capacity within that organization, that they shouldn't be using that capacity to do so. None of this,
Follow up,
none of
Mr.
the district facilities or books or materials.
Thank you. You're saying campaign for or against any political candidate or measure on a ballot. RSA 659:44-A already states that electioneering by public employees is prohibited. Would that already cover the employees of the public schools and the school district?
Not completely, because not all advocacy is electioneering.
It's okay. All right, but it does say that electioneer means to act in any way specifically designed to influence the vote of a voter on any question or office, which sounds remarkably similar to your statement or your language that is on a ballot within that district. What would be the difference between those two phrases there? You're saying that is on a ballot within that district, and the current statute, which states cannot influence the vote of a voter on any question or office.
Are you saying RSA 659, section 43?
44-A.
Sorry, I'm on the wrong statute for prohibited acts.
It's number 3. It's the definition of electioneer there.
All right, I don't have it in front of me. I have 659, section 43, but I don't agree that they're the exact same definition. But it certainly is happening. When I was gathering signatures for citizens petitions and for putting independent candidates on the ballot, electioneering included, if I recall correctly, just getting signatures for a candidate. It wasn't my intention that if somebody wanted to gather signatures, whether they were a school district employee or not, they should be allowed to do that.
Mm-hmm. Follow up, one more, Mr. Chairman. Is that okay?
Yes.
Oh, okay, thank you. I just had another question on the second section, number 2 of your bill. How would you define political doctrine, and how would you define political position? Both of which are mentioned there. Particularly, would this encompass all historical political doctrines and political positions, as well as contemporary, current?
Political doctrine would just be something that is actually up for a vote, either for the voters or for the elected officials. That it's something that people argue for, where you're trying to get people to vote in favor of or against. For example, my Civil Rights Bill of 2019, that's a political position. The Civil Rights Acts of 1866, 1871, and 1875. Those were all civil rights acts. They were political questions, and a doctrine would favor something like abolition or suffrage, women's suffrage, suffrage for freed blacks, and so forth. That's advocacy for positions that I think 99% of people support. But it still wouldn't be appropriate, even if it's something that you and I agree with, and probably everyone in this room agrees with, to push for that doctrine, to push for a doctrine, because what schools are supposed to do is get kids to challenge absolutely everything, even if 99%, even if 100% of people in society agree with something. The learning process is about learning. It's about learning how to question things. It's about learning the scientific method itself. It's about learning to apply that, or to choose whether or not to apply the scientific method to political questions and political doctrines. It's not about pushing, one set of conclusions or another.
One final. I certainly agree with you on the notion that one of the major functions of teaching and of education is to promote questioning and promote. I think the generic term often is used as critical thinking. But I wonder who would determine the line between simply promoting questioning and critical thinking versus advocate or ridicule, which are both words in your proposal here. Who would make that determination? Who would determine that? Who would define what is advocacy and what is ridicule as opposed to simply promoting questioning?
Every time we enact a law or propose a law, whether it's this committee or any other, it's well understood that the ultimate determination of fact is usually handled by a jury, and that the questions of law are handled by the courts, ultimately by the New Hampshire Supreme Court. And in very rare cases, it moves up to the federal courts. But I would think that it's something that would ultimately be decided by the New Hampshire Supreme Court, unless it's a matter of fact, in which case it's handled in the trial courts.
Thank you.
Representative Woodcock.
Thank you, Mr. Chairman. Representative Averson, thank you for taking my question. If you may, I'm looking specifically at line 4 and line 5 on your bill, Max. The part that talks about a measure that is on a ballot within a district. So it starts as no school, public school shall. I just want to be clear, when, at least in my school district, this is the school district I live in, when they have a building bond, when they have positions on the warrant annually, they send out to all people in the town or on the postal patron mailing list information about the bonding and that why it should be supported, what's necessary, or the warrant, why it should be supported, or other pieces of the budget, why it should be supported. I mean, it's a high gloss brochure. They take ads out in the local newspaper explaining their budget and why these bonds or bills or warrants, whatever it happens to be, should be supported. But I'm reading here, the school, public school, which you said was the district, shall not any measure that is on the ballot within the district. And these typically always come out before the ballot for the town meeting or wherever it happens to be in our form of government. So would that, under your bill, would that prohibit the school from sending out that position and informational items on bonds and warrants, et cetera?
It wouldn't prohibit them from sending out material. I'm from Washington, and we had voters pamphlets that would come in, and they were really thick. They were as thick as the House calendar, and they had information. They had information from both sides. Sorry, my phone's ringing. Got to ignore it. And they're sending out information both sides. It would be fine if the school district or the town or the city sent out mailers saying, here's information about what the article does or what its intent is, but it wouldn't be appropriate to advocate for, let's say, pay raises for the supervisors union, or for or against. It wouldn't be appropriate for them to lobby the voters at taxpayer expense. That wouldn't be right. And in Seabrook, people have seen that happen occasionally on articles where the town government is advocating for a position and people object to it. They raise objections, but currently they don't have, or the school district does, or Winnacunnet High School does. Currently, they don't have any avenue to put a stop to that. It's okay to make statements of facts, and it's okay to allow equal time for both sides on an issue, but it isn't okay to take a one-sided position and force taxpayers to pay for the one-sided position, advocating, against taxpayers' interest.
Just to follow up, Mr. Chair, if I may.
We're running kind of short on time here. We have another person like to ask a question.
Well, this is one follow-up. Representative Averson, so on that behalf, in those written documents, if it says the school board is supporting this 7-zip or 9-zip, and that's what they're doing, they're supporting this bill, bond, warrant, whatever it happens to be, or pay raise or negotiated contract, they're telling you what their position is. So you're saying they would not be allowed to do that because they're taking a singular position?
They would be allowed to make that statement. In fact, the reason that they are allowed to make that statement is we have another statute a more specific statute that says that they're required to tell you, if budget committee or the selectmen or the school board took a position. So when you pick up the town warrant and you look through it, it'll say the school board supports this 5-0, or the board of selectmen supports this 3-0. They're allowed to say that.
Thank you, Mr. Chair.
Representative Ford.
I think he's still muted.
Yes, Sam. Representative Ford, do you have a question or are you okay?
No, I have a question,
Okay.
Mr. Chairman. Can you hear me now?
Yeah.
Yeah, I hear you.
My concern has to do with, I don't sense much in your bill that recognizes the academic freedom of teachers and faculty in terms of what they teach and what opinions they might expect, or their concomitant academic responsibility to present a full range of perspectives on it. And this would seem to impede on those rights, which I'm sure they're going to stand up almost immediately and protest. Do you have any room, I suppose, in the way the bill is stated, that protects their academic freedom to maintain their interpretation?
I don't think that the bill does step on a teacher's right to express their opinions. I just don't believe that while the school is on the clock, or while the teacher is on the clock, or any public employees on the clock, that they should be promoting one side or the other. Like I say, my grandmother was a public school teacher for 30 years, and I knew quite a lot of school teachers, and the vast majority of school teachers would never even give the appearance of advocating for one side or another. They, just like a judge, insisted on being completely objective to the very end, or in a trial by jury, that the judge tried to remain as objective as they possibly could. We put this similar position on the ballot in Winnacunnet in 2013, and it passed with about 2/3 of the vote. It passed in every single town from Northampton to Southampton. And the teachers union officials were arguing that this would take away freedom of speech, and that was presented in front of the voters, and the voters said, no, it doesn't take away freedom of speech. And was it 60 to 70% of the voters in each town voted for this similar measure to say, public schools should not be used for promoting political positions or political doctrines, and they shouldn't be used for political advocacy or any partisan position of any kind.
Thank you very much. Are there further questions? Not seeing any hands. Thank you very much, Representative Higginson.
Thank you.
Okay, next we have Penny Culleton. I have promoted her, I believe.
Yes, hi, can you hear me? Can you hear me?
Yes, we can.
Okay, thank you. So I'm Penny Culleton. I'm from Temple, New Hampshire. I'm representing just myself. In the interest of time, I think that Representatives Layton and Woodcock already covered Section 1 of this bill, which I oppose quite well. So I'll go on to some concerns about Section 2. The bill's sponsor mentioned history texts. So obviously the section does not apply only to local ballot measures, as I mentioned in the first section. And I'm wondering, would this prohibit showing, for example, American World War II era anti-Nazi propaganda as part of instruction? These things were often satirical and satire ridicules, political doctrines. Would a teacher who is presenting these be subject to some kind of discipline because of the wording of this bill should it become law? For example, also, should teachers teach that the separate but equal doctrine didn't have any ill effects, just remain neutral on it? Be neutral on Comstock laws or the Dred Scott decision. Should they be prohibited from discussing the tensions that exist between democracy and capitalism, for example? This section of the bill would, I think, have a chilling effect on the free marketplace of ideas that we expect our public schools to be. After all, as I think was alluded to, teachers often posit doctrines, positions, and theories that we're not advocating, but we're trying to prompt critical thinking in students. But literally, we would be violating this law if this bill becomes law in doing that. So I think that presenting something via certain types of literature could be confused with advocacy. And finally, on this section, over the past 30 years, I have taken, I'm a teacher, and I have taken several contractual personal days to testify before this committee over the past 30 years, maybe about 5 times. And I think that's a citizen's responsibility. The personal days are bargained into the contract, and I'm not instructing students when I am doing it. The bill's sponsor says it would prevent teachers from taking personal days to do what I'm doing right now. I happen to be on vacation right now, but I'm being paid for my vacation. Should I give up a day's pay? This is a paid vacation I'm on right now, so I shouldn't be testifying in front of this committee. I hope not. It's my responsibility to testify about things like this. The third part really troubles me. At the present, school officials can forbid some types of expression if they can prove that these would, quote, materially and substantially interfere, unquote, with the operation of the school. And I'm quoting from the 1965 Tinker versus Des Moines Supreme Court decision. Tinker states that First Amendment rights applied in the light of special characteristics of school environment are available to teachers and students. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech and expression at the schoolhouse gate, a very famous phrase I'm sure you're all aware of. This bill, however, would seem to both unreasonably restrict pedagogical decisions of professional educators while extending the free expression rights of students with no mention of exceptions for forms of expression that could be deemed disruptive. Currently, forms of expression not protected under the First Amendment include obscenity, fighting words, defamation, libel, or slander. Child pornography, and the bill's sponsor mentioned pictures of 10-year-olds in doing sexual activities. That would clearly be prohibited. It would fall under child pornography. Perjury, blackmail, incitement to imminent lawless action, true threats, and solicitations to commit crimes. There is no mention in this list of substantial interference with school discipline or the rights of others, because that's in Tinker. It applies to schools in light of the special characteristics, quote unquote, of the school environment. These are considerations that are mentioned in the Tinker decision, and they're the current considerations that administration uses for restricting expression within schools. As somebody who's been teaching for over 35 years, I'd have to say that issues like this almost always come down to whether or not something is disruptive or infringes upon someone else's free expression. I think that just limiting this bill to student publications would work. Okay, student publications, I think they should get that freedom. In conclusion, it's my position this bill should be found inexpedient to legislate in its current form. I'll also leave us with one last thought. Later in the day, this committee will consider HB 234 concerning freedom of speech and association in post-secondary education institutions. I favor that bill, and I suggest that the provisions of it apply to secondary institutions.
Excuse me, when we're starting to talk about other bills, there's a time for hearings on those bills. We are not talking 234 right now. We're talking this bill, which is addressing 257, political advocacy in public schools, K through 12. So I'm not going to allow discussion to go that direction. We are in a very tight timeline here. We're past a couple bills. I prefer to stay with this bill. So can you unmute the?
I'm done. That was it.
Okay, thank you very much. Are there questions? Not seeing any questions. Thank you very much.
Next, we have Natalie Rotundi. She's been promoted. Go ahead, please. Welcome to education.
Good morning. Thank you all for giving me a moment to speak. You can hear me? Thumbs up?
Yes.
Okay, okay, great. My name is Natalie Rotundi. I am a citizen in Milford, New Hampshire. I'm also a parent of school-aged children. And I thank you for the opportunity to weigh in a little bit on some of my impressions from not only the bill as it was written and I was prepared to speak to this morning already, but also in reacting to some of the ideas and questions that have already been discussed at this point. First and foremost, I find it a little scary that we would use past history as precedent for what we are willing to talk about in schools. I think that our society is rightly pushing to move political conversations from being impolite to being necessary, and the fact that we need to learn to talk about things with civility and with critical thinking is important, not only for us as a society, but also for us to model for our children. Right off the bat, I have to respond to the paid personal days. I just object really strongly to the fact that as our educators are paid with taxpayer money, that they somehow relinquish any rights to participate in our government. I have a corporate job. I get paid time off and paid vacations, and I am not prohibited from using that time to advocate one way or another and participate in local government. That does not mean I'm representing my company's stance. It just means that I'm using my time. So I just don't understand why we would expect teachers and educators to relinquish their own personal personas and take up just a public persona whenever they're participating in our local government. That was one thing. I'm forgetting, I've gotten it open in another, it's perfectly normal. I think that sounds like a completely separate discussion. I don't think we should be politicizing sexual health. If that's a concern, that's a completely different conversation. I don't think that we need to include this in this large of an umbrella. I think it's very important when schools should be able to link legislation that has an impact on schools and education, and it doesn't need to be only in the ballot. I think it's very important that our children and students are exposed to any local political movement that does have an impact on their education. I think we're raising future members of our society, and I think we need to trust our educators to be responsible in imparting this knowledge. I think if there's an overreach in terms of either disagreeing with a student who might ask a question or represent a different stance, I think those things should be taken on a case-by-case difference. I don't think that needs to be handled by a court of law as a first pass. I think that those are things that students and parents need to bring to their school administration. I think we need to have confidence in our educators. We need to have confidence in our administrators to hear from parents if they have concerns. I don't think we need to be shutting down conversations for fear that our children may hear something that we disagree with. I actually would encourage my children to come home and share different views and different perspectives that they're hearing from in school, even if I disagree, because it's an opportunity to talk through these things. It's an opportunity for me to justify why I might feel differently and why they may feel differently. I cannot, if I'm releasing my children into the public school system or they're leaving my home, I cannot reasonably expect that they're not going to hear things that I disagree with or that they may disagree with or that are offensive to us. I don't think that's a realistic goal or objective to have from public education. Specifically, the second section where it says, nor subject any political position to ridicule. I think that's really vague. I think that is in direct opposition to that Socratic method that was discussed by some of the representatives before me. I think that it's much too vague the way it's written. That is an absolute tried and true effective measure of education. I used that both in my secondary school education and then as a college student, many times having to be divided up and to represent a certain stance. And it's not always going to happen that in one class block or however a school has it, that you're going to hear from both sides in that conversation. That doesn't mean that they won't come up. But I just think that's much too vague, and we need to give children an opportunity to discuss things and to use their ability to do critical thinking. That's going to involve role playing. That's going to involve breaking down different perspectives and views. The third piece, which the freedom of speech piece, I think Penny, who spoke before me, and thank you for your contributions to the education in the state. I fail to see how this is going to be read differently from hate speech. The freedom of speech in the public domain is very much different from in institutions. For example, I can wear whatever I want on the streets around Milford, but I cannot wear that on a professional call necessarily. I cannot discuss professional views or in professional settings, certain political views. I think it's a similar argument for the school. I wouldn't want to see a child wearing something that could be offensive or saying something that could be offensive or hurtful to others in their school. And I realize that doesn't mean any attempt at freedom of speech is going to necessarily be off-putting in those ways, but it doesn't say that those things would be restricted. So I just think, what do we mean by freedom of speech? And I also want to know where. I wrote this down before and I realized some examples were provided this morning, but where have we prevented a child from having freedom of speech? I would love to hear some concrete examples where a child was stifled from their freedom of speech, because I think, as was said by some of our representatives very well, if it ends up being disruptive to learning, disruptive to a collegial environment with peers and with educators, then that's no longer a freedom of speech issue. That is inflammatory to a learning environment. And I think we need to make sure that we're protecting our educators and administrators from being able to make those judgments, trusting ourselves that if we disagree, we can have civil conversations with the people involved to address it. So again, I have very much concerns over the vague use of freedom of speech.
Excuse me for a second. I hate to cut in, but I'm looking at all the people who are testifying. They sign up for 3 minutes or 2 minutes, and we've gone well beyond the time here, and we are very tight with our schedule. So could you please wrap it up? And then I'm going to ask the remaining people to please hold to the time that they put down, please. Thank you.
I totally respect that. I do have to say this is my first time participating in front of the House. So thank you for showing me some grace with this being new to me. It also was very difficult to prepare a testament before hearing some of this dialogue. So I would just hope that maybe we take that into consideration in the future, that it's very hard to restrict the time and have a prepared testimony when I haven't heard some of the things that I'm reacting to. But I think the board gets it, and I'm happy to document this. I did not provide a written testimonial for exactly this reason. I wanted to hear some of the dialogue that was happening this morning. I would happily put a more concise written testimony to this to provide the host, the House afterward.
Thank you very much, Natalie.
Okay, thank you.
Are there questions? Not seeing any hands. Thank you very much. What I'd like to do is please remind those that are coming up to try and stay with the time that you specified on the sign-up sheet. Thank you.
Next, we have Sophia Vito again. Welcome to education. Yeah.
Hi, can you hear me?
Yes. Yes, we can.
All right. Thank you, Mr. Chair and members of the committee for taking my testimony today. My name is Sophia Biondolillo. I'm 14. I live in Manchester, and I'm speaking today on behalf of the New Hampshire High School Democrats in opposition to HB 257. And once again, I will keep this quick. The central issue with HB 257 is that it is entirely unnecessary. And I can say firmly that as a high schooler, I have never seen a teacher make a political stance during a class or try to advocate for any candidate or another. Teachers are professionals who want to improve the lives of their students and create a nurturing environment. They have no interest in making a space where students feel divided based on politics. Were there a teacher who is purposefully advocating for some political stance, there are already policies in place that deal with that type of conduct. Schools can handle this themselves, and the legislature doesn't need to impose a rule that schools are already enforcing. Second, as others have already said, promoting discussion is a central part of class engagement, and I think this language is dangerously close to prohibiting that. Consider a class like English or social studies. If, for example, a teacher has feedback on an essay where a student covers something political, would they not be allowed to instruct their students accordingly? Would that part of the curriculum be considered to violate the language in this bill? I think limiting what teachers can and cannot say could very quickly become overreaching and would interfere very directly with instruction. Finally, there's a section of the bill that clarifies that students have the right to free speech. Once again, this is just unnecessary. Students have been guaranteed the right to free speech multiple times before, and we don't need to restate it here. If there is selective censorship going on in schools, that's already illegal. There was a case that reached the Supreme Court in 1969, which concluded that if censorship does occur in a school, the school, I'm paraphrasing a little bit here, basically must be able to show that the censorship was justified by something other than the desire to avoid discomfort based on the unpopular opinion. So based on what I've heard from the sponsor, this bill is supposed to prevent that. So therefore, that type of censorship is already prohibited. As a legislative body, the state's responsibility is not to simply declare solutions to problems that don't exist. And I think our efforts would better be focused in other places where there is actual work to be done. So in conclusion, I don't think there's any real reason to support this bill, as it is just a solution seeking a problem. I ask the committee to vote inexpedient to legislate on HB 257, and I will send in my written testimony after the hearing is over.
Thank you very much, Sophia. Are there questions for Sophia? Not seeing, thank you very much.
Okay, next we have Brian Hopkins. Brian, you've been promoted. Go ahead and welcome to education.
Thank you, Mr. Chairman, members of the committee. Not sure what's going on with my camera here, but my name is Brian Hawkins. I'm here to testify in opposition to HB 257. I will be extremely brief because I think the last three speakers covered everything that I was going to mention. The questions around the lack of definitions and vagueness in this bill, particularly as it relates to what is a political doctrine, the fine line around advocating, and also, I think there, with respect to the issues that the sponsor brought up around electioneering, as Representative Lay mentioned earlier, I think that it is already covered in 659-44A around electioneering for public employees. And so I don't think with respect to that issue, this bill is necessary. So I'll just close my testimony there. One thing I will mention, people talked about time off. Obviously people have freedom of speech, and public employees in addition also have freedom of speech rights under 98E. And those have long been held as an important component to our statutes for freedom of speech for public employees. So I'll close my testimony there and let you move on with the hearing. If you have any questions, I'm happy to answer them.
Thank you very much, Brian. Representative Shaw?
Yes, Brian, who do you represent?
NEA New Hampshire.
Thank you.
Sorry if I didn't mention that at the top.
You might have, I missed it.
Thank you very much, Brian. Are there questions, Mr. Hawkins? Not seeing, thank you very much.
Thank you for your time.
Next, Eric Christina from the School Board Association.
Eric, you there?
I am. Thank you, Chairman Ladd. Thank you, members of the committee. I will be very brief. As Most of NHSBA's concerns with House Bill 257 have been addressed. Representative Woodcock, you mentioned, can a school board advocate for its budget or a bond or the collective bargaining agreement, because those issues appear on the warrant. Those were some of the concerns that NHSBA has. Specifically as it relates to collective bargaining agreements, school boards have obligations under RSA 273 to actively support passage of a collective bargaining agreement. So this may be in conflict with that. And certainly NHSBA believes school boards have a right under existing First Amendment law to advocate for their own budget initiatives, their own bond initiatives, things of that nature. And last, relative to paragraph 3 of the bill, where it speaks to freedom of the press, there's a Supreme Court case from, I believe, 1987 or 1988, commonly referred to now as the Hazelwood decision. In that decision, the United States Supreme Court ruled that if it's a school-sponsored publication, the school district has a right to maintain some editorial content over that. So while the speech within the article itself, it was protected speech. A student wrote an article about teen pregnancy. That's certainly protected speech, but the court said it's a school district newspaper, it's an extracurricular activity. The school district has the right to control the content within its own publication. So we think that that provision about students having unlimited freedom of the press would run contrary to current SCOTUS decisions and interpretations of the First Amendment. With that, I conclude my testimony. We're in opposition to the bill, and I'm happy to take any questions.
Thank you very much, Barrett. Are there any questions of the School Boards Association? Not seeing any hands. Thank you very much.
We have Charles Ladd from the Hampshire School Administrator. Go ahead, please.
Good morning again, Mr. Chairman, members of House Ed. For the record, my name is Carl Ladd, the Executive Director of the New Hampshire School Administrators Association. NHSAA is opposed to this legislation, I think primarily because it provides the opportunity for too many unintended consequences because the language is so overly broad and vague. As an administrator for many years, definitions matter because that is how we define our actions. So when a school board makes policy or when there is a statute, we look for the definition and the meaning behind the definition in order to be able to interpret that and then be able to enforce it. So very practically, my concerns are around some of the lack of definition of what a public school is. Representative Abrahamson said it was basically everybody who works in the public school. So that means the superintendent, the school board, the custodian, the food services worker, not just the teacher, which is what this seems to be aimed at. There's also no real clear definition of what campaign means. Does that mean if I'm campaigning as a superintendent, does that mean I'm calling people? Does that mean if I meet people at the transfer station, because as a superintendent, I'm never off the clock? So if I meet people at the transfer station and they ask me about the bond or the budget or the CBA that's coming up, that I can't talk to them about that and advocate for the board's position because I would then be campaigning for a measure that's on the warrant. I think that could have a really chilling effect, and I don't think that's the intention of the sponsor, but that could definitely be an unintended consequence dependent upon interpretation, which could then end up leading to lawsuits in order to define it, which is what the sponsor said would have to happen. So that means that if I'm campaigning at the transfer station answering questions, which I often did when I was a superintendent, that means we could end up in court in order to define that. That seems a bit of a stretch. So the other two parts of this, I think, have been addressed really well. I'm always concerned about the practical implications and the applications of what these proposed bills do. And so for those reasons, we're opposed to this legislation, and I'd be glad to answer any questions.
Thank you very much, Carl. Are there any questions of the School Administrators Association?
Ralph?
Yes, Representative Bone.
Thank you, Mr. Chairman. Thank you for the question. Do you think RSA 659:44A covers this anyway?
Thank you for the question, Representative Bohm. I don't have that RSA in front of me, so I would be hesitant to say yes or no, just because I don't have that one memorized.
It covers election year.
So I'm not sure whether it would or not. I'm not an attorney, so.
Thank you very much. All right. Are there any other questions for Dr. Ladd? Thank you.
Thank you, Mr. Chairman.
You're welcome. Are there any other folks that signed up or hands up? Yeah. Okay, with that, I'd like to close this hearing. And in reading the sheet for everybody which folks signed up on to testify or just to submit their position, we had, I want to read the right one here. This is one, you don't want to hear the other one. Okay, I got it. We got 4 in support, in opposition 92, neutral 0, and total to testify it'd be 7. Okay, with that, we'll close this hearing on HB 257. Now, we have 2 hearings left that are scheduled before lunch, and we're obviously not going to be able to accomplish that. So what I'm going to do is I'm going to go into the next one, but then hopefully we might be able to get through that. And then to open up 458 and then recess until following the last bill we have up today, 234. So we can get back on schedule following lunch. So with that, I'd like to open up HB 215 and hand the gavel over to Representative Cordelli.
Thank you, Mr. Chairman. So House Bill 215, enact permitting school districts to contract with independent schools and private schools. And I'll recognize Chairman Ladd for introduction of the bill.
Thank you very much, and I'll be very brief. I think this is first, for the record, my name is Rick Ladd. I'm a representative from Haverhill, New Hampshire. This is among several bills which are going to be coming forward during this session referencing private schools. In the past, we've referenced private schools, be it in the tuition contracts or be it for some other form of a contract as either sectarian or non-sectarian, but not both. And this bill right here, you can see that there's incorporation of independent school. Independent school, it's there just for reference. It's already defined elsewhere in statute very clearly. An independent school is one that has a board or trustees which are not elected, publicly elected. And we have several of those schools which our students in this state are attending. Pembroke and St. Johnsbury Academy are 2 of them. Then the other part, a literary institution, I've had our research people over in legislative services look up literary institution. There is no term, a definition for this term. In fact, it came about back in 1874, and it's kind of a holdover in our statutory language. I did have some information provided to me yesterday. There are no literary institutions in the state as of this point. However, there was an article that was appeared in one of the papers back in 1908 about the New Hampton Literary Institution, New Hampton, New Hampshire. And I'll just read this little article. It's advocating for the school. It's located in the foothills of the White Mountains near the center of New Hampshire. No saloons, billiard halls, or other temptations to wrongdoing. Co-educational, ambitious, and worthy students cordially solicited. 6 attractive courses of study. 1 classical with the use of a 4-year degree, school with Greek, classical without Greek, Latin, scientific, requirements of technical and scientific schools, English, scientific, academic, prepares for general life's work, and commercial. A few college preparatory schools are prepared to cover a field so broad, religious influence, cost very moderate. And full particulars upon application, that was by the principal back then, a man named Treston. That's the only thing we could find referencing this type of institution in our state. So it's the feeling that where it doesn't exist anymore, to scratch that from our statutory laws. The insertion of private school, though, is one which has been done in accordance with recent Supreme Court findings, Espinoza versus Montana, that occurred this previous year, and to allow public funds to be used to make contracts with religious schools, and the religious schools, it's my expectation we don't exclude religious schools from public benefits solely because of religious status. And that decision was made as the Supreme Court saw in violation of the free exercise clause of the federal Constitution, and it all goes back to the Blaine amendments. So throughout this country. So I'm looking to, in regard to what we have going on in our society today with this awful pandemic, you cannot even get your kid in or student in a private school now. They're all booked, they're loaded, including the church schools. Homeschooling is doubled, and parents are looking for these options, and they're not necessarily looking for a religious school, they're looking for a school that is in business and willing to accept their children so that they can take advantage of these months that are being lost in terms of many of the schools being closed many days during the week. So in conclusion, this is an effort to incorporate private schools as that can be contracted with by schools to receive students in the state. Thank you very much.
Mr. Chairman, any questions from the committee? Seeing none, next call on Ms. Jody Underwood.
Good afternoon, everybody. My name is Jody Underwood. I have just finished eating, so I apologize. I am Vice Chair of the Croydon School Board, and I'm representing myself today. I appreciate the opportunity to speak in favor of HB 215. My town was a defendant in the court case that ultimately led to the passage of the so-called Croydon Bill. I participated as the chair of the board, the school board. During that case, the presiding judge looked at the phrase, including but not limited to, in an RSA and interpreted it to mean limited to. But that experience taught me is that until the legislature reins in the judiciary's ability to redefine common English words to rationalize the outcomes it prefers, there's really not much point in fussing over the words of statutes. But if we're going to fuss over words, it would be a mistake to take a phrase, well, like literary institution or something more general, to speak to Representative Ladd's point, that was clear until the court decided to arbitrarily interpret it to exclude private schools and replace it with a phrase that would exclude everything but schools. Because as the past year has demonstrated vividly, having alternatives to the traditional schooling model is essential to the resilience of our society. So if there's still a chance to amend the bill, I would add private and independent schools, to be clear, because that was the intention, but it ends with a more general phrase, again, probably not literary institutions, but to keep it in the general sense that's intended by this RSA. Thank you.
Thank you, Ms. Underwood. Any questions from the committee? Representative Ellison, did you have a question previously?
Yes, I do, and I apologize. It's for Representative Ladd, and I couldn't get my hand up soon enough. Just a clarification, Representative Ladd. I think I need a clarification. You're saying that under the determination of private school, or the definition of private school, that would include religious institutions. And therefore, under the bill as written, a local school district could write a contract with a religious school, and local school educational money would be used to fund that. Is that permissible under this?
That's correct.
Thank you.
Thank you very much.
Next we have Mayor Christina, but unless people have questions, I will see.
Mr. Christina, you're up.
Thank you very much, Chairman Cordelli, members of the committee, Barrett Christina, New Hampshire School Boards Association, opposed to House Bill 215. I guess one of our questions is, why is this necessary? I don't understand what this clarifies. I certainly don't understand why it needs to be added to RSA 194:22. We have Senate Bill 8, the Croydon bill that was referred to, found in RSA 193.3. That may or may not cover this issue. I'm not going to get into a conversation about the Espinoza decision. This bill in absolutely no way addresses the Espinoza decision or what the Supreme Court said about privatization and voucher programs. So I oppose the bill. We oppose the bill because I don't understand what it does or what the intent does. And I think there may already be coverage in RSA 193.3 paragraph 6 and the subsequent provisions thereafter. So that's the scope of my testimony. I'm happy to take any questions.
Thank you. Questions from the committee? Seeing none. Thank you very much for the testimony.
Thank you very much, Mr. Chair.
And the last person to testify, it looks like, is Dr. Ladd.
Good morning again. Thank you very much, Chairman Cordelli and members of House Ed, for taking my testimony on HB 215. NHSAA is opposed to this legislation primarily because, once again, it doesn't provide for transparency and fiscal accountability that should exist in the distribution of public funds. We've witnessed recently with a specific charter school within New Hampshire significant issues that can arise without a strong fiscal reporting and monitoring accountability system in place. In that particular instance, there was over $150,000 in misused taxpayer funds, as reported by the DOE. That resulted in the rescission of the school's charter and left over 40 students and their families scrambling to provide an alternative education. That was due to poor oversight and lack of accountability. Private schools, independent schools, especially those in other states, are not responsible in any way to the local taxpayers who are funding those proposed contracts. There's no level of direct accountability in the way of publicly available policies, procedures, requirements, except whatever they provide. NHSAA really views this as just another attempt to divert public taxpayer funds to private and independent schools who operate under significantly different rules. If public schools are held to a high level of accountability because they accept public funds, then so should private and independent schools. So we really respectfully request that you vote this as inexpedient to legislate. Thank you very much.
Thank you for the testimony. Representative Bowman.
Yeah, thank you, Mr. Chairman. Thank you for taking the question. In the case of a school district saying we want to send X number of kids to this private school, don't the voters in that district have the final say as to where their money is going?
They very well may. Depends on the contract language. It is up to the local taxpayers in order to enter into any kind of a contract. I think the concern really is about where that fine level of accountability goes to, and whether or not those schools have to follow the same rules that public schools do. We just spent a great deal of time talking about HB 140. If this goes into effect, does that mean that these private and independent schools are going to be held to that private right of action like public schools will be, even though they're accepting public school funds? I just think that if we're going to make these rules, they should be applicable to everyone who accepts public funds, not just the chosen few.
Thank you. I think Representative Myler.
Thank you, Mr. Chairman. Dr. Ladd, do you know how special ed funds or services or IDEA compliance relates to this particular proposal?
Thank you for the question, Representative Myler. My understanding is that if a student receives special education, they very well may or may not be able to participate in this private school that they've reached a contract with, which could then exclude them. I do know when I was the superintendent in Monroe, and we sent our students to St. Johnsbury Academy, some students went there, some students went to Woodsville High School, that parents of special education students were discouraged from attending St. Johnsbury Academy at the time, and most of them ended up going to Woodsville High School. So I think that there is some cautionary notes around this proposed legislation regarding students with special needs.
Thank you.
Thank you very much. Any further questions? Seeing none.
Thank you, Mr. Chairman.
Thank you. We will close the hearing on House Bill 215. And we will break for lunch. No, I'm sorry. No, not yet.
No. Okay, so we just, did you have the number of people that
Yes, I'm sorry.
testified?
Yes, there was 3 supporting, 73 opposed, and 3 testifying.
Okay, and so that hearing is closed now. I'm going to open up HB 458. This is a bill relative to the provision of menstrual products for students in need. And I'm going to recess the hearing to take place following the last afternoon hearing, HB 234.
Chairman, I think someone who was going to testify was wondering who could go first. I don't know.
When we do it.
Okay.
We're not going to have anybody testifying on behalf of the bill at this point in time. So with that, we will recess that bill to follow 234 this afternoon, likely to be somewhere around 3:30 thereabouts. So with that, we're going to break for our lunch right now and reconvene at 12:45. Thanks. It's available. Yeah, we still need.
Mr. Chair?
Yes.
I have a point of order, I think. It deals with the recessing of 4:58. I think if you recess, don't you have to repost it in the calendar? I mean, I recall last year we did that and we had to do it. I mean, the problem is you've got people in the queue who have wanted to, who want to testify on this. And you're now saying, well, wait, we're going to have to do it later in the day. I think procedurally, if you recess it, you have to repost it. So it's a question. It's a question of the chair around procedure on this thing. Why wouldn't we just go ahead and do three? If we just go ahead, then you wouldn't have to recess it.
That's true. We could put that right in now. And this,
I'm just conscious of those who are, who
Yeah.
are in the queue and have waited for this. So that's all.
past, we have, I don't know, recess, the word, we've opened it up and then taken a break and come back. And I know there's some bills we have actually done what I suggested to do, but I'm all for just going right on rather than putting it off. Let's go ahead and address it right now and just keep marching down through our agenda.
Good. Thank you, Mr. Chair.
Point of information, Mr. Chair.
Yes.
My only concern here is that you did actually recess the hearing and indicate that it would be done later this afternoon, which may have caused people to already drop off the.
Yeah, see, and I did recess it, and I did give it a time approximately like 3:30. I recall saying that. Yes. So I think there's nothing that's been, I recessed it to that time, and it's today at approximately 3:30.
No, but the point of order, Mr. Chair, I think it has to be posted for public notice following a recess. And I think that's what Representative Myler was talking about.
You control the time. All the bills have been posted. You control the time for the whole day.
I will just call the clerk. So I just texted him.
Are you checking with the clerk, Rick?
Yes, I am.
Okay, thank you.
Easier than when I worked in Boston, it's right at the base of the building. Salad.
It's all there.
I wasn't.
Representative Ladd, Chair of Education.
So I wanted to check. It is over Point Eddie Plaza, just as you're entering in, where it used to be Boston Market, right? It's been on the headlight. Is it still there?
I don't know. I haven't changed everything.
Yeah.
Anyway.
It's the same thing that it's been since 97 or earlier. Really? I guess part of it too is if you're gonna go out, especially when the prices are going up, you might as well go to some local.
Fast food places.
Yeah. Oh, fantastic options. Yeah. It's hard. You can't do that.
Okay, for the committee out there, I did contact the Paul Smith's office, talked with him. That's the clerk. And he is, the process which we took is appropriate. It's been done before. In other words, I opened it up, I recessed it to follow 2:34 and set a time approximately 3:30. The other process is also acceptable, where you just put it off till after lunch and you keep marching down through. But because I did announce that I'd be doing it this afternoon at approximately 3:30 after I opened it up, that's the one we have to stay with.
Okay, thank you, Mr. Chair, for the clarification.
Okay, good. So what we're going to do now is we're going to continue on our schedule that we're a little bit behind on here now with 401. This is a bill relative to the duty of school superintendents regarding criminal history records checks. Who's trying to stop on that motion? Representative Mullen, that's right. Welcome, Representative Mullen.
Thank you very much, Mr. Chair, and I just want you to know how happy Lieutenant Mike McQuaid from the Department of Safety and Attorney Diana Fenton from the Department of Education are that you stuck with 401 right now, because I know they're out there and some of them might even be on vacation this week. So thank you for having me in today, and I will begin and I will be brief. House Bill 401 actually began its life as House Bill 1136 last session. It is a bill that is to give the authority to appoint a designee to the superintendent of each school district to assist with criminal background record history checks. And it went through with strong bipartisan support last time around, but it died a COVID when everything went sideways last March. So it is back to you today in a new improved form. And I just want to go over with you a little bit about the intent of the bill and the amendment that I sent out yesterday. I apologize for this. I just want to reassure you it's not COVID, it's an allergy. So 401 would grant the superintendent the ability to appoint as a designee specific people within the supervisory union to act either in his or her stead or in addition to. We heard testimony last time that the bill came before us about situations that might require a superintendent to need help, ranging from what would happen if a superintendent became ill or needed surgery and was out of commission and was the only person that could review criminal history checks. How would that impede hiring in a timely fashion? We heard about things like superintendents being on vacation and last minute resignations coming in over the summer, and school districts being unable to hire people because they did not have the superintendent on site. We heard about the fact that the size of a school district greatly affects whether or not this is a one-person job, or it could in fact require more than one person to manage the number of cases that were being investigated for potential employment. So HB 401 seeks to give the superintendent that authority. Subsequent to 1136, which was Representative Eisner's bill the last time, last session, House Bill 1558 made changes to 189.13a, which is the criminal history statute, and broadened the scope So in conversation with the Department of Education, specifically Attorney Diana Fenton, we discussed the need for expanding training for superintendents and now potentially their designees to learn how to read and interpret the information that was going to be put in front of them, because 1558 actually allowed FBI checks to happen. And so the scope of the criminal history check became larger. Originally, Attorney Fenton and I thought that this training was going to be done with conjunction with the Department of Safety. But the Department of Safety, having the bill already been drafted, came to both Attorney Fenton and myself and talked about their belief that the training best lies in the hands of the Department of Education. And so the amendment that came to you over the weekend simply removes the Department of Safety from the training process and puts it squarely back into the hands of the Department of Education. And Attorney Fenton and Lieutenant McQuaid are both in attendance today to speak to the various aspects of the bill. I am happy to answer any questions that anybody would have, and I would now turn it back over to you.
Thank you very much, Representative Mullen. Representative Likas, do you have a question?
Yes, I do. Thank you, Representative Mullen, for answering my question. It has to do, remember last time when we did this, the Department of Safety said that because of some FBI rules and whatever, that we couldn't have a designee. Have you since talked to them and figured out?
I have. What they were initially objecting to was just the term designee. Subsequent to that, to what we did the last time around, what they were actually looking for were specific people to be designees. And so if you look at the bill, the designees are the assistant superintendent, the head of personnel, the director of human resources. They're out in the bill. And I'd love to be able to tell you which line they're on, but I can't see it at the moment.
11.
Oh, 11. Hello, in the bolded print. Yeah. So head of human resources, personnel director, the business administrator, the finance director. Some of those people seem, I don't know, perhaps a little odd. You know, why would the finance director be the alternate to looking at criminal history checks? But in some of the smaller districts, they don't have people to fill the positions, the other positions that are listed. And so what we tried to do was look at the makeup of a variety of districts and sizes and determine, okay, who would be a person that would be able to be a second in a district? Hence the finance director, the business administrator.
Thank you very much, Representative Mullen.
I think Representative Likas has a follow-up.
Go ahead.
Thank you.
You're welcome.
So the safety people were fine with the wording the way it is now?
Yes, and they will be up. They're in attendance today, so you'll get an opportunity to ask them any additional questions.
Thank you very much.
You're welcome.
Thank you very much, Representative. I'm not seeing anybody opposed to this bill. I think everybody's seeing it as pretty much supportive. That's my looking around the room here. I'm assuming that everybody else is. So I'm going to go ahead, but I ask that folks that are testifying try to, keep it short, and perhaps we could exec this bill at the same time. Representative Woodcock.
Thank you, Mr. Chair. Representative Mullen, thank you for taking my question. As I read through this, I'm trying to determine if each district is allowed a singular designee or multiple designees. I couldn't pick that up, Sue.
I don't think that I don't think it's spelled out in the bill, Representative Woodcock. I would like to say that's on purpose. It's not. But I would think that it would be up to the superintendent whether or not they felt that if they had 400 criminal record checks that were sitting on their desks, then perhaps they would designate human resources and personnel.
Okay, all right.
But
Thank you. Yep. Okay, thank you.
Further questions?
Thank you.
Representative Mullen. Okay, are there any further people to question? Okay, we'll go on to the next person's testifying. Mary Eisner.
Hello, can you hear me?
Yes.
Thank you, Mr. Chairman. Good afternoon, committee members. My name is Mary Eisner. I'm from Derry, New Hampshire. HB 401 is being introduced from HB 1136, which was passed by this committee and by the House in the last session, but due to the impact of COVID-19 was laid on the table by the Senate, which Representative Mullen has previously stated. Currently, only superintendents are allowed to process criminal records in the application process. This bill specifies who the superintendents may choose as a designee: the assistant superintendent, head of human resources, personnel director, business administrator, or finance director. By allowing a designee to process criminal history records, it relieves superintendents from this employment application function. By statute, superintendents have 20 educational responsibilities to perform. Providing adequate staffing for school districts is an ongoing process throughout the year. Derry is the third largest school district in the state. Derry School District had approximately 886 employees from July 1st through October 17th of 2019. 192 records were requested. As of 2020, the Human Resources Office fingerprinted approximately 178 people with 605 employees, not counting substitutes. Once records are received and reviewed, and there may be a question or concern, additional time is needed by superintendents to follow up on interviews, in most cases requiring numerous contact attempts to schedule interviews. By allowing superintendents to appoint a designee to perform the criminal background checks in the employment application process is in the best interest of our school districts and would allow superintendents to perform their main responsibility by educating our children. This bill considers the time factor involved in normal times for superintendents to process criminal background checks. If there are any doubts about the importance of this bill, we need only be reminded of how much time that all school administrators have invested this past year and will continue to do so because of COVID-19 in order to keep our schools safe and our educational system functioning. Recent reporting projects that we will not be back to our normal lives until the summer or fall. Given the ongoing impact of this pandemic and any similar issues that may occur in the future, this bill certainly would be a welcome benefit to our school superintendents and to our educational system. Therefore, I encourage this committee to approve this bill. Thank you for your time. And I'm open to any questions.
Are there any questions? Not seeing any. Thank you very much.
Thank you.
How many more
We
speakers?
just have, well, we did have, Mr. Dr. Lau.
Are you out there?
We do have two hands raised.
If those are just technical support, I think we're good.
Sorry, I don't know if okay, then, I guess that's.
I see state police still got their hands up.
Would you like to do it?
Lieutenant McQuaid, are you there?
Moment, Lieutenant McQuaid.
Can everybody hear me?
Yes, we can.
Okay, I'm sorry about that. I tried to log in as testifying, but for some reason it wouldn't allow me. I don't really have anything additional to add from Representative Mullins' testimony. The only thing is I just want to make myself available if anybody has any questions. And regarding the language to the FBI, nobody really truly knows what the FBI is going to approve. This is the best laid plan to go forward to get this legislation approved. And we believe that as far as a designee outlining the parameters of who would be included into that designee pool will push this legislation through to approval with the FBI.
Thank you very much. Are there any questions for the lieutenant? Thank you very much. With that, I'm going to close this hearing. We had 67 in support, 1 opposed, 1 neutral, and several testifying here. I'd like to close the hearing and go right into executive session. So this hearing is closed. I'd like to recognize Representative Bohm for a motion on the amendment, which is 0148.
Thank you, Mr. Chair. I make a motion to author pass on that amendment.
And Representative Mullen,
For
do you have a
HB4.
second?
I'll second it.
Mullen has a second. So we have a motion on the floor to approve 0148H made by Representative Bohm and second by Representative Mullen. Further discussion? With that, I'd ask that Representative Shaw please call the roll.
Representative Cordelli,
Yes.
Representative Bohm,
Yes.
Representative Allard,
Yes.
Representative Lakis,
Yes.
Representative Moffett,
Yes.
Representative Hobson,
Yes.
Representative Andrus,
Yes.
Representative Ford,
Yes.
Representative Leon,
Yes.
Representative Sodi,
Yes.
Representative Myler,
Yes.
Representative Luno,
Yes.
Representative Shaw, yes. Representative Cornell,
Yes.
Representative Tanner,
Representative Tanner is at a doctor's appointment and will be back later this afternoon.
okay. Representative Ellison,
Yes.
Representative Mullen,
Yes.
thank you.
No volume?
Representative Lay,
Yes.
Representative Woodcock,
Yes.
Representative Ladd,
Yes.
19-0.
Representative Bohm, do you have a motion?
Yes, Mr. Chairman, I make a motion to author pass as amended on House Bill 401.
Is there a second, Representative Mullen?
I'll second it.
Thank you very much. So we have a motion made to approve HB 401 as amended with 0148H. Any further discussion? Representative Shaw?
Representative Cordelli,
Yes.
Representative Bohm,
Yes.
Representative Allard,
Yes.
Representative Lakis,
Yes.
Representative Moffett,
Yes.
Representative Hobson,
Yes.
Representative Andrus,
Yes.
Representative Ford,
Yes.
Representative Leon,
Yes.
Representative Sodi,
Yes.
Representative Myler,
Yes.
Representative Luno,
Yes.
Representative Shaw, yes. Representative Cornell,
Yes.
Representative Ellison,
Yes.
Representative Mullen,
Yes.
Representative Lay,
Yes.
Representative Woodcock,
Yes.
Representative Ladd,
Yes.
19-0. Consent,
Yes, Deb.
Yes. Consent, yes.
thank you.
I want to thank Representative Mullen for all that work, bringing forth HB 1136, which we had previously, that got messed up last year. I think Representative Mullen, we're sending forward even a better bill with what you've done with the amendment. Thank you very much. Okay, we are a couple minutes out of doing the next bill here. You get a drink of water or something, we'll start right at 1:15 for the next bill, which would be 321. Representative Moffett, that's your bill. Okay, you ready? But don't, not yet.
Can you tell me Lieutenant McQuaid's first name?
Lieutenant.
Yes, it's Michael.
Thank you. I
You're
thought it was,
welcome.
but I wasn't positive. I just wanted to make sure. Thank you.
You're welcome.
We always refer to lieutenants as LT.
I know. What time is it, Jeff?
Water. Then I have to.
Want to accept the rest of this today or what?
Just reading. They don't think so. They're only a couple. We've done that way already. Doesn't it? Yes, it does.
Okay, it's now 1:15. We're ready to go ahead with the next hearing, which is going to be HB 321, requiring school districts to submit an annual report concerning gifted students. Prime sponsor of this bill is Representative Moffett. Representative Moffett, are you ready to present?
Yes, Mr. Chairman. And thank you, Mr. Chairman. For the record, I am Mike Moffett, State Representative for Merrimack District 9, which does include the towns of Canterbury and Loudon. Okay, this measure very simply calls for a best practices folder of sorts, or a virtual folder at DOE, Department of Education, for districts to simply share policies or initiatives that address the unique needs of so-called gifted students. There is no policy mandate, there is no spending requirement, and there is no expectation that anyone process or analyze data or information unless they wanted to. It very simply just involves a best practices folder to facilitate the sharing of ideas and approaches, and also to perhaps raise some awareness in this area. This was first introduced a couple of terms ago. One rep looked at it and said, this just sets up a folder. It should probably go on a consent calendar. but it did not. So, and why did it not? And the answer lies in our legislative committee process and how we properly do due diligence, and we ask questions and we scrutinize and sometimes over scrutinize every aspect or possible consequence of a bill. And this process is useful in preventing bad bills from moving forward, which I think we're pretty good at, I hope. But I think that occasionally overthinking or over scrutinizing prevents good bills from moving forward, like I think is the case here. During the exec session 3 years ago, considerable time was spent discussing the issue of defining what may constitute a gifted student. So this bill intentionally describes gifted only in the broadest terms, preferring to let local districts properly decide what they feel constitutes gifted, as opposed to having a prescriptive definition imposed upon them. It also concerns about imposing a new reporting requirement. But again, all this measure involves is simply mailing or emailing a message with appropriate attachments, if there are any, simply just describing existing policies or initiatives regarding gifted students, if there are any. The requirement pretty much can be satisfied in a minute or so with an email with a link or an attachment, just sharing what is in place, if anything is in place. And sadly, I think because so many districts do little or in some cases nothing in this area, the message would simply say, I think in too many cases, we currently have no programs or initiatives regarding gifted students. Going back 3 years, another concern back then was about imposing another administrative requirement on DOE. And back then, I did talk to some folks at DOE. In fact, I talked to one just earlier this week. There is no expectation, the intent of this measure does not ask or expect the DOE do anything other than simply maintain the information so someone can access it if they wanted to. In the best practices folder, virtual or otherwise. There's no requirement for analysis, there's no requirement really for anything, unless they wanted to, in which case DOE would have some material to process if there was some interest in doing so. Again, 3 years ago, speaking to several DOE people, I sensed some of them were intrigued and even excited about this measure. And yet another fair question that came up the last time around involved the notion that this folder could be requested or set up via DOE or some other organization or professional association as opposed to the legislature. And the response to that is that we feel this is such a neglected area that is so important that it needs the imprimatur of legislative statute to underscore how seriously we take the problem of a vastly underserved school population. Sending a request for paperwork from some administrative office is one thing that's easily ignored, but passing a statute shows that people are paying attention and they take this properly seriously. And that's why there's so many people tuning into this hearing, or at least tracking this bill's progress, and why there's probably some press accounts and widespread interest in what, if anything, flows forth from here. Again, going back 3 years, Jennifer Ford very wonderfully helped me to research what other states do in this area. And as I said then, and I'll say now, New Hampshire is arguably one of the worst states, some might even say the worst state in the country in terms of what we do in terms of gifted students. I said back then that even Mississippi has more to show in this area than we did. And I know Mississippi gets a bad rap. I've never been there. Nothing against Mississippi, but I just say that because looking at what Mississippi did, they had special schools in place. They had a lot of cool stuff that we don't. So anyway, the 2018, I thought we had a little bit of paralysis by analysis, and so this proposal was sent or referred to interim study. The chair set up a 7-person interim study committee. Representative Shaw chaired it. I was on it, and we met several times that summer and thoroughly discussed all the above issues and others. And then the interim study committee overwhelmingly voted to recommend future OTP. And some of you will recall in September of 2018, this full committee did have a meeting, and we discussed the interim study recommendation of OTP. And I always remember Representative Shaw making the motion, Representative Mary Giles seconding it. And I will always remember Representative Myler looking at me for a moment and then smiling and voting OTP as well. And then the full committee recommendation is for OTP. However, this was September of 2018, and it was there was a new session coming up, and there was no action to be taken then. And as you probably all know, I was not a member of the subsequent legislature, as the voters in their wisdom opted to give me a hiatus. So I really don't know what happened last session in terms of this bill, which had already been approved by interim study and by the full committee. So anyway, I hope we'll give it a good look this time around. And I'll also say it was obviously and is a very bipartisan bill. My good friend Senator Lou D'Alessandro was a co-sponsor then and now. And as I mentioned, my Democrat friends on this committee were quite supportive. And God bless those who had questions back then that hopefully have been answered by now. So anyway, we're hoping this moves forward this time around. Again, with no policy requirements, no spending requirements, next to no administrative expectations. What this bill would do would be to facilitate some local conversations and discussions about how to better serve a long neglected but very real and substantive student population. Now, these local discussions that we hope will flow from this may not always be comfortable in some places, but we think they're overdue, and we think that wonderful things could flow from this at basically no cost. And finally, as a product and advocate for public education, I and others see this as another little measure that can help increase support for public education. So here we are back with the gifted students proposal, and I'd be happy to take any questions.
Thank you very much, Representative Moffitt. Are there questions for the representative? No questions? You don't let them skate?
I have a question.
Representative Hobson.
This might seem obvious. Thank you for taking my question and thank you for allowing me to ask it. So would you surmise that allowing programs for gifted students might be more attractive to those that might want to draw their children out of public school? Is that kind of what the intention of the bill is?
Thank you for your question, Representative. I hadn't really thought about that. It wasn't particularly the intent of the bill to have that effect. Some may see that as a side effect. I hadn't really thought about that, but I think that it could be a positive byproduct for just shining a light on this.
Thank you.
Representative Moffitt, I do have one question for you. Is there going to be any guideline or anything sent out from the department regarding if you're going to be asking for gifted, including gifted as athletics and academics, is there going to be a breakdown in terms of how people report that? The gifted student sometimes is seen as the student has the intelligence, the achievement, those more academic oriented side, and then the talented side is those which are like the athletics, the basketball player, the high jumper, the person in the theater, the artistic. So is there any guidelines going to be provided in these districts so that we're getting information reported back that's somewhat able to be collated into a final report?
Thank you for your question, Mr. Chair. I think that question just might go back to the point I made about overthinking. Again, we try to keep this as clean and simple as possible. The format of the report is totally at the discretion of the reporting district. So there is no specific format. It does mention 3 different areas, academic, artistic, and athletic, that could be potential areas for gifted students to get attention. But that is totally up to the district. So whatever the districts opt to send, they can format it any way that they want. So there is no reporting format by design. You just want to give them a chance to share whatever they want to share.
So I'd like to follow up with just, so in the line, I don't have numbers on my page, but where it says in this section, gifted student means, should we be saying gifted and talented student?
Thank you for your question. And I know this came up last time around, and I think this was back then, and now is kind of the case of getting down into the weeds a little bit. I know some folks see a distinction between gifted versus talented, and you could make that distinction. But again, this is something we would like the districts to think about in terms of if they want to broaden their response to some description of what they think would be talented. That's totally a local decision. We're just asking them to share whatever they want to share if they have anything to share.
Thank you very much, Representative. Are there further questions for Representative Moffett? Yes, Representative Myler.
Thank you, Mr. Chair. And thank you, Representative Moffett, for taking my question. The concern that I have with this is that because you want to have it fairly open-ended, what kind of data do you expect to gather from this? And who at the department will monitor the receipt of this information? And how might the department use this information? So there are really three questions there.
Okay, thank you for your question, Representative. So remember, the first question had to do with the data. Just remind me how you phrased the first.
Just what type of data do you expect to get from a school district?
Thank you for that question. Don't know. That's why we're asking. Very simply, we're looking to, as I explained, simply set up I hate to say clearinghouse, but just a place, a central place where programs or initiatives or approaches regarding that are done locally for gifted students could be in a place where others could access them and look at them. As a quick example, when I taught at Trinity High School, they had a math club and a math team. Now that might be an example of something that was in place way back then at Trinity for students who either liked or were gifted in math. So if that was sent to the folder, that would be a simple example of something that the people who want to look into this could see what's out there being done. Not looking for any specific, as I said to the chairman, we don't have a format for requesting data. We just giving folks a chance to share what they have. Regarding DOE, and I have had some communication with them then and now, it made it clear to them that we, or those of us, the sponsors, certainly have no expectation that they analyze or process this information other than to have it basically in a folder. So if somebody wanted to see what's out there, that they could go through the folder and on their own see what's there. Now, as I said earlier, if DOE or if some other entity wanted to do some research or collate or organize some of this information, then it would be there in a convenient place. But there is no expectation for DOE or requirement for them to do anything other than just receive it and put it in the folder.
Thank you.
Any further questions? Thank you very much. Thank you very much, Mr. Representative Moffett. The next person is it Carl Ladd? Oh, wait a minute.
Have a question of the for the attendees. I'm sorry, Andrew Fairfield. I don't see. There she is.
Can you hear me?
Yeah.
Are you able to hear me?
Yes, we are.
Okay, great.
So good afternoon. My name is Anne Marie Banfield, and I'm an advocate for parental rights and academic excellence in education. I am here to testify in support of HB 321. I ask you to bear with me as I go through this because I think that where I'm coming from might be very different from where the sponsor's coming from. And I'm going to touch on some of the reasons why I support this bill, but it may be not in his intention. This bill requires all public schools to submit annual reports to the Department of Education. There is a new focus on educational equity, but there is a difference between equity and equality as it relates to education reform. Equality was considered a good thing until recently. Equality means treating people the same. Equity, by contrast, means elevating some groups of people so that the outcomes are equal. That may sound okay, but I think it's important to look at how this is playing out in the public schools. So looking for ways to elevate students who've been marginalized in the past in an effort to make sure that those opportunities are available provides equality of opportunities. Compare this to eliminating gifted programs so that all students are performing at the same level. This would still deny marginalized students opportunities, but now there is equity in outcomes. So I want to go back to the Massachusetts Miracle, which is a good example of equality for all students, the marginalized included. Pre-Common Core, the Massachusetts Department of Education focused on improving academic outcomes and targeting marginalized students in order to improve their opportunities. Under the current model, where competency-based education is introduced, the focus becomes on closing the achievement gap. We are seeing this played out by bringing the top down in order to achieve equity in outcomes. We've achieved equity by taking away opportunities for the gifted children instead of focusing on helping to elevate the marginalized students to gifted levels so that they can achieve the success that their peers have achieved in the past. This was a topic that Dr. Sandra Stotsky spoke about when she addressed the State Board of Education in New Hampshire several years ago. She was the Senior Associate Commissioner of the Massachusetts Department of Education from 1999 to 2003. While there, she directed complete revisions of the state's pre-K to 12 standards of every major subject. This has been judged to be amongst the best in the country by independent experts. On the 2005, 7, 9, 11, and 13 tests given by NAEP, Massachusetts students had the highest average scores in grades 4 and 8 in both mathematics and reading. The scores of the state's low-income students compared to those in other states on NAEPs, the 7000 tests, were tied for first place in grades 4 and 8 mathematics and in grade 4 reading. In grade 8 reading, they were tied for second place. The Massachusetts Miracle included drafting the best academic standards in the country, a focus on academic content and professional development, choice in educational options, and tutoring for students who needed extra help. Since 2010 and the adoption of Common Core, states have moved away from this proven model. That has directly impacted opportunities for all students who strive for gifted programs. I'm going to send you a copy of this written testimony with actual graphs that show how proficiency levels have declined. The University of Connecticut education professor, Jonathan Plucker, criticized school districts for using the Common Core standards in order to cut funding for gifted and advanced students in education. He said, "We found plenty of evidence that many districts are using the implementation of Common Core to cut services to advanced students. This is when we began to see a real effort to eliminate equality for all students and focus instead on equity of outcomes." This is what the National Association for Gifted Children had to say about Common Core state standards. Despite the obvious connection to the field of gifted education, the nature of advanced work beyond the Common Core is not addressed. In fact, the authors of Common Core state, these standards do not define the nature of advanced work for students who meet the standards prior to the end of high school. Although the Common Core are considered to be more rigorous than most current states, they fall short in meeting specific needs of gifted learners, and if strictly held to the standard, could actually limit learning. So what did this look like in Indiana? The gifted program is to follow on grade level with Common Core. That ensures that nothing special will occur for students who are gifted, even though the document goes on to say that students will get enrichment activities. It really implies that children will get the same activities. That's equity of outcomes versus removing barriers and offering extra help to the student who has been marginalized. For those of you who are interested in improving public schools, these are the discussions and debates that need to take place, providing the direct help to marginalized students so their opportunity for success is available. Why is it our NAEP scores have remained stagnant or have declined since the implementation of Common Core in 2010? The Massachusetts Department of Education under new leadership abandoned the reforms that elevated all of their students and public schools. The results are shockingly dismal. But I suppose if you are looking for equity, they are now all underperforming compared to what they were achieving prior to the adoption of Common Core and competency-based education. So who in New Hampshire is talking about this? Who has noted this problem and worked towards making improvements? How much was invested in our public schools since 2010 to align the curriculum to Common Core standards? When will we finally start talking about how to elevate public education in New Hampshire instead of settling for mediocrity? These are the discussions parents are desperate to hear about because parents do care about their child's education and they care about their public schools. The first, and I'm just about done, the first step is to see what local schools are doing to elevate these opportunities for all children, marginalized students included, not by lowering the bar, but by offering real opportunities to improve the academic content. So for these reasons, I urge you to vote ought to pass on 321. Thank you for taking my testimony.
Thank you very much, Ms. Banfield. Are there any questions for Ms. Banfield? I don't see any hands up, nor here. Thank you very much, Marie. Okay, do we have any others in the queue? Jerry Fruit, okay, from the School Administrators Association.
Okay, Mr. Crew, you've been promoted to panelist. Go ahead, please.
Can you hear us, Jerry?
Oh, yes, I can. Can you hear me okay?
Yes, we got you.
Thank you, Mr. Chairman Ladd, members of the House Education Committee. Thanks for taking our testimony regarding HB 321. We certainly appreciate the intent of the sponsors of this legislation, and we have some significant concerns regarding how this would be enacted practically. And the most glaring issue with this proposed legislation is the lack of a clear definition of gifted and talented. And without that definition, there really is no way to gather the data with any validity. With 167 school districts and 1,800 public and private schools in New Hampshire, it's just not inconceivable to think that there would be hundreds of definitions of what constitutes a gifted and talented student. We appreciate the sponsors' concern and opportunity for the gathering of the information and placed in a file with the DOE. And honestly, there's nothing prohibiting that from taking place now. That could be a great tool for utilization for districts who are interested in participating and accessing that data. With no clear definition, each district or school determining its own definition, the data collected for statewide reporting would just be anecdotal at best and couldn't really be used in any good way to determine what programs, resources, or accessibility actually exist for students. It seems unclear as to how this data will be collected, analyzed, and disseminated. And what's the purpose of the data collection? And if we're not going to provide statewide assistance for developing, staffing, and maintaining such programs at the local level, then it would seem to have not much purpose at all. Those who have been around for a while may recall once upon a time, the state had a gifted and talented coordinator and was extremely involved and supportive in developing gifted and talented programs in the schools. And we might submit that thinking around something around that vein might be more beneficial to the schools as well. We'd respectfully request that you retain HB 321 to further define and qualify the terminology and expectations of the proposed legislation. We would be happy and be prepared to assist you in any way that you feel appropriate. It is an important consideration to provide gifted and talented opportunities, and we certainly would welcome the opportunity to be a part of those discussions moving forward. With that, I would thank you for taking this testimony. And Mr. Chairman, I know that there's a burning question in your mind, wondering whether I get the top bunk or the bottom bunk. And when I'm a good boy, I get the top bunk. And when I'm a bad boy, I get the bottom bunk. So I just wanted to put that to rest, Mr. Chairman. Thank you for taking my testimony this afternoon.
Very much, Jerry. Are there any questions for the School Administrators Association? So I have one for you, Jerry. You referenced what we once had here in the state, and I unfortunately was not here at that time. I was administrator up in another state. Was our gifted program back then part of the special ed program under that umbrella? Or was it a program which was separate and apart and funded through a different stream of money?
Thank you for that question, Mr. Chairman. I do believe it was a separate program funded in the Department of Education. I recall, and those of you that may have been around for a while, Mr. Ellison perhaps may remember Michelle Munson was the person who was responsible for the Gifted and Talented program and did an excellent job working with school districts to provide that support.
And may I have a follow-up with you, please? You speak of gifted and talented, whereas this report just says gifted students. And I understand Representative Moffat's rationale behind saying only gifted students. He's trying to keep it wide open. But do you see the talented situation, talented side of this as separate and apart from gifted? And if so, how do we assess the talented student?
Thank you for that question, Mr. Chairman. And I think that begs the very opportunity that we talk of in terms of retaining this piece of legislation and working through those very questions, because I do think there's great merit in identifying the talented and gifted components of what so many kids have to offer their communities and the community at large.
Thank you. Are there further questions for Mr. Frew? Not seeing any. Thank you very much.
Thank you, Mr. Chairman.
Is there anybody else in the queue or as attendees? Or? Okay, on this bill, we had 11 or 12, I would say, including the sponsors, supporting, and 11 opposed, and 1 neutral. And so that was for HB 321. With that, I will close that hearing, and we will move on in a minute here to the next bill. Thank you. Oh, it's 2:15. So we think. For the committee, the schedule indicates that we don't have the next one until 2:15, so that leaves us a half hour. So we can open up discussion on, let's look back at this 321 bill that we just finished. Is there any discussion we'd like to have as a committee on that? Yes, Representative Likas?
I think you're asking for specific definitions of gifted and putting talented in or not, but I think he's basically defined gifted as a student identified as having unique academic, artistic, or athletic, so that would include talented and all of that, according to assessments selected and administered locally. So it's like if you want further definition, that's the local, it's up to the local school district to define. And I think that's good because we're not looking to do studies or, evaluate or whatever. As he said, it's just a place for people to go. And so the bigger the pot, the more things you're going to have. And so if a school is looking, let's say, for what to do with their athletically gifted, that'll be in the pot. If somebody wants to know what to do with their math, that'll be in the pot. So making the pot big, you're more likely to have something there that another school district is looking for.
Is there any further discussion? Representative Myler.
Thank you, Mr. Chair. I think Representative Moffett has kicked this thing around a couple times, and I don't think we've done it enough serious to really look at this. There are students out there that obviously are gifted and are not having perhaps a kind of curriculum that should be available to them. And I would think about retaining this bill. And let's look at what this is all about. If we currently are providing funding for some students who are struggling with reading, for example. Why couldn't we have some funds available to help programs in school districts that can deal with gifted issues and try to identify something? So I'm looking at this much broader than just a file that you put stuff in that we don't know what the value of it is. We don't know what the definition of it is. It seems to me that we ought to look at this in a much more serious way than just, I'm not talking about mandating things at this point in time, but to have a chance to really look at this thing seriously for the first time in a long time so that we can get a handle on this, so that we actually know what we're talking about and know what we might want to receive from school districts that could benefit the best practices for other school districts. So I think this is a little more, to me, it's more serious than just creating a file to sit on somebody's desk that nobody's going to look at. It's going to be on that shelf of indecision, and really look at this in a much, much more direct way than perhaps the intent of this particular bill has for us. Thank you.
Is there any more discussion on this particular topic from folks? Representative Mullen?
Yeah, I agree with both Representative Moffett and Representative Myler in the sense that I believe that you have to start somewhere, and you start somewhere by taking your first step. So I understand Representative Moffett's desire to start gathering this information. And I personally, I'm not that far out from working in schools, and I agree that sometimes our gifted kids are an underserved population because lots of them are able to learn independently, and they don't, shine a light on themselves as needing the kinds of interventions that some of the other kids do. But my question, I have a question and I'll poke fun at my own community. What do I do? What do we do when we think we have 100 gifted soccer players? I get the fact that we can give standardized assessments and come up with scores and measure achievement and, but how, I understand local districts can measure their own, but how are we going to determine that one shortstop is gifted and the other one is just okay? So I think that aspect, not the academic piece, because I think that's measurable, but perhaps the artistic and the athletic, thinking about what kinds of measures we would use might behoove us. Done.
Representative Land, you had your hand up.
Thank you, Mr. Chair. This is an area that's definitely close to my heart, both through my experience growing up with one of these programs and because so many kids and so many parents in the state are asking what's available for gifted students. They ask and they try and find out what programs are available. And within the homeschooling community, we see huge numbers of students that are leaving the schools because they're not able to get the challenges that they need within our public school system. And that's not just for those traditionally gifted children. That's particularly important for the twice exceptional students, those who have special needs and are gifted, because those children are better able to hide their learning disabilities because they get along well enough that they don't call out that attention. I think that there are a lot of very important different ways that you can be gifted. I mean, I know that you call out the idea, Representative Mullen, about having 100 gifted soccer players, but you know, you look at a small school like Azusa Pacific back in the early 90s, and you would never expect that having the Nigerian Olympic team there would bring you the Nigerian nightmare, Christian Nakoya coming out there. But they did, because there was a truly gifted group of athletes at that school at that one particular time. And if our towns and schools are able to see where their population really thrives, there can be some wonderful opportunities that we can do with a less structured point of view. I do know that when people start talking about gifted students, especially academically, there comes into some of the issues about equity and other factors. Now, I'm sorry that I keep bringing up my mom's school, but with their 98% free and reduced lunch, they actually did have the same number of students meeting those academic requirements, which was pretty fascinating to see. But as we're able to recognize the way that children really excel here in New Hampshire, and we just collect that information at this point, so that when somebody's asking, what do we do for gifted children? We can start a better discussion with actual information where somebody can actually go to the Department of Education and find out what's going on. I think that then when we see what's actually happening on the ground in our schools, we'll be much better positioned to potentially do something to keep these amazing, talented students in our public school system instead of watching them quietly step out and pursue their education in a different way.
Representative Moffett.
Yeah, thank you, Mr. Chair. Nice to have a little extra time here, real quick. A couple of things. With regard to this going to a file that no one will look at, I think that's a dismissive type of look at this. I think a lot of people would be very interested in what was in that folder that they could look at. Representative Mullen's point about the soccer players is well taken, and that's why we want to leave this to a local, let the localities, have this discussion as opposed to us imposing some prescriptive form or expectation. And the last thing I wanted to mention, Representative Myler mentioned retaining, and we'll have more discussions about this. I think amending would be something. If I don't see a need for amendment, although we could add the word talented, I think we should talk about amending before we talk about retaining. But then I have to say that we've already done this dance. We sent this exact same bill to interim study in 2018. We had a 7-person interim study go through this in detail. Overwhelmingly recommend that this measure move forward with OTP. As I said earlier in my testimony, it came to this or that full education committee at the time, which voted OTP. In fact, I already mentioned Representative Myler voted for OTP back then. So rather than retain something that we've already done an interim study on, I think we should think about honoring the work that the interim study committee did in 2018, which did in fact recommend OTP.
Yeah, there's a number of hands up here. Representative Tanner.
Thank you. And actually, Jerry Few was a superintendent in the school district I worked in, Kearsarge. And, Kearsarge had a math team that really worked with the group that was highly motivated and gifted in math. We had a literary group that worked with people in the arts and the drama program. I mean, that's one of the benefits of extracurriculars is it gives it a venue for some of the people that are gifted to actually pursue different things that they are gifted in. We also at the middle school and elementary school for a long time had a gifted and talented teacher. And I don't think there was a big problem in identifying who was gifted and talented. It was the teacher that identified a student who just wasn't motivated, but she knew that, or he knew that student had a lot to offer. And there wasn't a lot of restriction on who got into the gifted program, and she ran, some really creative programs. So I think we've had that, around. It's mainly in the schools that can afford it and that have the opportunity to do that. I think probably schools that are struggling, although they do have math teams and things like that, but it's hard to offer something else. And I think it's a program that needs to be discussed and needs to be, researched. I too think that, having a coordinator at the Department of Education, rather than just a portfolio, certainly gives more access to teachers and parents that want to find out more about this. So I agree that the program is a worthy bill, and I would like to see us work on it a little bit. So thank you.
Representative Woodcock, you have your hand up?
I do, Mr. Chair. Thank you so much. Since you're taking commentary, a couple of things have come out in the testimony anyhow, and one of the realities is this bill doesn't do anything more than what can be done by DOE themselves right now. Schools send it in and put in a file that people can access it. But beyond that, I think Representative Moffett brings the issue to the table again that's critical, but it's more wide of an issue than just a slim gifted program. It reminds me that DOE doesn't have an advocate or someone that's working to support this. And you look at the larger picture of DOE's support for curricular improvement, curricular review, curriculum administration across all our academics. They really haven't pushed a lot of money or time and effort or advocacy for whatever reason, I'm not suggesting they don't want to do it, or personnel, to look at all these curriculum places and move them up. And I think gifted is just another piece. And it's a critical part of keeping kids in public education. And because our cadre of youngsters now is so much sharper. And, we need to be on the upper level of that. And we should have an advocate there at DOE. I think this bill has a huge potential if DOE gets behind it as other curricular pieces and starts to go forward. But just taking what is one school doing, that can be done now. And I think Representative Tanner's comments are on target. As schools have money or individual initiatives from certain teachers, they go forward. If not, they don't. So I would like to see the bill be expanded. But the bigger picture, getting DOE to commit resources and time and people to all our curriculum reviews so we can look at what's the best for each area. Thank you, Mr. Chair.
Representative Lightfoot.
Yes, thank you. Sorry. The DOE currently has that portal where you can go and find out all that information about schools and all kinds of things. So putting this file on that portal so that other schools can go and look and see what schools are doing, I think should be fairly simple and gives that opening. This gets people talking about special ed, talking about gifted programs. Gets school districts to say, are we doing anything? Maybe we're not. It starts the conversation. So we start the conversation here, look and see what's available, look and see what people have said they're doing, and then another bill follows that conversation on to see what do we need to go now. But let's at least get the conversation started, because if we keep saying, oh, we need to, oh, we need to, oh, we need to, and pumping this down the road and down the road, we're not even going to start the conversation. So this is to get it started, and then we'll go from there.
Thank you very much. I'd just like to get my 2 cents in for a second, and then Representative Ford. I think it's important that we get some information in from the field. In my experience as a school principal for years, and that of a nationally recognized principal for having excellence in the school and school district, identification of these youngsters is really important. There are a number of kids that I found that become disciplinary problems that are gifted and just bored out of their minds. And with that, they take the wrong path. I'm sure that you've seen that, Representative Woodcock in the high school. We're losing a lot of them. So I really do feel that we need to get on top of this, and I don't want to kick this can any farther down the road. If we can get people thinking giftedness and talented, if you look at the bell curve and you look at the people on the right-hand side of that bell curve, what are we doing other than maybe AP courses or concurrent dual enrollment or Odyssey of the Mind or math counts or geography Bs, whatever you have in your schools? What are we doing to really get these folks and using their minds, their thinking skills, and their creativity and their leadership? All this comes into play from gifted kids. When I was a school administrator and principal and teacher, we had a program that was funded locally where we did provide gifted instruction with gifted teachers in each school. And we identified kids based on leadership, creativity, achievement, 95s or higher in a nationally recognized standardized test, recommendations of the teacher and the parents, and also we looked at the intelligence. Where are they with their IQ score? And a combination of those, we brought kids into the program with the understanding that there's some kids that were very unique and maybe didn't show up as well as they did in achievement because, quite frankly, they blew it off. So I would like very much to get something out there. I'd like to know what kind of programs might be in existence in this state right now that are doing some of this and having the ability to share that with other school districts. What I think Representative Moff is trying to do here is what we got to do. We got to start thinking this. I put a bill in, must be 4 years ago, and it was shot down, just like we've shot down this bill 2 years ago. And here we are dealing with it again. So we are kicking this can down the road. So perhaps what we need to do is before, in the next several weeks here or so, put a couple people together on a committee and work with Representative Moffett to see how we might be able to improve this. If we are going to do some kind of fact finding from the school districts, let's try to help out and design this thing so it might be of some potential and assistance to our kids throughout the state.
Chairman Moore, Rep. Shaw has her hand raised. She's a co-sponsor.
Okay, Representative Barb Shaw. You out there, Barb?
Yes. When Representative Lakis basically said everything that I was going to say, but I just think that sometimes if you start out with something informative, like what exactly is out there, take a look and then set up a committee in another bill that will look at this information and bring it further. That's the way I look at it. I don't want to put any extra burden. I don't want to have anybody have to spend all kinds of money in their schools at this particular time. But let's find out what exactly is out there. There might be tons of things. And as that material is collected at the DOE, it'll be in a best practices folder. Then we set up a committee or a commission to study it, and we can go forward from there. But just find out what's out there first. That's why I think this bill is good right now. Just what's out there, and send things in, and then we'll move forward from there. Thank you.
Thank you. Representative Luna.
Thank you very much, Mr. Chair. Yeah, I mean, there's a lot of stuff out there right now, referring to what Representative Shaw was talking about. And I think one of those things, and it's a very significant piece, is a book written by Carol Dweck called Mindset. And it's the observations that she makes in that book that really give me it makes me want to be a little bit cautious on this, particularly using terms like gifted or talented, because one of the things the author points out in Mindset is that when children are sort of labeled as gifted or talented, then they develop a mindset that makes them very adverse to failure, to mistakes, to taking challenges, feeling that, oh, I've been given this magical gift and now I can't do this. I don't want to be proven wrong or proven incapable or having people laugh at me. And there's a lot of evidence out there that suggests that, at least as Carol Dweck lays out in her book. So she, on the other hand, and I think this is consistent with a lot of the testimony or a lot of our discussion too, steers away from using words like gifted and talented towards focusing on effort and focusing on growth. So a growth mindset. And I guess, I guess it sort of fundamentally for me gets down to the, at base, what's being referred to here in the bill. I don't really think has a positive outcome for students, whether they're gifted, talented, or otherwise. And that in enforcing, this thought of effort, or the idea of effort and desire and passion for certain things is really a way to be taking it down. And I think, again, we may be looking at the same type of challenge, but maybe through a different lens. Thank you, Mr. Chair.
Representative Ford.
Need to unmute.
Rep. Ford, can you hear us? Okay, there you go. I think you're.
Okay, can you hear me now?
Yes, we can.
What I don't hear in our discussion here is what I also didn't hear in the testimony about HB 20. No one mentions innovation. No one mentions sort of creative stuff. And maybe a better word is creative kids, generating the very creativity that's out there. I think of a high school in Texas that gave letters like football letters, but in things like Latin. And I thought, oh, that's kind of an interesting idea. No one did that in my high school, but I was in Louisiana, so maybe we were, backward. But it's just the idea of, again, what has been said about tagging kids. We don't have any problem of tagging them as athletes. And there's an athletic program in every school. But we have one that says, hey, being creative, innovative, whatever. Find a better term for it. There's one that's not pejorative or doesn't create unrealistic expectations, but show that we are concerned that that's important. Whether we go out to find out whether the schools are doing it or to suggest to them, we sort of expect you to come in and tell us that you're doing something. And they didn't tell us that in HB 20. They didn't tell us anything. They just said, give us more money to keep doing what we were doing. And instead of, oh, we've got a better idea about how to do this better. If you could give us the money for that, then that would be helpful. I would have loved to have heard that. All I heard was status quo ante, again and again and again. And that wasn't terribly convincing to me. That's enough.
Representative Moffett.
Thank you, Mr. Chair, for letting me speak yet again. And I want to thank Representative Luno, Representative Ford, and everybody who's spoken. Again, I go back, it's wonderful to hear what Representative Ford just said and what Representative Luno just said. And they're getting into philosophy and definitions and mindsets. And that's actually the purpose of this bill. This bill recommends no policy whatsoever the intent of it, as Representative Shaw said, and as Representative Likas said, as I think most people, I think, are getting, the intent of this bill is simply to start baby steps, start the process, gather information. Now, all these wonderful conversations and discussion points that are now flowing forth are coming forth because this bill is on the table. So what's happening here in a micro sense is what we want to happen statewide. And this bill is a catalyst, I think, a very simple, clean, simple catalyst to start the conversation. We've had the interim study committee on this, and we've voted on it before. So I just look forward to seeing this move forward this time so that more of this great discussion can manifest itself. And thank you for letting me speak yet again, Mr. Chairman.
You're welcome. Okay, we're going to call this one just to a halt right here. We have a few minutes before we start. We're going to take about a 4-minute break here so we don't walk down the hallway, at least I can. And then we'll come back and we'll hear Representative Bohm. Thank you.
Oh, yeah.
You want? Oh, okay. Do you need help? Do you need help?
That's not yes.
Do you need help?
We got to drill that area.
Oh, was that you making the noise over there?
I did. 321? Yeah. We had an hour.
H371? Okay. I think this is, education for enforcement. So,
Yes. Yeah, HB 71 starts in 2 minutes. I didn't hear him say we were closing the inquiry. We did, and then we had time to just talk about it.
Oh, that's right. We were just talking.
It was,
We were expecting it, so.
well, not just.
Mike
discuss-
Moffett.
Yes.
Can you call me 234-6828?
Yes. 6828.
Yeah, thank you. Sorry, folks. I didn't know any other way to do it.
Those 5,000 calls you're gonna get now, Barbara.
Yeah, I know. I know. That's all right. Everybody knows it anyway.
We have a case, there was a couple of words that I changed in. One of the procedures or something like that. And I heard everybody there talking about programs. So what policies and programs? Well, I said no, before we use it again. No, we're not gonna do this. No, we're gonna do it until we get moving forward. That's just. Running out of water, drawing out my water. It's another coffee. What do you know? Might give Ralph a real hard time here, guys. Who does it? What is it, 71? Are you sure that's suggestion? Can we forget the hearing, just go right to ITL standards? Wouldn't be the first time. Okay, 71. It looks like we got a lot of blank places.
Ralph? No, do you remember the person you told me about? I don't see them. Are they on the phone?
She should be,
Is she on the phone?
no, just.
Oh.
See, I could still bring all my speeches, but you know.
Oh, I see, I see. Okay.
I get home and a few days and I find. Oh, no, it's not so funny. I was up at 2 o'clock, 3:30. My wife's running up and down the stairs.
Hey, Dad,
downstairs.
I should stay muted, right?
Pardon me?
Yes. Well, yeah.
Because of. Okay, we're good. Okay, for those people who are still in the audience here or in the committee, we're ready to go ahead with HB 71. HB 71 is an act relative to school district emergency special meetings, and the prime sponsor being Representative Ralph Bohm. Representative Bohm, you're recognized to present.
Thank you, Mr. Chairman and members of the Education Committee. I am Ralph Bohm, 7th term, Hillsborough District 20, Town of Litchfield. This is what I call a no means no bill. In the past, we have had a lot of special meetings for multiple reasons. But I believe in 1998, this law was changed to try to keep special meetings at a minimum. However, the law states that the judge to consider the following. This makes the current law moot. This bill does away with the consider. If the voters say no to a warrant article, then it should be it until the following year. I've lived in Litchfield for 44 years. During that time, we have had warrant articles fail, including contracts. No special meeting, contract was worked on and passed the next year. A couple of years ago, a teacher contract failed, mainly because of the health insurance part of the contract. The Allegheny School Board applied for a special meeting. As I said earlier, we've had them fail before, worked on over a year until the following year. In this case, a special meeting was granted. The special meeting was held in October. This meeting was not well advertised, so not many people turned out to vote. We are in SB 210. The meeting was not, the warrant article passed. What this did was cause our tax bill to be late. And rather coming out in late October, it came out in late November. This made the tax bill due right before Christmas. Merry Christmas. The argument made to the court was that the failure of the contract caused a lot of teachers to leave. This happens every year anyway. We are a small town, and as a small town, we are a training ground, and teachers always move. And we have had multiple failures of contracts over my 44 years. And as a former school board member, I've negotiated a number of contracts, and also a selectman negotiated a police contract. So I know what goes into contracts. This bill states, no means no. Let's fix the law and keep it out of the hands of activist judges. How many times over the years have we had to fix laws because of judges doing what they think or follow their political leanings? No should mean no. Thank you, and I will take questions.
Thank you very much, Representative Baum. Are there questions for the sponsor of the bill? Any questions? Representative Mylan?
Thank you, Mr. Chair. So if I'm clear on this, Representative Baum, what you're saying is that if a contract and if an employee contract gets voted down, that's it. They basically will not have a chance to look at that, or the school board would not have a chance to renegotiate that, even though both sides agreed to the initial tentative agreement. That means that they would basically go ahead with no contract until another school district meeting. Is that correct?
It has happened over many years, and many times I've been even on the school board. You just renegotiate, you spend the time working on it and come back. And usually, in most cases, the following year contract goes back retroactive. You fix what was bad, and so in most cases that I've seen in contracts not done, the teachers just have to wait. They'll get their raise even for the preceding year. So yes.
Thank you.
Further questions? Not seeing any hands. Thank you very much, Representative Baum.
We have Laura Gandia joining us. Laura, you've been promoted. Go ahead, please.
Can I speak?
Go ahead, please.
Yep, okay. So good afternoon. My name is Laura Gandia, and I am a parent, taxpayer, and resident in Litchfield, and I am also a former state representative who served 2 terms. I am here to speak in support of HB 71. As you hear, there are times when a bill comes before you with a story, and this is one of those times, so I'd like to share with you a story from the town of Litchfield. In 2019, the collective bargaining agreement between the Litchfield Education Association and the Litchfield School Board was set to expire on August 31st, 2019. Negotiating teams from both the union and the school board met several times between August 23rd, 2018 and December 3rd, 2018 to negotiate a successive collective bargaining agreement to their 2017-2019 collective bargaining agreement. The parties reached an agreement which was ratified by both parties and submitted via a warrant article on March 12, 2019. The school board recommended the warrant article by a vote of 5-0, but the budget committee did not recommend the article due to a tie vote of 4-4. The warrant article was defeated by the voters on March 12, 2019. After the article was defeated, the school board and the union met and renegotiated a different contract and sought relief from the Hillsborough County Superior Court to find that emergency existed per RSA 197:3, allowing a special meeting to be held, all to the detriment and wishes of the legislative body that I was a part of, who previously and clearly defeated the warrant article in March 2019. The LEA petition claimed an emergency existed to justify another election despite the legislative body voting down the warrant article and despite the ability of the school board and the union to present their renegotiated contract at the town's annual meeting in March, about 6 months away from the date of the requested special election. All this without regard to the voters' desire and wishes as clearly spelled out at the March 2019 election and at a significant cost to the taxpayers of Litchfield. Estimates for the special election, I believe, are around $8,000. The LEA claimed that an emergency existed, which required the immediate expenditure of funds. Typically, if you look at case law that surrounds RSA 197:3, an emergency requiring the immediate expenditure of funds includes the acquisition of land because it could be sold, and or the purchase or repair of a building because there's an urgency to that if the building's going to be sold or the repairs are needed immediately, which would result in an immediate loss. That clearly wasn't what was happening here. The LEA further claimed that the teachers will not receive any salary increases for the 2019-2020 school year. The lack of raises during the 2019-20 school year will cause a hardship to the teachers. And again, that's the LEA's claim. And they also claim that it was unforeseeable and unavoidable emergency arose, which required the immediate expenditure of money within the meaning of RSA 197:3. The fact that the collective bargaining agreement as put forth to the voters did not pass was in fact foreseeable in this fact pattern. The warrant for the collective bargaining agreement received mixed reviews and did not carry unanimous support from the Budget Committee when presented. Therefore, going into the election, it was foreseeable that the collective bargaining agreement could fail. In any event, having a collective bargaining agreement defeated with support, or in this case, without unanimous support, is not unforeseeable, nor is it unavoidable. In fact, it happens quite often. All of these harms claimed by the LEA are present during any type of labor negotiations, and to claim that it was elevated to an emergency is without merit and doesn't go in line with the intent of RSA 197:3 as it relates to an emergency. Further, when the court granted the school board's request, this sets a dangerous precedent, especially in this particular situation. The LEA had the opportunity to go back to the voters in March with this contract. Every collective bargaining agreement is subject to defeat. That's part of how we work in New Hampshire. And the lack of a raise should not and does not rise to the level of an emergency as enumerated in the factors set forth in 197:3. As some of you can guess, as I already stated, the request for a special election was granted, and then the special election was held at an off time in the fall, when many residents and taxpayers were unaware that one was even being held and that the contract passed. It's also important to note that there's no local newspaper for Litchfield at that time, and the voter turnout, I believe, was quite low in the vicinity of 7 plus or minus voters, where there are over 8,000 registered voters in our town. There was no urgency. The LEA's contract was set to expire on August 31st, 2019, and the LEA could have waited for the town's annual meeting in March. This was not the case where there were multiple years without a contract. Clearly, no urgency existed, as every collective bargaining agreement that failed would fall into this category of creating an urgency, requiring special meetings and leading to discourse and expense to the taxpayers and disruption of the process. The will and the voice of the voters in these situations would be severely diminished and in some cases ignored. The intent of HB 71 is to have the process respected, the laws followed, and the will of the taxpayers and the legislative bodies honored and respected. HB 71 would prohibit a special election for the purposes of voting on a contract that was voted down at a regular meeting. This concept is fair and consistent with how New Hampshire operates. I do not believe that RSA 197.3 was created to allow the LEA, the union, a special election to ratify a contract that was voted down by the taxpayers. No means no, and your recourse is to present a different renegotiated contract at the next annual meeting. Not to sidestep or backdoor the process, but to have full transparency and access to the voters. Thank you.
Thank you very much. Are there any questions from members of the committee? Thank you very much for your testimony.
Thank you.
Welcome. Who do we have next?
Next, we have Barrett Christina from the School Board Association.
Okay, Barrett Christina, School Board Association.
Good afternoon. Thank you, Chairman Ladd. Again, members of the committee, nice to see you. Barrett Christina, Executive Director of the New Hampshire School Boards Association. I want to thank Representative Bohm and the previous speaker, whose name I didn't catch, for sort of explaining the how and the why this bill came to be. As I said, we are opposed to the bill. I understand that the collective bargaining issue is a little bit different. I'll speak to that in a second. What I think is important for context, if the committee members have not looked it up, looking at the bill, it says the court shall not allow a special meeting if the emergency involves any of the following. And I know the previous speaker talked about the definition of an emergency in RSA 197:3, but I just want to read it again so the committee is clear. An emergency for the purposes of this section shall mean a sudden or unexpected situation or occurrence or combination of occurrences of a serious and urgent nature that demands prompt or immediate action, including the immediate expenditure of money. So with that definition in mind, NHSBA's concerns with the bill are primarily paragraph 1, which I believe is on line 5, and paragraph 3 that is on line 8. When we look at whether or not a warrant article that was voted down at a regular meeting, certainly the will of the voters should be respected, but that's sort of where the definition of emergency within RSA 197.3 comes into play. And I think the easiest example is a school board may put on the warrant to raise and appropriate $500,000 for, I'm just going to say some capital improvement, a new roof, a new heating system, a new boiler, whatever the case may be. But if we get into December or January and that boiler fails, or we get a windstorm and the roof blows away, the only way to fix that issue maybe go back to Superior Court to ask for that $500,000 to fix the roof, even though the voters last March may have voted that down. I think that's a true emergency that we need to leave some flexibility within the law to address these sort of unexpected circumstances and these emergency circumstances. And I guess the same argument would hold true for paragraph 3 on line 8, any item in the budget that was not approved at the regular meeting. Again, I can think of a number of scenarios, again, mostly related to sort of your capital expenses, where the board was not able to anticipate that the boiler would blow up, or that the roof would blow away, or that we would have an ice storm that would somehow damage the facility in the middle of winter. So it may not have been approved by the voters back in March because it was just that it wasn't an unanticipated event, occurrence, expense that came up. And NHSBA is concerned that if you were to pass this law, you'd be significantly inhibiting true emergencies. With respect to the collective bargaining agreement, when Representative Bohm was speaking, I had a chance to pull up the decision from the Litchfield School District that he brought up, and I read through it a little bit. Just a couple quick comments on that. One, to be honest with you, I was a little surprised at that decision. I don't know if there are any other Superior Court decisions indicating that the failure to pass a collective bargaining agreement constitutes an emergency, if that's the first one in the state. Again, I'm not aware of. But I think the better process, which is already allowed in law relative to the collective bargaining agreements, and many of you have seen this on your own warrants in your own local towns, is often they'll have the warrant article for the collective bargaining agreement, maybe article number 3. But oftentimes school boards will put article number 4, will say, in the event article number 3 fails, in the event the collective bargaining agreement fails, can we go back, do you authorize the school board to hold a subsequent meeting to revisit the contract? That's pretty common in New Hampshire on warrants, of my understanding. And truthfully, I think that's a better way to handle circumstances in the event a collective bargaining agreement fails at the annual meeting. That way, if the contingent warrant article passes, the voters have had their say, and we're agreeing with the will of the voters. So, I wanted to comment on that a little bit. So the collective bargaining language in the bill, I think there were workarounds for that outside of having to go to Superior Court. Again, that Superior Court decision, just reading through it quickly when Representative Bohm was speaking, kind of caught me off guard. But NHSBA does have concerns about, again, paragraph 1 on line 5 and paragraph 3 on line 8, that in our opinion, those would address sort of true emergencies, which I think the origins of RSA 193:3 and going to Superior Court are truly intended to address. So we'd like to keep those provisions within the law in case those emergency circumstances, exigent circumstances arise, such that the immediate needs of the district and the students can be met in some manner. That concludes NHSBA's testimony, and I'm happy to take any questions.
Thank you very much, Mr. Christina. Are there any questions? Representative Land.
Thank you, Mr. Chair. Thank you, Mr. Christina. I guess my first question you may have addressed, it sounds like in dairy, we do put those warrant article questions about having a subsequent meeting. So it sounds like, in your opinion, that's a better way to deal with it instead of leaving this up in the air, and then I'll have a follow-up.
Sure. Thank you for the question, Representative. Yes, I think having that contingent warrant article that follows the collective bargaining agreement warrant article is a smoother process, both for the voters and the teachers and the school board, rather than having to potentially go off to Superior Court seeking judicial remedy to revisit the collective bargaining agreement. The way I liken it, as I mentioned, if you put that contingent warrant article in front of the voters and they pass it, then you're allowed to hold a subsequent meeting in line with what the voters have authorized you to do.
Thank you. And then my follow-up is similarly, isn't there a process where if there's something that wasn't approved at the regular meeting, they can go to the DRA or to the budget committee in order to be able to spend some unanticipated revenues?
Thank you for the question, Representative. Not to my knowledge, certainly not to the budget committee. The budget committee makes recommendations on the budget. The voters then vote to adopt it, and so the school board is within the constraints of whatever the voters have adopted. Whether or not there's a process to go to the Department of Revenue Administration for sort of emergency spending, if there is, I'm not aware of that, Representative.
Are there further questions for Christina?
Sodi.
Representative Sodi.
And with regards to this,
Yeah.
regards to the roof blowing away or the toilet blowing out, are schools required to have building insurance? Cover these kind of things?
Did you hear that, Mr. Christina?
Thank you for the question. I could not hear anything. It was all sort of garbled and choppy. My apologies.
So he asked, are schools required to have insurance to cover these unknown expenses such as the roof blowing off or the boiler blowing out?
Thank you for the clarification, Chairman Ladd. I believe they are. Any school district is going to have property liability insurance and insurance on the structure itself. How that works, I can't necessarily say, but certainly in times of COVID, I heard of at least a couple of school districts that had to go back and ask for additional money to fix their HVAC systems over the summer, because the HVAC system was not it wasn't up to certainly current best standards, and in times of COVID there were issues relative to air quality within schools. So I mean, yes, school districts do have insurance. So I mean, that may be one avenue. I don't know if insurance is necessarily going to cover the entire cost of the capital project that may be necessary due to the emergency.
Thank you. Are there further questions for the School Boards Association? Not seeing any. Thank you very much, Greg.
Thank you very much, Mr. Chair.
You're welcome. Is Jerry Fruit coming?
Next we have Jerry Fruit, yeah.
Okay, welcome, Mr. Fruit.
Thank you, Mr. Chairman. Thank you, members of House Education Committee, for listening to testimony this afternoon. I'll make it brief. You've got an ambitious agenda and a long day. Many of the points that we would make were eloquently stated by Mr. Christina. We certainly would agree with RSA 197:3 and the opportunities that are spelled out in that existing legislation. Also, the opportunities of collective bargaining and the school board being authorized to petition for a special meeting is important. This proposed legislation would eliminate the locally elected representatives the opportunity to determine the best course of action for the school district in case of an emergency or change in circumstances. And we see that particularly in line with collective bargaining and other issues. So we would respectfully request that you find HB 71 inexpedient to legislate. There are remedies already in place to handle those situations, and I'm happy to take any questions.
Thank you very much. Are there any questions for Mr. Prue? So where'd you get that bump behind you? I need to get one.
I'd have to consult with my furniture designer. My wife, in other words.
Looks good. Any questions for Jerry? Thank you very much.
Thank you.
Yes, Brian Hawkins from NEA New Hampshire.
Thank you. Thank you, Mr. Chairman. Can you hear me okay?
Yes, we can.
Good. And I think I figured out my camera too, which was, looked like I had it half blocked at the last time I was testifying this morning. For the record, Brian Hawkins, NEA New Hampshire, here in opposition to House Bill 71. We think that this bill is a solution in search of a problem. And some of the provisions of this are far too broad. First off, I'd say from the collective bargaining piece, I inquired from one of our attorneys how often she's seen this occur, and at least in the last 6 years that she's been at our organization, this has only been sought twice in the last 6 years across the entire state, and we represent the the bulk of collective bargaining agreements for educators in the state. So this is not something that is sort of a runaway train of people seeking follow-up remedies from the court. And I think, why would we want to take this away from a district if they're trying to solve an urgent matter? I think it's unnecessary to do that. Why not let the parties go before the court if they're going to make a case for an urgent matter? As Mr. Christina had mentioned, the guidance in the statute that the court looks at, and they looked at in the case that Representative Bone mentioned, was they assessed the severity of the harm to be avoided, the urgency of the petitioner's need, whether the claimed emergency was foreseeable or avoidable, whether the appropriation could have been made at the annual meeting, and whether there are alternative remedies not requiring an appropriation. And happy to submit that to the committee if you'd like, the decision that was rendered in the Litchfield case, because I think it does outline the reasons where the petitioner in that case met those standards according to the judge. So let them go before the court. The court can say no. That has happened, gone before the court, and that has not been granted. I think this is also a good provision for taxpayers and for the educators in our state. So, we start, I think, from the standpoint of wanting good labor relations in the state. We want our educators. I think the legislature has said we want our educators to have agreements. I think this is true at the local level, from school boards and superintendents. We want an agreement to be in place. Everyone is better off in that situation. And so from that standpoint, if after the process has concluded and we've brought a collective bargaining agreement to the voters and they've said no, and we go back and seek another solution that can be presented before the voters, because of the urgency that the court agreed with in, for example, the Litchfield case, why not give the voters the opportunity to say, we said no originally, the contract cost too much. You went back, you came back with another agreement that is going to cost less, and that gives us an opportunity to satisfy both needs, both the something that costs a little less, and so that our employees can have an agreement. There are urgent circumstances with regard to collective bargaining agreements. And I think this was true in the reasoning that this was granted in the Litchfield case, which is we're in a very competitive environment with respect to teacher pay and critical shortage needs. Why? So, and as Representative Bowen mentioned in his testimony, there were the school district was losing educators as a result of this. The multiple contracts when you fall behind on multiple contracts, it does reach a point when you are really in an urgent situation with respect to making sure that your district is competitive. That's good for the people in the town. It's good for the students to make sure that you have a competitive agreement in place. We don't have statewide salary scales. We have individual school district scales, and so all the more reason that that's important. I'm just looking back at my notes for the testimony that was put forward before. Yes, so I would say, in the case that was brought up earlier, I think the parties did exactly what they were supposed to do. They heard a message from the voters. They went back and they fixed an agreement that was needed and needed to be put in place in an urgent fashion. Last point I'll make is not related to the collective bargaining piece, but to the the provisions that would prohibit a warrant article or a line item from returning. I think we've seen some urgent examples of the need to be able to go to court. Mr. Christina brought up a couple of examples, but if you had a warrant article in March before everything shut down for the pandemic that said we want to replace or have a substantial fix to our HVAC system, and it was voted down, according to the language, or at least is how I read this bill, you couldn't bring that back. You would be the court would be prohibited from allowing you to allow the voters to even consider that. So why take that out of the hands of the district? And again, it's the district that needs to come before the court to request this, not the union or not an individual. So I see this as tying a district's hands when they're trying to fix a problem. I'll conclude my testimony there and happy to take any questions.
Thank you very much, Brian. Any questions for Mr. Hawkins? I don't see any. Thank you very much.
Thank you for your time.
Do we have any other folks that are signed up under attendees or?
No.
That's it. Oh, so that's it on HB 71. In conclusion, we had 2 people supporting, 67 opposed, 0 neutral, and 4 testifying. Thank you very much. This hearing is closed. The next hearing which we have is HB 234. This is relative to freedom of speech and association on college campuses. The prime sponsor of this bill is Representative Alexander. Is he? He's been promoted. He's here. Okay, good.
I am here, Mr. Chair.
Welcome, Representative Alexander.
Thank you, Mr. Chair, members and friends of House Education. My name is Representative Joe Alexander. I am a representative of Goffstown, New Hampshire, or Hillsborough District 6. I'm here to speak on behalf and in favor and move House Bill 234. This is regarding freedom of speech and association on college campuses. Free speech is under attack. The Knight Foundation reports 61% of students believe that the climate on their campus prevents some students from expressing their views. 58% of Americans are not confident that others can hold civil conversations with people who have different views. 50% of Americans say that universities should disinvite speakers that will offend some part of the campus population. This bill seeks to further enshrine protections for all speech on our public colleges and universities. So some of the things this bill would do: it would increase the environment of mutual respect among a diversity of sincerely held beliefs. It would provide for that public institutions of higher education in our state protect all speech, even those that are considered unwelcome, disagreeable, or even deeply offensive. It protects students against actions by others that materially and substantively disrupt their practice of the First Amendment. It mandates the institutions of higher education make public in their handbooks, websites, and through orientation programs the policies around speech and expectations around the freedom of expression. It provides for injunctive relief should a university fail to do these things, monetary damages and reasonable attorney's fees and court costs. And finally, it would prohibit speech zones and speech codes. So it sets a minimum standard for upholding free speech on our public colleges and university system. It sets the minimum standard, and any university or college would be welcome to adopt increased standards should they see fit. So with that, I have students ready to testify and other people ready to testify in support. So I'd be happy to take any questions to start.
Thank you very much, Representative Alexander. Are there questions for the representative? Representative Leahy.
Thank you, Mr. Chairman, and thank you, Representative, for taking the question. Just a simple one. Do you have any specific examples that have occurred in the last couple of years that would raise this issue from New Hampshire, from the New Hampshire schools?
I do. Thank you very much, Representative Light, for asking that question. I would say that there are instances at the University of New Hampshire system in which speakers were invited and there were students that were blocking doorways. A speaker from PragerU that was blocking the door, or students were blocking the doorways and not allowing access to our students for our students to attend the event. So there have been recent examples. Another example was from UNH where a student was seen and recorded on video. It actually went viral of the student tearing down posters of a local conservative group that was endorsed by the college.
A follow-up, Mr. Chairman? Just one. Thank you. Now I'm trying to remember what it was. I forgot.
I did such a good job.
I guess you did. You're young and I'm old, so thank you.
Again, okay, we'll go to Representative Myler.
Thank you very much. Thank you for taking my question, Representative Alexander. A question and then a couple situations I'd like to ask you about. Do you believe that there is should there be any restriction on free speech?
I mean, I don't know. I don't.
All right. So here are a couple of examples, and how would you treat them? How would this bill treat them? Graduation. Graduation obviously is kind of a hallowed experience for students, etc. Should free speech interrupt a graduation based upon a protest or whatever? That's question one. Question two is that if I'm teaching a class in a college and I've got somebody outside my window who is practicing his free speech rights that's interrupting my presentation or the process of that school, should that be restricted? So those are two examples I'd like to have you respond to. Thank you.
Yeah, absolutely. Thank you, Representative Myler, for asking those questions. I'll address the second one first. There is text in this bill that would say the system and the administration is allowed to impose time, manner, and place restrictions on some speech, depending on the educational, to provide that everyone has the equal opportunity to education. So that's in the bill just to make sure that that is protected in that case. And then regarding the graduation, I mean, the university system, you know, usually, I mean, I went to St. A's, but I also went to UNH for graduate school. But St. A's kind of had this like essay contest on who got to be the student speaker. And it was kind of an opportunity for everybody to up and give their say on why they should be the student speaker. So that speech, I think, is still protected. With regard to the graduation, I mean, there's already free speech being practiced during graduation. So for instance, I decorated my cap with a I'm still a Republican after college kind of cap. And that was an exercise of free speech during a hallowed ceremony that would still be protected under this bill.
Yeah, just as a follow-up, Mr. Chairman Ladd, yeah, the issue of the putting something on a mortar board is terrific. I mean, you can do whatever you want to there. It's your head. My concern is that if in fact during the actual graduation ceremonies, there is an attempt on the part of somebody who wants to express their free speech through verbosity of the expression that would interrupt the ceremony, is that a permissible restriction of that person's free speech? It's very similar to, can somebody just stand up in a crowded auditorium and yell fire? I mean, there's restrictions there. Would that same kind of restriction be limited in this particular bill?
Well, I would say just to respond is that kind of disruption is already happening during graduation ceremonies. I mean, there was one time where former President Trump was the keynote speaker, and there were many graduates that chose to walk out in that situation. And in that example, that was a great exercise of their freedom of speech to do that. So again, I think this bill adequately is covered with a time, place, and manner restriction on it. And I think that would help answer your question with that situation.
Thank you very much. Thank you.
You're welcome.
Further questions? Not seeing any hands up. Thank you very much, Representative Alexander.
Thank you, Chairman and members committee.
Next, we have Ben Mickens. I promoted him. Go ahead, Mr. Mickens. Welcome to education.
Hello there. Can you all hear me all right?
Yes.
Very good. Thank you. I would like to begin my remarks by thanking Representative Alexander, as well as the Education Committee, not only for hosting me, but for putting together a hearing on an important issue. My name is Ben Mickens, and I'm a New Hampshire college student. I'm here first and foremost to argue that freedom of speech is a fundamental pillar of our democracy. With it, our ideas are exchanged and tested against one another in the public square. This not only leads to a stronger underpinning for democracy at large, but it helps us understand those who we might otherwise not hear from. Alas, on college campuses today, freedom of speech is a shell of what it once was. Conservatives in New Hampshire and around the country often feel pressured to stay silent while they're on campus. It's pretty rare for a college conservative like myself to consistently advocate for what they believe in on campus. This is not healthy for our country generally, and it's especially not healthy for academia more specifically. Little more than a year ago, the union leader ran a piece on UNH college Republicans expressing their hesitancy with speaking freely on campus, including not being comfortable showing their support for President Trump when he was running for re-election. Now, while some conservatives will speak anyway, it is nevertheless repressing conservative voices at large. With this bill under discussion today, New Hampshire can stake its claim as a leader for freedom of speech in this country. We should celebrate each other's viewpoints and be working together to complete our understanding of the world, not shutting each other out and tearing each other down. I believe this bill will not only help conservative students to feel more comfortable to speak out on campus, but to help liberal students gain a deeper and more personal understanding of conservative thought. This is fundamentally good for our country and for the state of New Hampshire, and I urge this committee to pass House Bill 234.
Thank you very much. Are there any questions for Mr. Mickens? Or Representative Lay?
Thank you, Mr. Chairman, and thank you for taking the question. So you said, you referenced a kind of hesitancy to speak out and to articulate publicly political views. But I guess what I'm trying to figure out here is, what has the university done that has created that for you? I mean, there may be one thing where students, you're feeling pressure from peers, etc. But what specifically has the university done that has led you to be hesitant to articulate publicly your views?
Yes, So I think as Representative Alexander brought up earlier, a pretty crystal clear example of what this might be is when conservative speakers get brought onto college campuses, not only in New Hampshire, but you generally see this throughout the country, is that if people show up and start blocking physically your way to get in and stuff like that, that's sending a signal of, you're not welcome here. You're not allowed to speak. You're not allowed to think the way you think. So that, and when college administrations don't have an adequate response to situations like that, which they tend not to have, that's what helps lead into this culture of, well, I'm a conservative, but I don't want to say anything because I don't want to get targeted by other people, because there's not that underpinning of support that I believe that this bill would help put into place here in New Hampshire. If that answers your question.
Follow up, Mr. Chairman, follow up. Thank you. So again, and I actually agree with you that, people of any persuasion should be permitted to speak. I don't support, preventing speakers, but again, did the university have any disciplinary procedure in place for these people who did interfere and blocked fellow students from entering the arena or wherever the speech was? Was anything done on that, or is the issue that there's a lack of any sort of disciplinary consequences for that action of blocking students from accessing the speaker?
Yes, and that's a good clarification. So the problem that I would cite more specifically is the lack of action on college campuses to allow freedom of speech on campus. So I think you hit it on the head with the second part of your question.
Thank you.
Any further questions? Representative Allard, is your hand up?
No.
You just hold it yourself.
Yes, I'm holding my head.
Thank you very much. Representative Lay, we do have Ron Rogers, who will be talking a little bit later. He's from the University System of New Hampshire, from the agency itself. That might be a good question for them.
Thank you, Mr. Mickens. Next, we have Brendan Flaherty. He's been promoted. Welcome to education.
Hi, all. Thank you for having me. I just want to make sure you can all hear me. Are we good? Okay, great. I know Zoom tends to be a problem with COVID and everything. Good afternoon. Like my the predecessor, Mr. Mickens, I'd like to thank Representative Alexander and the House Education Committee for hosting us this afternoon and providing us the opportunity to speak on this bill. My name is Brendan Flaherty. I'm a lifelong resident of Nashua and a New Hampshire college student, and I'm joining you today to voice my support for House Bill 234. We're fortunate that mass demonstrations against campus speakers aren't all that much of an issue here on New Hampshire's college campuses in the way that we might see elsewhere in the country. For example, University of California, UC Berkeley, comes to mind almost immediately when thinking about issues pertaining to political speech on college campuses and the inability of college administrations to adequately accommodate certain speakers, whether by deliberate choice or incompetence. While we're lucky that college students don't face those kinds of issues with mass demonstrations and protests and riots as elsewhere in the country, that does not mean that we are immune to those kinds of problems. Most colleges here in the state allow outside groups to conduct politically motivated operations, or club activities, which in its most basic form is a good thing to have, because civic discourse and engaging with each other is a foundational component of living in a larger community. However, some of the groups on our campuses like to take their actions to new heights. I'm thinking of organizations like NextGen at Plymouth State University. They've had some problems in the past with harassment of students on campus, especially around election season. But like I mentioned before, we've really been lucky on our campuses because we don't see. Harassment is not nearly the same as rioting. And I think it's important to clarify that. But that being said, House Bill 234 really attempts to take a proactive approach in establishing a legal standard for colleges to use in issues that might arise pertaining to free speech and association issues on campuses. What House Bill 234 proposes is not and should be seen as an indication that colleges in the Granite State are in any way suppressing free speech, but rather the bill should be seen as a framework for how to deal with those issues that come up in fostering the formulation and articulation of political ideas. I think that having a standard before any of those issues arise would serve our campuses well at a time where political issues are becoming increasingly more sensitive and touchy. And it's important that students be allowed to learn and engage in those different ideas respectfully with the support of their colleges. The law presented here today would be beneficial for our campuses in the long run, and hopefully it would foster true intellectual growth for our college students here in the Granite State. Thank you so much for your time.
Thank you very much. Are there any questions for Mr. Flaherty? Not seeing any hands. Thank you very much.
Thank you for coming.
Thank you.
We have Ron Rogers from the University System. Go ahead, Mr. Rogers.
And yours, Ron?
Thank you. I can, yes. Thank you, Mr. Chairman, and thank you, members of the Education Committee. I'm Ronald Rogers, the General Counsel for the University System of New Hampshire and for each of its 4 institutions. I'm here to testify in opposition to House Bill 234. I have written testimony that was submitted. I won't go through that. I just have 3 points that I'd like to make for you this afternoon. And then, of course, I'd be happy to answer questions. The first is that our institutions of the University System of New Hampshire agree with the principles that are stated as underlying this bill. Right at the beginning, the bill is for the purpose of protecting the rights of free speech, free association, free assembly, and those are values that university system institutions hold dear and have policies, processes, personnel to enforce. The bill goes on, though, from stating that purpose to describe a whole host of interpretations of those constitutional provisions and various procedures and processes and requirements, reports to be filed and causes of action that might be invoked in order to protect those protections. In fact, though, the US Constitution and the state of New Hampshire Constitution, which also has a free speech clause, has a substantial body of jurisprudence interpreting it and applying it. We're a public institution. We can be sued for violations of any of those principles. All of what the authors of this bill claim they want to accomplish is already in place, and the bill's not necessary. Point number 2 is those policies that we have in place to protect free speech, free assembly, free association have been independently reviewed by the Foundation for Individual Rights in Education, or FIRE. This committee knows that organization from Philadelphia. They've testified in front of the House Education Committee before. And they've given each of our 3 institutions a green light rating, their highest rating. If you can click on the states on their website, and there are a lot of states surrounding the state of New Hampshire in which no public institutions have green lights. They've got red lights, they've got yellow lights. In fact, fewer than 1 out of 10 public institutions across the nation have green lights from this public advocacy group. Each of the university system residential campuses have those green lights. In addition, I've been the general counsel for the university system for 34 years. We haven't had any complaints. Not only no lawsuits, we haven't had complaints in front of any federal or state agency about any of these issues. The administrations care about the issues, they're responsive, and they've kept their policies current and effective. Finally, point number 3, this is not a New Hampshire solution. I'm sure you realized when you read the bill that this is drafted by a national advocacy group out of the DC area. It is a bill that has been encouraged in all of the legislatures across the nation, and it doesn't fit New Hampshire. It doesn't fit our circumstances. It doesn't fit our issues, and you can tell that it's not addressed in New Hampshire. For number 1, we haven't had any complaints. This isn't responding to any real issues. Number 2, There's no mention in that bill of the New Hampshire Constitution, which, as I mentioned, has got a free speech protection in it, and it's completely ignored. And then finally, you'll notice toward the end of the bill, there is a provision that would have the legislature waive 11th Amendment immunity for the university system institutions. And what that means is we'd be subject to suit in the federal court. Well, guess what? We don't have 11th Amendment immunity because of the way the university system is structured. We already get sued in federal court. That provision is absolutely not necessary. This bill was written for other people's problems. It may be a good solution to their problems. It's not a New Hampshire answer to any problem that we have. And so for those reasons, on behalf of the Board of Trustees and the university system, we urge you to vote inexpedient to legislate. I'd be happy to answer any questions you may have.
Are there any questions for Ron Rogers, University System, New Hampshire? Representative Woodcock.
Thank you, Mr. Chairman. Attorney Rogers, thank you for taking my question. A moment ago, you were talking about this bill has been reflective of a national agency bill that's sort of boilerplate across the country and doesn't fit New Hampshire. Could you repeat for me, please? I didn't capture it on Zoom here. Could you repeat for me the name of the national organization that typically orchestrates this bill?
This one is from ALEC, the American Legislative Exchange Council. It's right on their website. They've got the language. It's almost verbatim. There have been a couple of adjustments, but it's almost verbatim. And the encouragement, the point is to encourage legislatures all over the country to consider the bill.
Thank you, Mr. Chair. Thank you, Attorney Rogers. Appreciate it.
Thank you. Representative Milo.
Thank you, Mr. Chair, and thank you, Mr. Rogers, for taking my question. How has the university attempted to provide for free speech for students? What are the policies and the practices that they've had to ensure that we do get the quote green light from fire?
Those policies that Fire was particularly interested in its review have to do with assembly, the free speech, typically in the public forums outside of buildings, the solicitation along the walkways and outside the public buildings, and then also the handing out of materials. And so the policies cover all of those issues. They also cover the rights of the students and student groups to invite speakers, and they cover the way in which security will be provided, and the university will ensure that the speakers are able to speak without interruption, without being disrupted, and that the members of the audience and the community are safe as a result of that. The university has a public safety office which has advance notice of these events, has a protocol that it goes through to ensure that the personnel are deployed necessary in order to be able to ensure the protection of free speech, but also the safety and welfare of the members of the audience and the community at large. And they've done that for groups and speakers that are both from both sides of the spectrum, of the political spectrum, including one notable example of an organization called Turning Point USA, a particular focus on conservative presentations at college and university campuses.
Thank you.
Thank you.
Thank you very much. I have a question for you, Mr. Rogers. We've had this discussion on the Education Committee in prior years, and one of the areas which we can have discussed are the free speech zones in the outdoor areas. Can you tell me what the policies are? Can an area that's used for instruction and curriculum be taken over by those advocating free speech?
Excellent question. Like so much of these constitutional issues, free speech, free assembly, free association, the protection of the rights comes with an obligation to balance the rights of all people involved. That leads to a set of policies that include the regulation of speech on time, place, and manner. And so there are places in the university where the institution has said they, number one, aren't open to the public, and number two, that the speech can be regulated in order that the mission of the institution not be disrupted. One of those places is in the classrooms. The faculty in charge of the class, teaching the class, are in charge of the classroom, and are able to decide when the speech is appropriate and when it'll be disruptive, provided that they don't do it, provided that they do it on a viewpoint neutral basis. They aren't about picking among various opportunities to speak based on the content of the speech. It's about the ability, it's about maintaining the ability to get the mission of the educational institution accomplished. Is that responsive to your question?
Yes, it is. That's fine. Representative Lefkowitz, you have your hand up?
Yes, I had a question. You had referred to this just using the United States and not being specific to New Hampshire. And I'm reading, it says in Part 1, Article 22 of the New Hampshire Constitution, and I'm wondering what else you would, what other references you would want for it to apply to New Hampshire.
And I have to apologize. I guess I must have missed that in my reading of the bill. Could you direct me to the section you're referring to, please?
Yes, that's Part 5, Roman numeral 5 on line 22. Well, it goes down to 24 is where that's specific.
But and which page is that? Oh, I see it. Yes, I'm sorry. Physically blocking amendment, Part 1, Article 22. You're exactly right. And I apologize. There is a reference to the free speech article, Article 22. There are other articles in the New Hampshire Constitution, but they have in that one place recognized one of the provisions. So thank you.
Further questions, Representative Mock?
Thank you, Mr. Chair. And Mr. Rawls, you may recall around 3 years ago, we had a somewhat similar bill that I chaired a subcommittee on, and you were wonderful to come and speak to that subcommittee. And at that time, I recall Keene State had a red rating from fire, and UNH had something less than green. Plymouth State actually was green, but since then I've noticed that your ratings have improved. I want to ask you one question. I recall when we had this subcommittee before, one of the concerns at Durham was the requirement to, in order to have like a gathering or a demonstration or whatever, a permit was needed from the campus police. What's the status of that requirement today?
Working with the lawyers from fire, the university adjusted that, has adjusted it, amended it, so that now spontaneous gatherings of less than 25 people are permitted. Gatherings that are pre-planned or are more than 25, there still is a permit requirement. The way in which the permits were applied, way in which students apply for the permits have also been adjusted to make it easier and quicker to access.
Okay, thank you.
Thank you.
Further questions? Thank you very much, Mr. Rogers.
Thank you for the time.
Have a good afternoon.
You too.
First, we have is Paul Esmond. Go ahead, Mr. Esmond.
Hello?
Yes, we can hear you, Paul.
I'm sorry about that. I'm going from a cell phone. I'll make this statement quick. Greetings and thank you for letting me voice support for HB 234. My name is Paul Esmond. I am a New Yorker, and as such, I appreciate that it may be strange that I am submitting testimony in support of your state's bill. In my previous career, I was a legislative analyst for the New York State Assembly. And in this role, I received testimony and memos of support for or opposition from residents and businesses outside of New York State. Because many people correctly or incorrectly see New York as a national policy leader, there was a tremendous interest from non-New Yorkers in what went on in our state house. Now I'm on the opposite end, looking in with profound interest in your bill. I hope that it will become law, or at least portions and provisions of it will, and that New Hampshire will be regarded as leading the way in protecting what I consider the endangered species of free speech on college campuses and also other parts of public life. This bill is nonpartisan. It affords the same protections for all students, regardless of their political, economic, social, or religious perspectives. The bill merely establishes standards and sets the expectations the students' First Amendment's rights will not be trampled on or watered down by administrators and disruptive students. The legislation would prevent public colleges and universities, which belong to the people of the granite state by virtue of their subsidization, from fostering an environment of illiberal behavior towards speech that is deemed unpopular. Universities and colleges must never allow for the intimidation of students, organizations, or speakers, even if the views they hold may not be in the mainstream. It is not the mission of a university to endorse or condemn speech or opinions, particularly if such speech or opinions do not promote or incite violence. In recent years, institutions of higher education have been the site of deplatforming and violence directed at students, campus organizations, and guest speakers who are expressing unpopular views. In many cases, administrators have looked the other way and allowed the heckler's mob to have the final say. This is unacceptable. It only serves to create groupthink in American society. The free exchange of ideas is critical in higher education. Unfortunately, this spirit seems to be dimming, as evidenced by incidents in recent years, including one that happened here in New York State in 2019 at the University at Binghamton, where administrators looked the other way as students set upon a campus group handing out literature for an upcoming speech by a conservative economist, and then, in a sense, allowed his speech to be disrupted. Hundreds more examples have been documented in the news and have largely gone unpunished. And what I just want to say is that this type of behavior seems to be growingly tacitly accepted, and it should not be accepted. I like that the bill is nonpartisan in spirit. It protects every student, left, right, or in between. And I would urge you to move some version of this bill and enshrine some protections in your statutes to preserve the free speech at your public colleges and universities, and hold administrators and students accountable. And I just want to thank you for this opportunity. And
Thank you very much, Mr. Esmond. Are there any questions for the presenter? Not seeing any. Thank you very much.
Next, we have Ross Connolly. And Ross, you've been promoted. Go ahead, please, and welcome to education.
Hi, Mr. Chairman. Can you hear me?
Yes.
Yes, we can hear.
Excellent. Well, thank you, Mr. Chairman and members of the committee for holding this hearing today. Just for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity, New Hampshire, and I'm just here to voice our support for HB 234. Free speech is the cornerstone to any free society. Students at the University System of New Hampshire and community college system institutions should feel free to speak their minds, ask questions, and be intellectually curious. However, currently these schools do not have many provisions for incentivizing and protecting these rights. And in many cases, it's just the opposite. Schools like UNH Durham and Keene State College have enacted and retracted certain speech codes and speech zones for years. As previous speakers pointed out, that many of those institutions have been greenlit by fire, but just a couple of years ago, many had red lights. This bill would stop that practice from the constant switching based on administration control. It would stop that practice from occurring. And if we are to be more united as a nation, we must really start speaking to one another, listening and understanding our differences at the most local level. And the best place to start that change is in our schools, so that future generations do not look at their fellow Americans as the enemy, but instead understand our differences and work together on the extensive common ground that exists. Teaching our young people the virtues of respectful civil debate and disagreement will be critical in the coming years. Luckily, HB 234 would take a giant leap towards fostering this culture of inclusion and tolerance on campus. As has been pointed out, this bill would require New Hampshire public institutions of higher learning to adopt policies of free speech into their student handbooks and codes of conduct. What it does not allow is for speech that has calls to commit violence or harassment. It still allows, to answer some of the previous questions, it still allows the institution to halt demonstrations that disrupt campus activities. And that is, that decision would rest with the university. This small reasonable change would start the process of moving campuses back to centers of learning, questioning, and critical thought. Differences of opinion are normal, and higher education was founded on teaching students how to think critically and challenge their own beliefs. And 19 states and counting have enacted a similar legislation to HB 234, including states under both Republican and Democratic majorities. Free speech, expression, and association should not be a partisan issue. We really must learn to speak and listen to one another again, and that is the intent behind HB 234. And for all these reasons, we urge the committee to move HB 234 to pass. And I'd be happy to take any questions if there are any.
Thank you very much, Mr. Connolly. Are there questions for Mr. Connolly? Not seeing any hands. Thank you very much.
Thanks so much for your time.
Yeah. I see Shannon Reed up. Is she next?
I believe I am. Can you hear me? You can hear me. And can you see me? I'm not quite sure how this works. Yes. Okay. Thank you. My name is Shannon Reed. I am Director of Government Affairs for the Community College System of New Hampshire. Thank you for the opportunity to testify. I apologize for not signing in early enough to be captured in the portal, but thank you for allowing me to speak nonetheless. I certainly don't argue with what the prior student speakers have said about their experiences with fellow students. And I've even seen that type of peer pressure operating on my own teenagers who are more conservative than many of their peers. However, this bill declares that post-secondary institutions must follow the principles of the First Amendment and the New Hampshire Constitution. The community college system has policies that were written specifically to ensure support and protection of First Amendment rights. Our history has shown that we actively seek to be venues where diverse public discourse takes place. Our policies are consistent and content neutral, have been developed to support First Amendment protections for all, and have been effective in achieving those objectives. Given the policies in place at our institutions, we're unsure why the sponsors believe this bill is needed here in New Hampshire. Is the bill designed to go beyond established First Amendment protections? If so, it would be helpful to have those new boundaries laid out clearly. And if not, we ask why this bill is needed. Beyond that general question, I have just a few comments to offer. On page 3, beginning on line 6, the bill acknowledges the college's rights to maintain reasonable time, place, and manner restrictions, which are content neutral, and which our policies reflect. There appears to be a contradiction with the statement immediately preceding that language, forbidding the college from designated areas for expressive activity. We understand the colleges may not designate so-called free speech zones that have the effect of removing expressive activity from accessible parts of campus. But the colleges do exercise their right to require certain areas to remain unblocked by such activity, for instance, so that students and other members of the campus can go about their business unimpeded. The colleges have a safety obligation to our students, employees, and visitors. This includes the ability to plan for events or gatherings to ensure they don't unduly disrupt the learning experience for which students attend our colleges and pay tuition, or put anyone at risk from destructive actions. For instance, working cooperatively with groups in advance and understanding the likely scope of an event enables our colleges to plan appropriately. We're also concerned that the bill establishes a separate right of action involving injunctive relief, monetary damages, attorney's fees, and court costs, since we already have a grievance procedure in place that protects students' rights. And this is on page 4 toward the bottom. We would ask that the committee consider striking that section rather than create a separate track and process for grievance resolution. On page 3 toward the bottom of the page, we're unclear what is meant by the language in Roman 2, which provides that the institution may not discriminate against a student organization based on the expression of the organization, including any requirement that the leaders of such organizations comply with the organization's standards of conduct. We ask that the sponsors please clarify what is meant by that language. Finally, on page 4, the accountability section requires the institutions to report to the governor and the state legislature prior to the beginning of the state legislative session, detailing the course of action implemented to be in compliance with the requirements of the chapter, with a report on any changes or updates to the chosen course of action. This section outlines additional details on what should be included in the report and how such information must be disseminated. I'll just share 2 points about that section. First, the bill includes an unusually detailed series of reporting requirements. We would ask that you consider limiting the level of detail in a way that honors the sponsor's intent but does not create this new level of administrative workload for our organizations. And second, we recommend you define to whom the reports should go instead of simply to the legislature. That may be a result of this being boilerplate language, but for instance, other reporting requirements in New Hampshire statute would specify the Speaker of the House and the Senate President. And that concludes my testimony. Thank you for your consideration.
Thank you very much, Ms. Shannon. Are there questions for the community college system? Representative Milo.
Thank you, Mr. Chair. Thank you, Ms. Reed, for taking my question. In your experience with the community college system, have you had any problems in the recent past in dealing with free speech issues on any of the 7 campuses of the community colleges?
No, not at all that I'm aware of.
Thank you very much.
Further questions of Shannon Reed? Yes, Representative Cordelli.
Thank you. Thank you, Ms. Reed. I just wondered if you had written testimony, if you could submit that to the committee?
Of course, yes, I will.
Thank you. Further questions? Thank you very much.
Thank you all.
Do we have any other participants or hands up?
Not that I can see.
Okay, with that, I'm going to close HB 234. We had testifying, we had approximately 13 support, opposition 91 or 92, and neutral 1. And testifying, we had 7. So we're done HB 234 now, and we will enter into the next bill which we brought forward from this morning. HB 258. Or 458. 458. With that, I'd like to ask, do we have the sponsor of the bill?
Yes.
On deck?
Yeah.
Representative Aaron?
Go ahead, Representative Aaron. Welcome to the.
She needs to unmute.
I'm sorry, what?
She needs to unmute.
Oh, okay.
There I am. Hi. Thank you. It's good to see everybody. I'm sure you had a very long day. Good afternoon, Education Committee. My name is Representative Judy Aaron, And I represent Sullivan County District 7, that's Ackworth, Goshen, Langdon, Leominster, and Washington. Can you all hear me okay? Okay, great. So in 2019, SB 142 was passed in the state legislature in response to accommodating a need that was identified having to do with providing students attending New Hampshire public middle and high schools who could not afford feminine hygiene products with sanitary napkins and tampons in school bathrooms. The concept had and still has much merit. However, there are several things wrong with the current statute which needs to be fixed, which is why I'm presenting this bill to you today. First and foremost, it is our sworn oath and duty to uphold the New Hampshire Constitution. Our New Hampshire Constitution makes it very clear in Article 28A, having to do with mandated programs, the state shall not mandate or assign any new, expanded, or modified programs or responsibilities to any political subdivision in such a way as to necessitate additional local expenditures by the political subdivision unless such programs or responsibilities are fully funded by the state, or unless such programs or responsibilities are approved for funding by a vote of the local legislative body or of the political subdivision. So this statute that was created in 2019 created an unfunded mandate to our school systems. It first mandates through RSA 189-16A1 that menstrual hygiene products must be made available at no cost in all gender-neutral bathrooms and bathrooms designated for females located in public middle and high schools. And then it goes on to further say in RSA 189-16A3 that the school district shall bear the cost of supplying menstrual hygiene products. That is clearly a violation of Article 28A of the New Hampshire Constitution. I believe that needs to be fixed. So the bill that I'm presenting seeks to repeal the statute and replace it with one that is in line with our constitutional oath and duty, yet it still allows for females in need to be provided with menstrual products. First of all, I thought it was better to place this statute in a section more appropriate for the topic, as this does not really belong in an area of statute having to do with school boards, transportation, and instruction of pupils. Instead, it seems better suited to be in the section of the education statute having to do with school health and sanitation. Usually, young ladies would go to the nurse's office if they were in need of sanitary supplies. Nurses' offices always had supplies available in an emergency or if someone was genuinely in need. This bill also leaves it up to the school administration to decide for themselves if they have an issue of students being in need of menstrual products and to determine themselves how and where to provide those products. I don't think the state of New Hampshire should be micromanaging schools regarding how and where to provide these products. Those things should be left up to the discretion of the school administration. And when writing this bill, I heard from people telling me that their schools were experiencing problems with the current policy set in 2019 by RSA 189:16A. In passing, people told me the current policy has been very costly for their school and ultimately the local taxpayers. Schools have had to buy machines or other distribution devices for every bathroom at great cost, and they constantly have to refill product that is left in the restrooms. Products are ending up being hoarded by all students and worse, removed by non-students. The truth is, if you leave a basket of tampons or napkins, they will disappear in a flash. Clearly, this was not the intention of this statute. The unintended consequence here is that the reality is that schools are supplying all students plus any school visitors with menstrual products, and not just those who are in need. This is a costly proposition for schools and may in fact not allow products to be actually available by the ladies who this RSA was intended to help. If product is gone from the restroom when they are there, they won't have access to them. I think it makes much more sense for the schools to decide their own policies regarding the availability of menstrual supplies and how to distribute them to those who truly need them. If they want to supply product to everyone, then that's their choice as well. With regard to how school districts pay for these supplies, that's also another matter. Since this bill before you doesn't mandate that every bathroom in every school offer these products, it is no longer an unfunded mandate. The bill also states clearly that if a school decides to offer product, that the cost can be covered by donations to the school or purchased via available grant money or through any available state or local funding reimbursement programs. This bill still allows product to be available, and I think that's very important. But it leaves decisions regarding availability to be made by the local administration and allows them the flexibility regarding how to cover the cost of these products. This makes for constitutionally sound and flexible statute, which overall benefits our schools as well as our students that are in need. So I appreciate your time and listening, and I look forward to your question.
Thank you very much, Representative Aaron. Are there any questions from the committee? Not seeing any hands. Thank you very much.
Appreciate it.
Representative Ladd,
Yes?
I do have a question.
Okay, go for it.
Thank you. Representative Aaron, on the bottom of your proposal, the part that talks about the nonprofit community grants, I think it's line 9 actually, that is the same language that was in the bill that's approved. So that hasn't changed. Is that correct?
Well, the current language says the school district shall bear the cost of supplying menstrual hygiene products. A school district may seek grants or partner with a nonprofit. It's the part that is a mandate is that the school district shall bear the cost of supplying menstrual products. And that's
the grant question was the part that's still there. I guess I want to go back to the rationale for this bill. I was looking at, I don't know how much your school system paid for menstrual products last year. I do have a couple report outs for schools here. Interesting to know, at least none up here in the North Country had talked about any of the schools being left empty or taken away or damaged from those. As you recall, I'm sure you recall from doing your research on this bill, that was a Rochester school board and a school student that started this bill. Because, and for the people who were not on the committee last year, this falls into the term called period poverty.
Yeah.
It has a significant issue as regards student attendance or the lack thereof because of the lack of feminine products for adolescents. The other part we found after the legislation last year or last session in the hearing, over and over and over again, I'm sure you're aware, of schools saying the kids did not come to school. They did not come to school because of this difficulty in the financial issues, which obviously are more critical now. So I guess I'm asking you, how do you balance student attendance and minimal costs? They're looking at, interestingly enough, the New Hampshire, the school district down there by Hampton and Rye and Seabrook and those, the average, just for your instance, $12,500 for toilet products and 0.05 cents for feminine hygiene products out of the whole district. And we have other data from that. But how do you get to that point that we want to make this? You're agreeing that the need is there because you said you agree with the bill. Is that correct?
I agree the need is there and this
Okay.
bill addresses it, but it doesn't mandate that the school does certain things. It leaves it up to the school to decide, where and when and how to provide the product.
That, that
so-
may, if I may, finally, that may change the whole intent of the bill. May has been the way for all the years. The schools may do this, the school may do that. The teachers have been trying to provide assistance, and phys ed teachers and female teachers and nurses. But the stigma that goes along with that has been devastating for kids, to the point that they choose not to come to class if they can't afford it, or if they don't have a change of clothes because they can't afford the product, or the multiple use of products. So it's a lot more than just the absence of the process. This has a huge issue. So once you go back to May, it does exactly what it was for the last 30 years. And we see it more and more and more youngsters not coming to school because they can't receive the assistance because the financial assistance is not there.
Representative Woodcock, do you believe that schools would ignore a problem then?
I believe schools, yes, I do. But not that they ignore problems, they have not been able to keep up with the problem.
Well,
We've done it for the last 20 years. If you've been in schools, you've seen it.
I don't want to have this a debate between the presenter and an individual on our committee, please. Let's keep the questions from the committee to the presenter, and that's the way we'll leave it.
Thank you, Chairman Ladd. Chairman Ladd, may I also add too that this bill does not, still recognizes that there is a need, but it removes the unfunded mandate. And I would suggest that if you want to keep in the language of shall, that you then put in a stipulation for the state to fund it.
Thank you very much. Are there further questions for the presenter? Thank you very much, Representative Aaron.
Thank you, and I appreciate your time.
You're welcome.
We have another representative, Jeff Edwards. Go ahead, Jess, you've been promoted. Unmute yourself. Welcome to education.
So I'm Representative Jess Edwards, representing Auburn, Chester, and Sandown. And one of the things I do in my community is for Boy Scouts, I teach a citizenship in the nation merit badge. And within that course, we teach the importance of maintaining the checks and balances within our government and recognizing what our constitutions restrict the government from doing. You may recall that the Constitution was written primarily to tell government what it shall not do. And so in 1984, the New Hampshire citizenry got together and passed into our Constitution a new amendment or Article 28 Alpha, prohibiting, making it impermissible to pass unfunded mandates. And the way that the law is written now, it couldn't be more clear. It couldn't be a more textbook example of an unfunded, unconstitutional mandate. And while it may frustrate us as legislators to use our authority to do the right thing for society, part of doing the right thing is maintaining our own legislative discipline so that we only do the things that are permissible. The statute as it stands now is currently broken. I support the bill before you, 458, as one way to fix the problem. The other way to fix the problem includes, but is not limited to, having the state pay for it. If the state's going to mandate it, the state has an obligation to pay for it. That's really what 28A says to us. And it's said in very plain, simple language. And if we refuse to obey our oath, I think maybe we should resign. So I'll take question if there are any.
Thank you very much, Representative Edwards. Are there questions for the representative? Representative Moffett.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. I was not in the mix when this came through before. Did not anyone point out that this was an unconstitutional unfunded mandate before, or is this the first time that this has been flagged?
Thank you for the question. The reason I found out about this RSA was when I was talking to my senator, Senator Sharon Carson, and she was livid that this got passed over her objections about the unconstitutionality of this mandate. But it was just one of those bills where you weren't going to get a bunch of Republican men to oppose it because it would be too easy to paint us politically as people who don't care about women. So we fell silent, unfortunately, while a knowingly unconstitutional bill that would be simple to pass or fix was allowed to pass. And then, nobody got to the governor to point out to him that he should veto it over the constitutional issue. But so people did know, and not enough people cared, Representative Moffett.
Thank you.
Thank you very much. Are there further questions of Representative Edwards?
Question?
Yeah, Representative Woodcock.
Thank you. Just a question for Representative Edwards. Being new to this process, Representative, I was interested to find out, figure out, maybe you could help me with this. Since the governor's staff and the governor's people went through the bill, I'm sure, before the governor signed it to make it law, would there be assumption then that the governor would budget it?
Thank you for the question. And I would say that given that the law itself prohibits the state from funding it, it's very clear. So unless a policy committee passes a policy, then the finance committee doesn't pick up and then fund that policy. And in this case, somebody decided to write it so narrowly that the state is essentially prohibited from meeting its obligation under Article 28A.
Thank you very much. Further questions of Representative Myler?
Thank you, Mr. Chair, and thank you, Representative Edwards, for taking my question. Are you aware that is this the only bill that we have passed on from this state house and the state legislature that's unfunded? Aren't there other bills that we have also forwarded on to local property taxpayers?
So thank you for the question. I would say that given the number of laws that we pass and given sometimes what seems to be a haphazard regard for 28A, that there are probably other laws out there that have passed unfunded mandates. And I would encourage you that if you come across one, that you do what I'm doing, do what Representative Aaron is doing, and that is fix the problem. Don't ignore the problem, fix the problem. And I've got another bill. I don't know if you're ever going to see it in education, but I had another solution to this, but I don't want to talk about any bill other than the one that's before you today.
Thank you.
Thank you very much. Other questions? Representative Likas?
Yeah, I don't have a question. I have an answer to a question that was asked when this came up. Yes, not only did I mention and other people mentioned that it was a 21A violation at the committee hearing, I spoke on the floor and said the exact same thing. 28A, I'm sorry.
Getting late.
Yeah.
Are there any other questions for Representative Edwards? Not seeing any hands or folks. Thank you very much.
Thank you, Mr. Chair. Thank you, members of the Education Committee.
You're more than welcome.
Next, we have Julia Lee. You can promote it. Go ahead and unmute yourself. Welcome to education. like you're unmuted, but we cannot hear you.
Oh, can you hear me now?
Yes, we can.
Okay. Thank you. Thanks for allowing me to testify. I know it's the end of the day. I'll speak quickly. My name is Julia Mead. I'm an OBGYN. I live in Lebanon and I practice in the state of New Hampshire. And I'd like to speak in opposition to House Bill 458. I'm strongly opposed to this bill for several reasons, and I stand with the New Hampshire Medical Society as well as New Hampshire American College of Obstetricians and Gynecologists to oppose this bill. Unlike most people, I actually love to talk about the menstrual cycle. I love working with patients, many of them who are adolescents or teenagers, and to work with regulating their cycle, managing heavy bleeding or cramping, to allow them to live the lives that they want to. So many young women are held back from sports or like Representative Woodcock was talking about, not able to go to school, not able to participate fully in class due to their periods. I personally might school or had to leave class in the middle of the day because of painful period cramps. So I can definitely identify how women are feeling. And it's unpleasant and embarrassing enough without access to menstrual products to kind of compound this issue. I know that periods are kind of considered taboo or embarrassing to talk about, but I think it's time that we, recognize this normal physiologic occurrence and think of it as a way to provide fair accommodations to young women and adolescents in our state, rather than hold them back. So I don't think it's something that should be shameful or embarrassing or a cause for distress. I think we can all imagine either ourselves or a niece or a daughter who might someday need menstrual products, whether they can't afford them, they forget, or they have unexpected bleeding, rather than having to have their clothes changed or call home or, an embarrassing encounter. And I think having these products available to everyone should be considered a human right. So in conclusion, I'm opposed to this bill, and thank you for the opportunity to speak.
Thank you. Are there any questions for Ms. Mead? Not seeing any hands. Thank you very much.
Thank you. Next, we have Shilpa Venula, and you signed up to speak for 4 minutes. Thank you for.
Yeah, what I'd like to do is try to remind everybody that the minutes that they've signed up for, try to stick to what you've signed up to do, please.
Okay. So go ahead, Shilpa. Thank you. And presentations.
Can you guys hear me?
Yes, we can.
Okay. Hi, my name is Shilpa, Dr. Daria Vemula. I am a resident physician here in New Hampshire, and I'm speaking on my own behalf, and these are my own thoughts. I am talking in opposition of this bill. We all know 1 in 5 girls misses school during a menstrual cycle, and 1 in 4 can't access it. In fact, WIC and Medicaid, many people and many patients I have are on WIC and Medicaid. They consider pads and tampons a luxury good. Now, women have cycles every month in the same way that people use toilet paper. They consider it a luxury good, and our toilet paper and not menstrual pads is an affront to women's dignity. Many families don't have disposable income to afford sanitary products. Many of these people, you're talking for the state of New Hampshire, right? From Manchester, a super urban environment, all the way to Berlin, which is super rural. Now imagine a young girl trying to go buy pads. You have to go up to the store, talk to the male storekeeper. Sometimes they don't even stock the pads. That's a known fact amongst other studies all across the United States. And to then have to buy pads and walk out of there is extremely embarrassing, especially for a 13-year-old. We don't talk about menstrual cycles enough, and I know that because my patients come to me having no idea about their own bodies. And so to say this is stigmatized is an understatement. On top of that, there's a racial divide as well. And I've worked in Manchester in the past, and I've seen patients come in and have even less of a knowledge and less of access to menstrual pads and cycles because of cultural taboos. Now you're telling me that this unfunded mandate should require funding. You are right. I think that should be some sort of funding here. But the fact that an unfunded mandate was passed that then requires schools to think about this, to offer this, makes it a sign of support for young girls that are menstruating. saying that we see you as equals and we see that your bodily biological needs are met at our school. In the same way we provide food, in the same way we provide toilet paper, the same way we provide a space to learn and study. These girls might have upfront costs for their pads and their tampons, but in the long run, you are giving New Hampshire State a great workforce of young ladies and women that can be extremely effective change makers. By taking away the access to pads and tampons, you are actually having a huge opportunity cost loss in the future for your own state. I think it's not a luxury, and it's not something that we talk about often. Not every body that menstruates is also female. So then to have this young person who's gender nonconforming have to go up and ask for menstrual pads when they may or may not identify as a woman is then adding trauma to the lives. And I think I see plenty of patients come to my clinic with that issue as well. So we're about equity and we're about racial equality and gender equality here. And when we pass this law, I highly support that we continue that extremely profound and honorable mission by keeping that law in place and not repealing it and not changing it. Some of the wording in the bill makes it permissible to offer pads or tampons. And I think that's also inappropriate since many people use one or the other for cultural or personal reasons. And so I thank you guys for your time, this honorable staff, honorable representatives here that have sat and listened to me kind of share my thoughts. I highly hope that you choose human justice and gender equality and racial equality today by voting against this bill. Thank you so much.
Thank you very much, Doctor. Any questions? Thank you very much.
Panelists, do I have questions for education? Just speak for 3 minutes.
Thank you, Mr. Chair and members of the committee. My name is Jeannie Horeska, and I'm the political director for the American Civil Liberties Union of New Hampshire. I really appreciate the opportunity to testify today in opposition to HB 458. The ACLU strongly supported the 2019 bill and was very proud to be part of that incredible effort to combat period poverty in New Hampshire. And it's really disappointing and disheartening to now see legislation attempting to repeal that legislation and to send students back into period poverty. I want to be clear here that access to menstrual products is not about convenience. It's about public health, it's about dignity, and it's even about academic performance. A student's access to tampons and pads relates directly to their education. If you can imagine for just a moment trying to focus on a math problem while wondering if your pad is leaking or if your tampon will hold up for another 4 hours. This anxiety and shame can significantly impact a student's academic performance for obvious reasons. It's also worth noting that it's actually unsanitary and unsafe to not regularly change tampons or pads. And it bothers me to hear discussion about whether schools should have to assess a student's need for tampons and pads. I can't imagine a school that would try and determine a student's need for toilet paper. Can you imagine a student trying to prove to a school nurse that they needed toilet paper or that they needed more toilet paper? We would never, ever do that. And yet to ask that a student have to prove to a school that they need a tampon is just to really misunderstand the level of stigma and shame that can be associated with periods. To ask a student to publicize their need for menstrual products is just to not understand the shame associated with periods and to ask students that basically to go either the entire school day with one tampon or one pad, which is highly unsanitary and unsafe and distracting, or to ask them to skip school. I mean, that's the reality, is that too many students actually miss school because they do not have these products. And I understand that these products may only apply to 50% of the student population, and therefore they're not seen as necessary as like water or toilet paper that apply to the entire student body. But I would encourage you to think of them in the same category of necessity as you think of toilet paper and you think of water. And I would just want to note that Governor Sununu did sign this legislation in 2019. And when he signed it, what he said at the time was this, quote, "This legislation is about equality and dignity. SB 142 will help ensure young women in New Hampshire public schools will have the freedom to learn without disruption and free of shame or free of stigma. And this bill will undo that progress. It will send students back into period poverty, and it will result in more students missing school. And for these reasons, I respectfully urge the members of this committee to vote inexpedient to legislate on HB 458. I'm happy to take questions.
Okay, thank you very much, Ms. Haruska. Are there questions from the committee? Not seeing any. Thank you very much.
Thank you.
Okay, next we have Ashley Yang. Go ahead, Ashley.
Hello.
Welcome to Education.
Can you hear us?
Yes, I can hear you.
Okay, great. Thank you very much for wanting to testify today. You can go ahead.
Sure. My name is Ashley Yang. I am a medical student at Dartmouth, and I would like to testify today in opposition to this bill. Not only am I a future medical provider, I'm also a product of public schools for my whole life. And from speaking from both experiences, I can say that having access to menstrual products is essential to young women's ability to participate equally in school and engage fully in the learning environment. From what I remember as a student in public schools, people come from a wide distribution of family socioeconomic circumstances, and people have very different abilities to afford these types of essential products that previous individuals have testified have been viewed as luxury items rather than necessities. Just like we provide textbooks to students in schools and school buses to get them there, we must provide menstrual products as well so that they can, learn safely and, actually come to school and be as prepared and able to participate. And it's also important to have a way to fund the provision of these products rather than just say that we have to provide them or make a reasonable effort to provide them. And it is really essential for the physical and mental health of young people to feel like they can exist in public with dignity, and having protected access to sanitary products is a really crucial way that they can get that. So I urge the committee to not recommend that this bill be passed. So thank you very much.
Thank you very much, Ashley. Are there any questions from the committee? Not seeing any hands. Thank you very much, Ashley.
Thank you.
Next, we have Vera Christina from the Board Association. Go ahead, Mr. Christina.
Good evening, or excuse me, good afternoon again. Thank you, Representative Ladd. Thank you, members of the committee. It feels like nighttime, doesn't it? Little levity at the end of the day. I hope that's all right with everybody. Vera Christina, Executive Director, New Hampshire School Boards Association. We are in support of House Bill 558. Please know that our support of this bill has absolutely nothing to do with the underlying policy issues. 2 years ago, when I believe it was Senate Bill 142 was working its way through the legislature, NHSBA did not take a position on that. However, we certainly did have some hallway conversations with many representatives worried about the fiscal impact that it may be downshifted to local school districts. So when the bill, Senate Bill 142, came into law, and school districts were trying to come in compliance to buying the menstrual products and buying the dispensers and whatever equipment was needed for the restroom. NHSBA received a handful of phone calls from superintendents and school board members asking what our position was on Senate Bill 142. So I explained to them why we didn't take a position, how were the competing interests relative to the policy impact of helping these young women versus the fiscal impact that school boards have to wrestle with every single day. Part of the reason NHSBA is supporting this bill is in part echoing the comments of Representative Aaron and Representative Edwards, but in speaking with some representatives and not representatives, but people in Manchester, through the Manchester School District, they had a six-figure price tag to implement this. They were looking at $125,000 in a school district that is woefully underfunded to begin with, that is shutting buildings, that has a low cost per pupil. And, that's obviously the extreme. The largest school district in the state is going to have the most significant expense. I did certainly hear from other school districts that were looking at, $5,000, $10,000, $15,000 expenses as well, too. And we did it. And I don't know if, in part we did it because we were told to do it. In part, school districts did it because it was the right thing to do. But the reality is it's an unfunded mandate. The legislature through Senate Bill 142 created a new program, created a new directive, and downshifted that cost to local school districts. So that's NHSBA's support of the bill. If we want to maintain the policy aspects relative to the bill, then the legislature should fund it. We're in a budget cycle right now. I don't know what the statewide costs for implementing this are. But perhaps a survey could go out, but all I know is, many school districts have had some expense. Manchester had a very, very significant expense. So that's the bulk of NHSBA's support from this bill, because it undoes the unfunded mandate that Senate Bill 142 that Senate Bill 142 created. Representative Myler, I believe you asked Representative Edwards a question about other unfunded mandates. How much time do you have, Representative? NHSBA keeps an informal list of unfunded mandates going back probably about 10 years or so. I haven't updated that in the last couple of years, and it's not a polished final document by any means. But if we're going to be talking about unfunded mandates, perhaps we could start with adequacy aid. Just a thought. But anyway, House Bill 458. One last point, I did email some comments to the committee as well too about a half hour ago. I wasn't sure if I was going to be able to stay online for the Zoom, so you should be getting my comments as well too. But NHSBA supports this solely on the fiscal issue and the fiscal impact that Senate Bill 142 has had on our member schools, on our member school boards. So with that, I'm happy to take any questions.
Thank you very much, Mr. Christina, School Board Association. Are there any questions for Representative Bohm?
Thank you, Mr. Chairman, and thank you for taking the question. School districts provide other needs such as toilet paper without being a mandate by the state. So don't you think that school districts, if they see a need, would supply that need?
Thank you for the question, Representative. I think certainly that's certainly a legitimate argument. I know that was one of the arguments that proponents and supporters of Senate Bill 142 expressed a couple years ago, that we provide, Kleenex and we provide toilet paper. There may be a larger conversation about sort of unconscious biases with doing those things that I'm certainly not qualified to speak about. But I guess the difference is, the state is not telling school districts that they have to buy toilet paper and they have to buy Kleenex and tissue. Should districts be providing these? Should they have been doing so already? I believe the testimony from Senate Bill 142, and one of the reasons it was able to gain support was that many districts, or at least some districts, were already providing feminine hygiene products for free on their own. But I guess my response to that, Representative, would be that if it's embedded in the local budget, local taxpayers have decided that they're willing to pay for those products. And whether or not everybody should pay for it, I guess it's a different argument. Or whether or not every school district should offer feminine hygiene products in the school is a different argument. But when there's a mandate and the impact of that legislative mandate is that school districts are expending $10, $15, $125,000, then I think perhaps we need to either revisit funding or revisit the bill itself.
Thank you very much. Any further questions for the School Boards Association?
Jeff Tanner.
Representative Tanner?
Thank you. Thank you for taking my question. I'm wondering how much of that money is actually because people felt or school districts felt as though they had to get dispensers. And that seems to be one of the big ticket items in this. And if so, that investment has already been made for that particular part of the bathroom. So once that's made, do you have any sense as to the continuing cost of having these items? And I'll just preface it by saying that I had talked to an assistant principal about this. And she was like, the kids are taking them all over and everything. That calmed down within a month of the kids goofing around with the different free sanitary napkins, which also brought out a good discussion about personal hygiene, I guess. But then things settled down and they realized how much it was important to the school. So just those kind of comments.
Thank you for the question, Representative. I mean, I certainly haven't looked at a school district budget or expenses as to, this amount of money for the dispensers, this amount of money for the products themselves. So that aspect I can't, I can't speak to. I cannot also speak to some of the comments about parents taking, the products and the students hoarding them. I haven't heard that specifically, and that's sort of not the bulk of NHSBA's, comments. I guess what I would say relative to the cost of the dispensers that have already been installed, there's a Representative Luno's bill is looking at retroactive building aid. So I suppose if the state wanted to pony up some money for this, there might be a way to look at some retroactive feminine hygiene product dispenser aid.
Thank you very much. Further questions? Thank you very much, Barry.
Thank you very much, Mr. Chair. Have a good afternoon, everybody.
Okay, next we have Elizabeth Canada. Sorry. You guys promoted. Signed up to speak for.
Good afternoon. Yes.
Yeah.
Hi there. Sorry, just had a little bit of a lag. Good afternoon, Chairman Ladd and members of the House Education Committee. For the record, my name is Elizabeth Canada. I'm the Advocacy Manager for Planned Parenthood New Hampshire Action Fund and Planned Parenthood of Northern New England, and we've submitted our testimony through email as well. We urge you to vote ITL on House Bill 458. As background, which you heard already, in 2019, this body passed Senate Bill 142, which required New Hampshire public high school and middle schools to make menstruation products available at no cost in girls' restrooms and gender-neutral restrooms. That bill passed with broad bipartisan support. House Bill 458, however, would repeal that statute. House Bill 458 would no longer require public schools to offer menstrual products at no cost to students in spaces that are accessible without students needing to ask someone. This bill instead would make offering free products optional for schools. They would also have the option to offer products at a low cost to students. Let's be clear. Allowing for no-cost menstruation products in public schools decreases learning interruptions. Students should not have to go to a nurse's office to access needed supplies. They should have what they need in their restroom to minimize any stigmatization and time away from class. And we've heard earlier today this issue surrounding need. And to that, I want to bring up 2 points. First is that if you are operating a middle or high school in a school district, you have students who menstruate and they need tampons and pads. And second, the issue of stigmatization and embarrassment is real when it comes to financial need. We see that in how the number of students who submit free reduced lunch paperwork decreases as they become teenagers. Students may feel embarrassed that they are what we might refer to as in financial need. And this is magnified when it comes to menstruation, which is already a stigmatized topic. In order to enable students to practice proper hygiene, we expect schools to supply toilet paper, soap, towels, and dryers at no cost to students. And we expect schools to supply those items where they are accessible to the students. We should similarly expect schools to supply products needed by students who are menstruating. In short, House Bill 458 would increase barriers for students, and those barriers will occur with regular monthly frequency. The goal should be to support students in feeling safe and comfortable in their school buildings without feeling stigmatized or singled out. And the good news is New Hampshire already has that law in the books, and other states and countries are following our lead. Let's not roll back progress. We ask that you vote in expedient to legislate on House Bill 458. Thank you for your time.
Thank you very much, Ms. Canada. Are there any questions? Or thank you again for testifying today.
Thank you.
You're welcome.
Lastly, we have Caroline Dillon. Okay, Caroline has been promoted.
Hi, am I here now?
Yes, you are. Welcome.
Okay. Hello, I'm Caroline Dillon. Some of you may remember me from 2019 as I am the one who approached former Senator Martha Hennessy with the idea for SB 142. As you can imagine, I'm thoroughly disappointed to be sitting here right now hashing this out again. But it was amazing to see so many people speaking in favor and or in opposition to HB 458. And they touched on most of my points, so I just have a few brief things. Article 28A was a huge argument in 2019, one that we discussed thoroughly with a lot of the staff in the Senate. We sent it around to like a bunch of different people. I discussed it with Governor Sununu when I met with him, and he was telling me how excited he was because he loved SB 142. And the general consensus was because of the may in the second clause or whatever, that didn't contradict the shall. Like they can get additional funding from other places, but ultimately it's the school district who's still paying regardless of where that money comes from. As far as budgets, school district budgets are like multi-million-dollar things, right? So I started this for Rochester in 2019 before this bill was introduced. Our budget that year was around $70 million. And when I spoke to the school board, they hashed out the costs and designated $4,000 a year for these products for the middle and high school. And that includes dispensers. The actual estimate was like $3,200. And they were like, oh, well, we'll just, increase that, whatever. So the dispensers are a one-time purchase. No school district should be spending $125,000. If you are spending that much, you can look for a different type of dispenser, or you can have a basket. It does not say that you need to have a specific dispenser. You don't need to be spending that much. Rochester spent $4,000, and that was 0.06% of the school budget. Other states, by the way, have been looking at us as a really good example. Personally, since 2019, I have been contacted with numerous people from Connecticut, Washington, Florida, California, South Carolina, Pennsylvania, and currently I am working with Massachusetts. They are all trying to base bills off of SB 142, and we are really leading the charge in the country with fighting period poverty. So I think that passing SB 450 or HB 458, sorry, that would be a huge step back in our progress, and like just for public press, that would not look good for New Hampshire. And then again with the gauging needs, school districts, like if you don't have to pay for something, like you're not gonna do it, right? Like why spend the money when you could just have it in the bank? And so like, how are you going to gauge the need? You really can't do that unless you're going to go through and ask every single person who menstruates if they have trouble affording tampons or if they use something like newspapers instead of pads. You don't want to do that because it's uncomfortably. And honestly, even if I myself was suffering from period poverty, there is absolutely no way I would be brave enough to say, you know what, Mr. Superintendent? Yeah, I do skip school when I'm on my period so I don't leak through my pants and bleed over my chair. Nobody's gonna do that. So, I mean, unless you really want to, I would urge you to vote an expedient to legislate. If anyone has any other oppositions, I would love to hear them. And if you have any questions that I could answer to potentially change your mind, I want to answer them. I am sure you will hear from me again because I will always be here to speak up for others and I will always fight for menstrual equity. And that is a promise. So thank you very much for hearing me today.
Thank you very much, Ms. Dillon. Are there any questions for the presenter? Not seeing any hands. Thank you very much.
That's all.
Is that the end of the list?
Yep.
So that concludes all the speakers for 458. I will go through what we have here as far as the numbers. Supporting the bill 20, opposed 245, neutral 0, testifying a total of 9. Thank you very much for hanging in there today. I appreciate it. We are done for today's work. We're adjourning this meeting as at this point. Tomorrow, don't forget, we have session down in Bedford or wherever over in Bedford. I look forward to the experience of visiting Bedford.
I wish you were, Mr. Chair, I just want to say that I wish that you were all coming to my home tomorrow. Perhaps after everybody is vaccinated and/or it's gone, we'll be able to do that in Bedford.
That's a wonderful invitation. I'd much rather be at your house tomorrow than in a huge room like we're going to be in.
Oh, yes, you would.
And first of all, I'm just going to have to find the place. So, never been there before, and I don't know.
It's not tough to find if you know where Target and Lowe's are in Bedford.
Just saying, it's right beside Macy's.
You go down with them on your right-hand side, and you're just looking for the road on the left.
Right near the male strip club.
Right, yes, down by Mark's show place, right.
Yeah, okay, it's down in the southern part of the state somewhere. I don't frequent your neck of the woods that often.
Well, we'll come get you. We'll come find you.
And we don't go to Haverhill either.
Yeah, that's right. I guess I gotta leave my maps at home and try to, as somebody says, use GPS. I gotta figure out how to use my phone first, though, to do that.
I went there yesterday. The easiest place is the easiest way is to go right down the Everett Turnpike through the toll and or not through the toll. Just keep going down till you see the airport road.
Yeah.
It says airport road, not 293. It's past that. You take that airport road, Ray Resorick Highway, and when you get off, you go toward Merrimack, Route 3, and you come down to the light, and then you take a right to go back toward Manchester, and it's only about less than a mile up there on the right.
Okay.